morning. How is everybody today? My name is Debbie. Welcome to my channel. Uh-oh, hang on. Okay, sorry about that. Um, Good morning. Hey, Jennifer. Hey, Nancy. Hey, Judy. Nancy? I don't know. My parts are different than Court TV's parts. So, I couldn't tell you because I'm not gonna know. It depends on how many things we get through per day, and I don't know. So, if you were with me yesterday towards the end, there was a CSI person on the stand that was showing, hey Tricia, that was showing. Why did you say hit play, Nancy? I'm talking. I'll hit play when I'm ready to hit play. Um, there was an evidence tech, CSI, whatever they're called, on the stand, and she was just showing pictures to the jury, and it was getting very, very boring because we couldn't see the pictures, and she was just showing them to the jury and explaining where they were, what area of the house they were looking at. So I skipped the rest of those and we're going to start back. It's still the same evidence tech. She's on the stand and they're asking her questions. So that's going to be a little more interesting. And then after that, she's going to actually show some evidence. And if that gets boring, we'll skip that too to the next witness. Okay, here we go. This is about the owl theory because there is a theory that an owl attacked her. I'm not sure if the theory is the owl attacked her outside the house and she made it inside and collapsed at the bottom of the stairs, or if it flew into the house and attacked her. Either way, I think it's a ridiculous theory. Owls can rotate their heads and necks as much as 270 degrees. Owls have 14 neck vertebrae, and their vertebral circulatory systems allow them to rotate their heads without cutting off blood to the brain. Oh, wow, that is interesting. Because, yeah, if you think about it, if you've got a blood vessel there and it twists, it's going to cut it off. Like if you twist a water hose, it cuts the water off. I never thought about that. Most owls share an ability to fly almost silently and more slowly in comparison to other birds of prey. Most owls live a mainly nocturnal lifestyle. There's a bird show at Animal Kingdom, and they have owls in it that they bring out and teach you about owls. And the last time I saw the show, I think I was working night shift, or I had worked night shift in the past. And I went up after the show and I asked the owl trainer, if keeping, because they keep them awake during the day and let them sleep at night, so they switch their natural sleep schedule, so they'll be awake for the show. And I remember asking her if if they knew if there were any studies or anything about what it does to switch their sleep cycle like that, because there have been studies about people that work night shift that it actually shortens their lifespan, because our normal rhythm is to be awake during the day and sleep at night. So people that work night shift and sleep during the day, it literally takes years off their life. Not a lot, but it does. And so I asked her if she knew what it did to the owls, and she said that she didn't know. They'd not done any studies on that, and she found it extremely interesting. And now that it's decades later, I would love to know if there's any studies on that about owls, like in captivity, that are made to stay awake. How long have I been on YouTube? Around 3 years. Why? You should know, Nancy. You've been with me since the beginning.
Judge, yesterday I asked for an instruction on destruction of evidence, and the court asked for case law. Mr. Harden asked for case law. Mr. Widenhouse, over the evening recess, in fact, came up with a North Carolina Court of Appeals case on that issue. And I'd like to hand up to the court a proposed instruction as well as the case, and I'll give a copy of it to Mr. Harden. And in light of that, we would renew our request for this instruction to be given at this time when that incident is still fresh in the minds of the jury.
Mr. Harden, you wish to be heard on?
Well, Your Honor, I'm just being handed this. I would like an opportunity to review it for us to conduct our own research. I see that this is a civil case. I would like to formulate thoughts about how that would be applicable in a criminal case. And I'd ask the court to give us time to do that.
All right, I will allow you some time to research that. All right, Mr. Are we ready? Otherwise, if you'll bring the jury in.
At this point in time, as she takes the stand, it would be my motion to publish all of the photographs to the jury.
All right.
Rather than going back into them individually. And I guess, Mr. Bowles, we could just split them half and half, however, as long as each juror is able to see each one.
Ms. Black, to refresh my recollection, I think.
I have moved to introduce all of them.
Okay. You mentioned maybe it was at the bench that you had some other ones.
There were 6 or 8 more, but I believe rather than going to those individually, some of them are duplicative. I'll just let the jurors look at them one by one, if that's all.
All right. It's allowed.
And hopefully I don't have to read all of them back into the record.
Yeah.
All right, thank you. You took all of your photographs on the 9th, is that right? December 9th?
Yes.
Now, did you take them all at one time, or were there 2 different times you were taking photographs?
The majority of the photographs I took in the morning hours of the night prior to attending the autopsy. When I returned from the autopsy, I took other photographs as well.
Now, you stayed there about how long the morning of the 9th?
I arrived at approximately 0540 hours, and I stayed until approximately 1100 hours left to go to the autopsy, and then returned sometime after 3:30 p.m. I don't recall exactly what time.
At about what time did the autopsy of Kathleen Peterson begin?
Approximately 11:30 hours.
Now, when you arrived back to the dwelling that afternoon, you say you took more photographs?
Yes.
Did you observe any luminol testing on the top of the stairway?
Yes.
Who did you see performing that test?
CSI Eric Campen.
Now, while you were at the autopsy and at the conclusion of the autopsy, were you asked to bring a number of items back to the property room?
Yes.
Can I approach the witness? Just look at these items if we could. What we got there? 38A, 35A, 36A, 37A, 32A. And a bag marked 32A. If you would look at these items, we're going to come back to this one. See if you recognize each of them.
Yes.
How do you recognize them?
These are the items that I collected from the medical examiner's office on December 9th, 2001.
How does that happen when you go to the medical examiner's office, watch an autopsy, and then bring items back? What process is used?
Usually the medical examiner or someone who works in the office packages evidence items for us after the conclusion of the autopsy, and we transport them back to headquarters where we turn them into property.
And do you actually document that by way of a sheet entitled Evidence Disposition?
Yes, it's a sheet that we are given by the person who transfers the items to us at the medical examiner's office.
Take a look, please. It states Exhibit 155. Let's look at that. What is that?
This is the sheet, the evidence disposition form that I received from Natalie Depchick-Smith from the medical examiner's office.
Keep your voice up, please, now. Did you sign that?
Yes, I did.
What date and time is on it?
December 9th, 2001, 2:10 p.m.
Does it list all of the items that you brought back from the medical examiner's office?
Yes, I also brought back a footprint and fingerprint card from the victim as well. I don't believe that's listed on here.
All right, read aloud, please, the items that are listed there.
Number 1 says a small wood metal chip found in hair at back of scalp. Number 2 says purple top tube of blood from aorta. Number 3 says hair found in right hand. Number 4 says DNA card from blood of aorta. Number 5 says scalp hair. Number 6, hair found in left hand. Number 7, clothes, sweatshirt, and sweatpants.
All right, I move to introduce State's Exhibit 155 into evidence. Now let's identify each of the items that I've handed to you. First of all, 35A is what?
The hair that was in her hands, when they tested it, it was her hair, I believe. And that fed into the owl theory that when she reached up to get the owl out of her hair, she got some of her own hair in her hand. And then supposedly it was tested, the hair was tested, and they found microscopic feathers in the hair, but it was too late by the time they found that, and they couldn't submit that into the court. I don't know if I believe that or not. I feel like if that was true, they would have gone ahead with the second trial and submitted that evidence, but they didn't. He took an Alford plea. So, I don't know. What do you guys think?
35A are the prints that I took from the victim, fingerprints and footprints.
I move to introduce.
Yeah, David. The owl theory. There is a theory that an owl killed her. That an owl attacked her, caused the lacerations on the back of her scalp, and that she stumbled into the house and collapsed at the bottom of the stairs and bled to death.
35A and its contents into evidence. Okay. What is 37A?
37A are hair samples from the victim.
Open that and look at the envelope to see if they look like what you brought back from the medical examiner's office. No.
Yes.
All right. I moved.
In the area, there are great big giant, they're called barred owls. We have big ones here too. I don't know if they're the same. I don't know if they're the same owls or not. Like, we have owls here. Like, they're big enough they could pick up my beagles. They're huge. When I had my Chihuahua, I had to stay outside with him. Well, not for the owls. We have hawks too, but I had to stay outside with the Chihuahua when he went outside to make sure that none of those big birds of prey got him, because in the southeast United States, we have some big birds of prey that will pick up dogs, small dogs. So there are birds that are big enough to do that, but I don't think that's what happened in this case. I really don't. Oh. Yeah, that's possible. Yeah, that is possible. I mean, if it's even true that they were there. I mean, who knows if they were really even there though? Did they really retest the hair and find the microscopic feathers, Like, I don't know. But supposedly, and I wish I could show you. If you guys have Netflix, you don't have to watch the whole documentary. There's one, if you go to, I don't remember on Netflix if they have a thing that says extras or if it's just in the list of episodes. There's a short little tiny clip. I mean, it's super short. Like seconds short, of them explaining the owl. Yeah, that's possible too. There was no blood at the top of the stairs. It was all at the bottom. So the theory is that the lacerations, unless, well, no, that would be stupid. I was going to say unless he got rid of the big feathers, but that would be stupid because if he wanted to prove that the owl did it, not him, he'd leave the feathers there. But the lacerations, they say, look like talons, like they're in the shape of, a talon, like they're like this with then one going down. So they look like they're a shape of a talon. I don't know. I really don't know. But so supposedly cuz a scalp wound bleeds really really bad. Your scalp is really vascular, so it bleeds really really bad. So that's the theory, that the talons cut her scalp and then that's why there was so much blood. Owlman killed her. But as much as your scalp bleeds, it's not like an artery or anything. I don't think you're going to bleed to death. I really don't. I mean, I don't know. Is it even possible to bleed to death from a scalp wound? Now, a head fracture, a skull fracture, yeah, you could die from a skull fracture, but her skull wasn't fractured.
Introduce 37A and its contents and the evidence.
So,
What's this? 36A. What is that?
$36A is labeled as the DNA card from the victim.
You brought that back?
Yes.
I move to introduce 36A and its contents and the evidence.
so,
2. What is 38A?
That's the blood tube from the aorta of the victim.
That you brought back from the medical examiner's office.
Yes.
I move to introduce 38A and its contents and the evidence.
It's a blood tube.
Now let's look at the contents of this bag. 32A. Go ahead and pull the contents out, please, and identify those for us.
These are the sweatpants.
What are they labeled as far as the state's exhibit number?
They're labeled State's Exhibit 32.
Those are Ms. Peterson's sweatpants.
Yes.
All right. I moved to introduce State's Exhibit 32 into evidence.
so,
What is the next item that comes from the bag?
This is State's Exhibit 33, and this is the sweatshirt of the victim.
The one you brought back from the medical examiner's office?
Yes.
I move to introduce State's Exhibit 33 into evidence.
so,
May she be allowed to step before the jury to show those two items.
so,
Bring those with you if you would, please. Hold them before the jury. Show the front and the back of each item so that each juror may see. Please.
Oh, that blood tube, woman.
All right, while she's doing that, I move to introduce the package that housed each of those items 32A into evidence.
so,
Was there blood on the top? On the top. How did that?
Now let's show these sweatpants, please. Let's begin with the front of them, if you would. Is that the rear you're showing this juror?
Yes. This is the back of the sweatpants.
There's more blood on the back.
Let's begin with the front.
This is the front. This is the back. Yeah, this is the front. And the back.
Thank you. You may put those back in the bag. Now, while you're doing that, Miss Ashby, when you say you attended the autopsy, did you actually watch it?
Yes.
Were you clearly, witness,
Yes.
were you clearly able to see what transpired there during the autopsy?
Yes.
Were you clearly able to see the wounds on Kathleen Peterson's head?
Yes.
I'll show you a photograph marked P175A. Do you recognize it?
Yes.
What is it?
It's a photograph of the back of the head of the victim.
Is that the way you remember seeing it back on December 9th of 2001?
Yes.
Take a look, please, at P175. Is that an enlargement of that same photograph?
Yes.
And do those injuries represent what you saw during the autopsy?
Yes.
I move to introduce State's Exhibits P175 and P175A into evidence.
There was blood all over the butt of the sweatpants. So when she started bleeding, she had to be standing for the blood to get on the butt of her pants. She did end up sitting, but she had to be standing for it to get on the butt. Because there would have been a void there if she'd been sitting when she started bleeding. There would have been a void on the butt where she was sitting. So in order for the blood to get underneath her butt, she had to be standing when it started. I can't think of any other way for the blood to be on the butt of the sweatpants, which makes his story not make sense at all. Because if she got the lacerations on the back of her head from falling down the stairs, unless no, no, it still wouldn't be that much blood. Because because there was blood, so the stairs like curved at the bottom. There was blood on the wall. Like if she fell down the stairs and then hit her head and started bleeding, there was blood on the wall. Yeah, head wounds do bleed a lot. So she got blood on the wall and then fell around the corner and landed kind of weird. I still don't see how she got so much blood on the bottom of her sweatpants and almost none on the shirt. Maybe. Yeah, I was wondering about that too cuz the shirt is darker. Maybe we just can't see it. Why would he dress I was going to say why would he dress her in bloody clothes, but maybe the clothes got bloody because he dressed her. I don't know. None of this makes sense. None of it makes sense. There are certain cases, you guys are going to laugh at me, but there are certain cases that when I get to heaven, I'm going to ask Jesus about. Like, one of the first ones are going to be, who killed JonBenet Ramsey? Or when we get to heaven, are we going to have like instant knowledge of everything? Because if we are, I don't know. That might blow our minds too much. like, I have all these cases in my head. Like, when I get to heaven, am I just going to know everything? Is it going to be like, oh, wow, I now did kill her? So-and-so killed John Benet Ramsey. Oh, I know where Savannah Guthrie's mom is. Oh, speaking of cold cases that have been solved, I saw this morning that Rex Heuermann hey Mike, Rex Heuermann is going to plead guilty to the Gilgo Beach murders. That blew my mind.
Wow.
I'd like to ask these to pass to the jury, please.
Wow. Cross-exam.
Morning, Ms. Bell. I'm sorry, Ms. Asher. I think you mentioned that you observed that luminol testing that Eric Campa was doing on the 9th.
Yes.
Did he ask you to photograph that at all?
No.
No further questions.
Oh my God!
Thank you.
All right, you come down. Yes, that's allowed.
Ma'am, for the record, please state your name.
Vicky Mincer, Durham County Detention.
How are you employed?
Sorry, I'm a sergeant for the Durham County Detention Facility.
How long have you worked in the detention facility with Durham County?
Going on 9 years.
Okay. If you would please take just a moment and describe to the jury what your educational background has been, what your training and experience has been as it relates to your employment with the Durham County Detention Facility.
I worked at I was in booking for 8.5 years. I processed detainees that came in, and if they required to be fingerprinted, I did the fingerprints. Or if they were misdemeanor, we didn't fingerprint them. But we just processed them. They're given a 2-hour time limit to make bond or either go upstairs.
Okay. Now, during your nearly 9 years in the facility, that's the Durham County Jail, right?
Correct.
It also houses the magistrate's office as well.
Correct.
And specifically, where are you all located within the facility and in relation to the magistrate's office?
The magistrate's office is on the other side. It's the actual place where they come into the facility, where we don't receive them yet. They're brought in either by the sheriff department, the deputies, or the police department. And once they have received, they've been processed with them as far as the arrestee's paperwork done and going before the magistrate and receiving a bond. After that, they're brought over to the detention part of the jail, which is booking.
Okay. Would you please describe the booking process that one would go through after they reach your side of the facility?
If they have already received their bond, they would come into us, empty out their pockets, place everything on the counter. They are written in under a ledger for coming into the jail to keep a time log of how long they're there. And they're given that time to process, to get out, to make their phone calls, to talk to the bondsman or their family members. If they're felony, being charged under a felony, they would come in without a bond, but the proper paperwork would be done already, where you would have the arrestee report and then the supplemental report. And you'd have to have a felony warrant. And it'd have to be signed, and the charge and the general statute numbers would have to match under what you're charging them with. And the magistrate would have to have signed it, and then I would go to the live scan, make a document of it, sign them a check digit and a picture, photo ID number, and I would process the information from the arrestee report and the supplemental into the live scan computer.
All right, you're talking about a live scan computer. Exactly what is that?
It's a computer that we use to take the fingerprints. We put in all the information that's given to us, even the charge, and the live scan assigns a check digit. And after that, there's a process that you would roll the fingers in, and you would do left hand first, then right hand, and then after that, we'd wait for the computer to process it all down onto the hard drive. Then it would come out. We'd take the black ink and do your palm prints, and also roll your right thumb onto the supplemental sheet, which goes along with the felony process. And we press your right thumb down 4 times, and then you're sent over to the part of booking where there's the pictures to be taken. And you would stand there and take 3 poses, and we call out your name, your full name, the check digit number, and the photo ID number, and the date that it's being done in.
And with respect to the live scan, you indicated that's a computer, and that you roll the prints in the computer. Can you describe generally how you do that? I mean, is it just a glass top that you roll the fingerprints on, or how does it work?
It's actually a plate, a glass plate that sits on the flat part of the computer. It sits on the table of it, and it has a laser, and it tells you when it has a good print and when it doesn't. If it doesn't have a good print, it'll come back and say poor, or it'll come back and say good. Either way, it'll let you know. And also, as you're rolling this print, the screen goes from black to showing you what you're doing. So you actually get to see if you're missing the actual fingertips, what part of the finger isn't touching, if it's not flat enough, or if their fingertips are rough, that you might need to wet their fingertips so that it can get a impression on the plate. And the plate, the laser goes across it and it scans it as you're doing it. So you're not using ink at that point. You're using just moisture from the fingertips.
And I think you indicated a moment ago, live scan won't take the palms, and you actually ink those?
Correct.
Go ahead.
We have a blacktop ink table that you actually take the roller and the ink, and you would roll it out evenly and take the palm and suppress the fingers back and roll the palm out, and then you would take the palm and place it down on the back of the felony arrest card, fingerprint card, and you would mash out the palm prints onto the board.
Now that process you described is real different from the old way, isn't it?
Correct.
How did you do it when you were first starting out? I'm assuming they still inked everything, is that right?
Correct. When I first started out, there was 3 cards you had to fill out. If they were arrested from the sheriff department, they had a card. The police department had a card. And you had an SBI card and a felony FBI card. You had to write down all the information, everything they gave you on each and every card. You had to fill out whether the picture was taken, where you got the check digit number from, which usually came with 2 cards suppressed together, and you had to pull them apart. You had to roll every finger on each card. So you rolled their fingers at least 30 times, and you suppressed their palms twice.
And with live scan, you don't really have to do that much.
No, the card, you don't have to fill out no cards. You just have to type in all the information, which takes little time at all.
Now, with respect to the live scan, does it actually produce a card?
Yes, it does.
And where do you house those cards?
Down at the Durham County Detention Facility.
With respect to the information in the computer, is that available? Well, let me back up. Do you send that to other agencies?
If they request that they would like a card, yes, and they have all their numbers sequenced into the SBI, they can request a card to be sent to them.
Do you automatically send the live scan fingerprint card to the State Bureau of Investigation?
Yes, sir.
And how is that done?
You would go through the process of finish, and it would ask you, do you want to put or remove information, put information, is everything correct according to the arrest report? And you would select yes, and then you would push done, and it takes maybe a 30 to 45 second for it to take out all the information that you put in and send it, wire it to the SBI, and that's where they hold it.
Okay. Now, with respect to your employment with the Durham County Detention Facility, exactly what were you doing on the 20th of December of 2001?
I was assigned to booking intake. I was the booking officer. I was the one who received you at the door when you come in, and I would write your name in. If you were a misdemeanor, I would write your name in. If you were a felony, I would just be in charge on a felony. I would just hold your charges until you come back from being explained your charges and receiving a bond.
Now, on the 20th of December of 2001, do you recall processing Mr. Peterson through the booking area as it related to taking his live scan prints?
Yes, sir, I do.
And about how long did that take?
No more than maybe 5 minutes, 5 to 8 minutes at the most.
After the prints were taken, was that information electronically sent to the State Bureau of Investigation?
Yes, it was.
Okay. Your Honor, I have no other questions of witness.
Prosecutor, no question. You come back. So,
Another person he didn't cross-examine. Well, he cross-examined the last one.
Oh, excuse me. Would you please spell it?
Spelled Petzka.
How are you employed?
I am a special agent with the State Bureau of Investigation, assigned to the Latent Evidence section of the Crime Laboratory.
How long have you worked in the Latent Evidence section of the State Bureau of Investigation Crime Lab?
I've worked in the Latent Evidence section for slightly over 20 years.
And during the time period that you've been there, what specifically have been your responsibilities at the Latent Evidence section?
In the Latent Evidence section, we examine evidence for the presence of latent fingerprints or palm prints or footprints and compare them to known inked impressions to effect a positive identification. I also compare questioned shoe track impressions and tire track impressions to known shoes and tires.
Would you please take just a moment and describe to the jury what your educational background has been and what your training has been, specifically as it relates to your responsibilities at the Latent Evidence section of the State Bureau of Investigation?
I've received 480 hours of training in the science of fingerprints from the Federal Bureau of Investigation. I then worked for 6.5 years in their identification section, where sets of inked impressions were submitted from agencies across the country. Excuse me. Those sets of inked impressions were then classified by characteristic and compared to prints in the existing files, and identifications were made by the characteristics. I then worked for 6.5 years in North Carolina State Bureau of Investigation's identification section, doing the same type of work only on a statewide basis instead of a national basis. In March of 1983, I was assigned to the Latent Evidence section, where I received 8 months of classroom and on-the-job training in the examination, processing, preserving, and comparison of latent prints. In addition to the latent print training, I also received training in question footwear and tire track examination. At that time, there were no formal schools, so for a period of 2 years, I worked with the qualified examiners already in the section and learned the methods of comparison and identification as far as shoe tracks are concerned. Initially, I worked with the examiner as they were looking at the cases, and then eventually I ended up doing the cases first and having them review them after I completed the work.
Do you have any idea how many fingerprint comparisons you've made in your 20-year career?
Hundreds of thousands, I would say.
Do you have any idea how many analyses you've conducted of footwear or tire impression comparisons in your career?
Several hundred, at least.
Have you had the occasion to testify and qualify as an expert in the courts of this state or in federal court as a fingerprint examiner and comparison expert?
Yes, I have.
Approximately how many times?
I've testified approximately 83 times in fingerprint comparison and approximately 36 times in shoe track comparison.
You know, at this point, we would tender Agent Pesca as an expert in the field of fingerprint and latent print identification and in footwear impression examinations and comparisons.
It's allowed.
Now, Agent Pesca, did you have the occasion to review some items submitted to you from the Durham Police Department?
Yes, I did.
No, I mean, witness, please.
Yeah.
I'm sorry, but I don't understand why fingerprints matter in this case. They don't think that an intruder came in and killed her, unless you count the owl. And owls don't have fingers. I don't understand why they're taking fingerprints. I mean, that just might be naivety on my part, but I thought they took fingerprints when they thought someone broke into your house and did something. The only people that have been there are the people that lived there. Why are they taking fingerprints? Am I just being obtuse? I don't know why they're taking fingerprints. Somebody explain this to me. I'm stupid. I need an explanation. I don't get it.
And before we get to those items, would please describe what a latent print is?
A latent print is a hidden or chance print that is left on the surface when a finger or palm touches that surface. The print is made visible by either using chemicals or powders, depending on the type of surface it is on. Once the print is visible, the print is then preserved either by lifting it if it is a powder print and placing that lift on a card, or by photographing it if it's been enhanced by chemicals.
And with respect to what was presented to you from the Durham Police Department, were those photographed or were they lifted? Any latent prints that you received from them, do you recall?
I received some lifted prints and I also received some photographs.
All right. Now, with respect to any analysis that you conducted, do you typically?
And see, like, even if they had the blowpoke and they did fingerprinting on the blowpoke, that's not going to tell him. That's not going to tell them anything because the blowpoke belonged to them. So yeah, their fingerprints are going to be on it. I don't know what they're going to what do they expect to find from fingerprints? The people that lived in the house? That I don't understand. I don't understand. I need someone to explain this to me. Where is Paul? I need to get with Paul. We need to figure out a time for to do a members only live with Paul, and I need to figure out a list of questions. And I guess I need to do a post and have you guys submit questions for Paul, cuz he used to be a court officer and he's got stories. I'm going to let him tell stories too, but I want to ask a few questions. So if you guys have any questions for Paul, let me know. I guess I'll start a thread in the Facebook group too. Cause like I said, I have a couple questions and I know he has stories he wants to tell. So, booger sugar. Booger sugar.
Typically, take what is presented to you, or if you have an article that is believed to have a latent print on it, do you take your own photographs?
Yes, we do.
Or your own lift?
Yes, we do.
In which do you typically do?
It depends on the type of processing that I have completed. We have a specific set of processes that we use on all of the items that are submitted. Initially, an item is what we call super glue fumed, and it's placed in a tank with super glue, and the fumes adhere to the moisture in the prints, causing it to become a polymer and harden. And then we can process it with fingerprint powder, and sometimes the prints are sufficient to be lifted at that point. If there are not any prints there sufficient to be lifted, we then process it with a chemical called rhodamin 6G, which will fluoresce under the use of a laser. And when those prints are developed in that manner, we photograph them.
Whether it's a photographic print or a latent that's been lifted, how do you go about comparing those to a known subject print?
The latent print is placed next to the inked print that we are comparing it to. We then look at both of them and are looking for characteristics that are present in those prints. And by the characteristics, I mean an ending ridge, which is a ridge that flows and then just stops. A bifurcation, which is a ridge that flows and then splits to form two separate ridges, or a dot, which is a ridge that has no length to it. It's just a small speck in the detail. When we're looking at the prints and comparing them, we're looking to see that the same characteristics are present in both the latent print and in the known print. And we're also looking to make sure that the relationship between those characteristics is the same. That is, if there is a ending ridge and 3 ridges down from that, there's a bifurcation. 2 ridges down from that, there's another bifurcation, and below that, there's another ending ridge. That same relationship of those same characteristics has to be present in both impressions, and then we can say that they were made by the same finger.
Okay. Just because a finger is put on some kind of substance doesn't.
Yeah, what are they going to do if they find an unknown? Are they going to say somebody snuck in the house and killed her? Is that going to change the whole entire theory of the crime if they find an unknown? It could be like one of the kids' friends or something. I don't understand. Is it just because it's protocol to take fingerprints at a crime scene? I guess because it's just protocol. I don't understand why they're taking fingerprints. It's just another added step. And I'm sure if they didn't do it, Rudolph would probably get up there and go, "Why didn't you do it?"
Necessarily mean it's going to leave a print. Is that right?
That's correct.
If you would please generally go through some of the things or materials that someone could put a finger on and it not necessarily leave a print, just generally.
Textured surfaces, there may be prints there, but the texture of the surface will interfere with it, and you won't be able to get much identifiable detail. Another factor that comes into play is how much moisture is on a person's hands. Some people have very dry hands and do not have a lot of oil and moisture on their fingers, and they can touch things, but if there's no oils, they will not leave a fingerprint. Smooth surfaces are generally good. We also can get prints off of porous items such as papers and cardboard, things like that, where the oils, if they are present, will be absorbed into the papers, and then we treat them with a chemical which will react to those oils, the amino acids in the prints, and turn them a purple color.
And exactly what makes up a fingerprint?
A lot of it is water, but there's also oil in it,
Okay.
and
Now,
perspiration.
all right. Now, would the surface, say if a surface, even though it was a flat surface, if it had moisture or oil or something like that on it, would it affect the ability to receive and sustain a fingerprint?
Yes, it would.
Can you describe generally whether under normal conditions you could get a print off a surface that was moist or oily?
If a surface is covered with moisture or oil, you're probably not going to get prints because that will mask it. If the substance is a kind of a thick surface, you may leave an impression in that surface. Such as dirt or something like that, you may be able to leave ridge detail in that surface, and rather than leaving something on top of the surface.
What about blood?
You could leave prints in blood.
All right.
If you had blood on your finger, there's another way you could have. If you have another substance on your fingers, you could also leave that when you touch something. Such as blood. You could leave it on a surface. If there is blood on the surface and you touched it, the ridge detail may take away the blood that is on the surface and leave the ridge detail.
All right. Well, just because, if say a subject put something down on the surface doesn't necessarily mean that it's going to leave a fingerprint.
No, it does not.
Okay. Your Honor, may I approach the witness again, please?
Yes.
Now, let me show you, if I may, a series of items and ask whether you can identify these, please. Let me show you what is marked as State's Exhibit 76 and ask if you can recognize that.
Yes, I can.
What is it?
It's a white envelope, and it's marked with the laboratory case number, the item number from the lab, the date I received it, and my initials.
Would you please open it up, please? Now, let me show you the contents, which is marked as State's Exhibit 76A. Do you recognize that?
Yes, I do.
What is it?
It is a set of inked fingerprint impressions bearing the name Michael Peterson.
And how do you recognize those?
It has the laboratory case number, the item number, the date I received it, and my initials.
At this point, we move into evidence what's marked as State's Exhibit 76 and 76A.
So,
Now, how did you acquire this fingerprint card?
This fingerprint card was received from the SBI identification section through an automated system that we have that is called NIST Archives. Prints are stored in the automated system, and we can obtain them through the files, through the automated files, and print them out on a printer that we have in our section.
And with respect to what's marked as State's Exhibit 76A, did you do that?
Yes, I did.
And with respect to that item, did you then compare that series of fingerprints with items submitted to you by the Durham Police Department?
Yes, I did.
Let me show you what is marked as State's Exhibit 16B and ask whether you can identify this, please.
Yes, I can.
How can you identify it?
I placed a plastic tag on here that has the case number, the item number, the date that I opened it and took it out of the evidence container, and my initials.
All right. Now, with respect to what's marked as State's Exhibit 16B, did you determine that there were identifiable prints on that item?
Yes, I did.
If you would, please describe to the jury how you went about that process.
Initially, I processed it with the fingerprint powder and made one lift off of the glass. After I did that, I then processed it with the Roteman 6G and looked at it through the laser, and another print had developed, which I was able to photograph.
If you would, please hold the article up and generally show the jury where you located the print.
The print that was photographed is in this general area,
Right?
but I do not remember where the print was that I lifted.
Okay. Let me show you another envelope next to it. Like this. Let me show you what's marked in State's Exhibit 156. And we'll mark this as 156A. And ask whether you can identify this, please.
It's a manila envelope that is marked with the case number, the item numbers, and my initials.
If you would, please open that up. And remove the content. Okay. Show you what's marked as State's Exhibit 16A1, 16A2, and 16C1, and ask whether you can identify these, please.
Yes, I can.
How can you identify them?
They're all marked with the laboratory file number, the item numbers, the dates I lifted. Two of them are latent lifts, and they're marked with the dates that I lifted them and my initials. The other is a picture, a photograph, and it's marked with the date that I took the photograph, and it's got my initials.
You know, at this point, we'd move into evidence what's marked as State's Exhibit 156A. We would also move what's marked as State's Exhibit 16A1, 16A2, and 16C1.
So,
Now, Agent Pesca, with respect to these lists that you've described, did you have the occasion to compare them with the fingerprint card that is marked as State's Exhibit 76A?
Yes, I did.
If you would, please describe to the jury what your analysis revealed.
One of the lifts was lifted from this wine glass. I'm not exactly sure where. It's on the top rim from the disc, because I can see the pattern of the glass in it, and so it had to have been up around the top rim somewhere. That has ridge detail, but is not sufficient for comparison purposes.
All right.
The second lift was taken from one of the wine bottles that were also submitted to me when the glass was submitted.
All right.
And there was ridge detail on there, and I was able to identify it as having been made by the right middle finger of the same individual whose prints are on the card bearing the name Michael Peterson.
All right.
The photograph is of ridge detail that I developed on the glass near the stem. And I was able to compare that also and identify it as having been made by the right index finger of the same individual whose prints are on the card bearing the name Michael Ivor Peterson.
Now let me show you what is marked as State's Exhibit 16C and ask whether you can identify that, please.
Yes, I can.
How can you identify it?
It's marked with the laboratory case number, the item number, the date I took it out of the evidence container, and my initials.
And you compared, you indicated a moment ago that you were able to conduct an analysis of that article and that you had a lift. And for the record, this is marked as State's Exhibit 16C1. Is that right?
That's correct.
And again, where was this located on what is marked as State's Exhibit 16C?
It was on the back label on the upper right corner.
All right. And you also indicate that with respect to this lift, there was an identifiable print that corresponding to the print card bearing the name of Michael Ivor Peterson.
Yes.
So based on what is labeled here, what type of wine is that?
It's Herbaceo Apulian white table wine.
All right. Did you have the occasion to look at other articles for fingerprint comparison analysis?
There was another wine bottle and another glass.
Okay, just to show you these, did you attempt to compare or conduct analysis of what's marked as State's Exhibit 16D? You recognize that?
Yes, I do.
Were we able to take any latent lifts off of this article, or were any submitted to you?
No, I was not.
Now let me show you what's marked as State's Exhibit 16A and ask whether you can identify that, please.
Yes.
How can you identify it?
There's a red tag on this one also that has the case number, the item number, the date I took it out of the evidence container, and my initials.
Now, is it in the same condition as it was when you received it?
No, it is not.
If you would, please describe the difference in the condition.
There are two breaks in the stem of the glass, and it's been repaired. When I received it, it was all in one piece.
Now, did you conduct an analysis with respect to what's marked here as State's Exhibit 16A to determine whether there were any fingerprints on that as well?
Yes, I did.
Did you locate any identifiable prints?
No, I did not.
So if I understand you correctly, then the only articles that had identifiable prints would be State's Exhibit 16B and State's Exhibit 16C. Is that correct?
That is correct.
You'd indicated that there was a print on each. Were there any other identifiable prints on either of these articles that you were able to locate?
Not that I was able to locate.
Okay. Did you prepare a report as it relates to the analysis that you conducted of these items?
Yes, I did.
Let me show you what's marked as State's Exhibit 16E, please. Do you recognize that?
Yes, I do.
You know, at this point, we move into evidence what's marked as State's Exhibit 16E.
So,
Mr. Rudolph, you have a copy of that. We're moving that up. What's marked as State Exhibit 16E. I think I may have done that, but I want to confirm it.
It's allowed.
Now, did you have the occasion to compare any of these articles present, those being 16A, 16B, 16C, and 16D, as it related to other lifts that were taken off of any of these articles?
I did receive some other lists that were taken from some of these things.
Okay, let me show you what is marked as State's Exhibit 87 and have you pull out the contents if you will, please. With respect to some of these, let me show you what is marked as State's Exhibit 16B2 and 16B3 and ask whether you can identify these.
Yes, I can.
What are they?
State's Exhibit 16B2 is a latent lift of ridge detail on State's Exhibit 16B.
Okay.
State's Exhibit 16B3 is a photographic copy of that latent lift that I made in the laboratory. There was ridge detail that I noted on the latent lift, and I made a photograph of it on our image processing system to increase the contrast between the ridge detail and the background in order to make a comparison.
With respect to what is marked as State's Exhibit 16B2, from whom did you receive that, or who submitted it to you?
It was submitted by Officer Eric Campen.
All right. Now, with respect to that lift of Mr. Campen, with regard to this item, what's marked as State's Exhibit 16B, could you tell where that lift was on this article?
It's going to be on somewhere around the upper rim of the glass.
Is that a different lift from the one that you actually found?
Yes, it is.
All right. With respect to the lift that Mr. Campen submitted to you, did you compare that with a fingerprint card to determine whether there was a comparison of these two articles that matched?
Yes, I did.
Let me show you what's marked as State's Exhibit 157 and ask if you can identify this, please.
Yes, it's a white envelope that I have marked with the laboratory case number, the item number, the date I received it from the ID section, and my initials.
Would you please open it? Did you take the contents out, please? I'll show you what's marked as State's Exhibit 158 and ask if you can identify this, please.
Yes, I can.
What is it?
It is a set of inked fingerprint impressions bearing the name Michael Peterson.
And from whom did you receive those, or how did you come into possession of those?
I received it from the SBI's identification section via the NIST archives, again, on the electronically transmitted computer.
Now, with respect to what's marked here as State's Exhibit 158, did you then compare that to what was submitted to you by Mr. Campen?
Yes, I did.
And for the record, that would be what's marked as State's Exhibit 16B2. What was the analysis of that article as it relates to your activities?
there was one latent fingerprint of value on the lift, and I compared it to the known inked impressions of Michael Peterson and was able to identify it as having been made by the left middle finger.
You know, at this point, we move into evidence what's marked as State's Exhibit 16B2, 16B3, and 158.
So,
Okay. Well, if you'll allow me just a second, I'll get this kind of organized and packaged back up. Now, with respect to what is marked as State's Exhibit 158, that being a fingerprint card, and what's marked as State's Exhibit 76A, what is the difference in these two cards?
The card is the same set of impressions that is stored on the computer in the identification section. The only difference is one is the time that I got them, for one thing, but there's a little difference in the contrast and the darkness of the prints, and that's due to the difference of the ink cartridge in the printer. But it is the same rolling of the inked impressions, or the impressions.
Here. Now, did you have the occasion to compare a series of photographs with known fingerprint samples or with fingerprint cards?
I received several photographs for comparison, yes.
Approximately how many photographs did you receive, and what did they look like?
There were 22 photographs, and many of them were of the same area of ridge detail.
Could you tell what those photographs were in, or what the fingerprints appeared to be in?
They appeared to be in blood.
All right.
And there were 8 different areas of ridge detail that were in those 22 photographs. But upon examining them, there was ridge detail, but none of it was of value for comparison purposes. Some of it was smudged, some of it was just fragmentary and not enough detail in it to make a comparison.
All right. Now, did you prepare a report with respect to the analysis of the photographs you looked at and with respect to the latent prints that you received from Eric Campen, or
Yes.
latent print?
Yes, I did.
Let me show you what's marked as State's Exhibit 158. And ask whether you can identify this, please.
Sorry, date on that.
Excuse me?
What's the date on that?
That's going to be. No, Ms. Black is telling me this needs to be Exhibit 159. So if we can change that, please. Again, show you what's marked as State's Exhibit 159. Can you identify that?
Yes, I can.
What is it?
It is the report that I generated on April 25th of this year, referenced the latent lifts, 8 latent lifts that I received, and the 22 photographs.
At this point, we move into evidence what's marked as State's Exhibit 159.
so
Now, Agent Pesca, with respect to other analysis that you conducted, did you have the occasion to compare footwear to an impression on a pair of sweatpants that were submitted to you in this case?
Yes, I did.
I'm going to approach the witness, please.
Yes, sir. Ms. Harden, how much time is it going to take?
About 20 minutes.
We better break it at this point.
Yes, sir.
All right, the members of the jury will take our lunch break. Remember the instructions I've given you throughout the course of this trial. I'll need to have you back at 12:45. Further questions, Mr. Harden?
Yes, sir. Now, Agent Pesca, just before we broke for lunch, we were getting ready to move into different subject matter. But before we go there, let me ask you a couple of other questions about the wine glasses and the wine bottles, if I may, please. You want to approach the witness?
Yes.
Now, in your direct testimony, I want to make sure that you're clear on exactly what you said with respect to these items. And I want to show you again what's marked as State's Exhibit. (16B) and ask, is that the item that you located the two prints on?
Yes, it is.
Your Honor, could the witness step down and show the jury what's marked as State's Exhibit 16B?
So,
And with respect to that item, I think you indicated that you found a lift and you were submitted a lift by Eric Campen off of that article, is that right?
That's correct.
And they were identified as belonging to whom?
To Michael Peterson.
Did you find any other partials or any other prints at all on that article?
There was some other ridge detail, but it was not a value for any type of comparison.
Okay. Let me show you what's marked as State's Exhibit 16A. Your Honor, with your permission, can she show that to the jury?
so
Now, with respect to that item, did you find any identifiable prints on that at all?
There were no identifiable latent prints on this glass.
And I'll show you what's marked as State's Exhibit 16C. With your permission, can she show that to the jury? And what type of bottle is that?
It's a bottle of Embraccio white table wine.
And I think you indicated that you found one print on that, is that correct?
That is correct.
And you actually lifted that.
I lifted that.
And to whom did that print belong, or was it identified?
It was identified as I don't remember which finger, but it belonged to the same, it was identified to a fingerprint on the card bearing the name Michael Peterson.
Did you find any other partial prints or any other prints or anything like that at all?
There was some other ridge detail, but it was not of value for comparison purposes.
All right. Now, in earlier testimony, one of the identification technicians indicated that he would have conducted phenolphthalein processing of this item. Could you describe what, if any, impact that would have had on the prints that might have been on this article?
When they do phenolphthalein, a lot of times they don't wipe the entire surface of the bottle. And in addition, the way they do a phenolphthalein examination is to take a white pad and wipe the dry pad on the bottle and then drop the drops onto the pad, and the pad changes the color if it is blood. That may or may not have an impact on the impressions.
If the reverse had been done, if the pad had been sprinkled with the phenolphthalein solution and then wiped over the article, what impact would that have had on any prints if they were there?
If you used a wet pad, it would probably wipe off any rich detail.
But you did find one latent print.
Yes, I did.
Let me show you this what Marcus states to do at 16D. John, could you show that to the jury as well, please?
So,
And what is that?
It's a bottle of Shandong sparkling white champagne, I believe.
I think you indicated you processed that.
Yes, I did.
Whether there were latents as well.
Yes, I did.
Did you find any latents on that article?
There was some ridge detail, but again, nothing of value for comparison.
You conducted one additional comparison, is that right?
Yes, I did.
Would you please describe to the jury what that was about and how you went about that process?
I compared there was a footwear impression on the pair of sweatpants that had been submitted to me, and I compared them to a pair of known shoes.
May I approach the witness, please?
Well, let's just say the documentary. Hang on. Let's just say the documentary is much, much better than the trial. I thought the trial would be so much, well, not better, but at least as good as the documentary. It is so boring. I'm ready for the male escort to testify. This defense attorney is driving me insane. From the documentary, I thought this was an actually nice, ethical, good guy defense attorney, and so boring. Not so boring. So boring. He seemed like such a good guy in the documentary, and he just keeps asking the same questions over and over and over till he gets the answer he wants. But so he'll ask a question, and the first answer out of the witness's mouth is the answer. They'll say no or yes, and then they'll add something behind it. Like one question was, you could have sprayed that with luminol, right? You could have that surface can be sprayed with luminol. And the guy said, yes, any surface can be sprayed with luminol. That wasn't my question, sir. Listen to my question. He answered your question. So then he asks it again. And then another similar thing, and he asks it again. Like, he's answering it. The first word out of his mouth is the answer. Ugh. He's driving me insane. I think he drove everybody else insane before he drove me insane, because I liked him from the documentary. And everybody's like, he's an a-hole. He's an a-hole. And I'm like, oh, and he's just doing his job. and then he started driving me nuts. Hey, Nichelle. Actually, this is an old microphone, but everybody complained about it. And I was using my earbuds and using that microphone. And then I went back and listened to myself, and I was like, ew, that's awful. That is awful, 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 awful. And then I figured out how to control this stupid microphone. I mean, it still gives me fits sometimes, but I figured out how to make it louder. And most of the time it's good. I just have to remember to talk right into it. And then when I'm on my Disney streams and I'm talking on it, people are like, move the microphone. It's blocking your face. I'm like, if I move the microphone, you won't be able to hear me. You want to see me or hear me? You got to pick one of the two. Yeah, it is. It is. It is. This is the kind of defense attorney that you want, though. I mean, if you're on trial, this is absolutely the kind of an attorney that you want. This is the kind of attorney that will get you off. But Nichelle's right. He does get rude. And he nitpicks the cops about the way they do their job. And I don't like that. You know, he's like, well, was it a mistake that you didn't do this or that? Or, no, I just didn't do it. That was a judgment call on the cop. Doesn't mean it was a mistake. That's funny. Yeah, well, my husband got it for me. He didn't know what he was getting. It was a Christmas present. It was a surprise, so that's why. But it's okay. Dang it. My windows got separated again. You guys know how I hate it when my windows separate. Oh no. Did I lose it entirely? Uh-oh. Where did Core TV go? I lost it. There it is.
Yes.
Careful. She got mad at me last night. I was just
Let
petting
me show
her.
you what has been marked as State's Exhibit
He did not want to be
42A,
petted.
and the contents which are marked as State's Exhibit 32, and ask whether you can identify these articles and the packaging and the contents.
Yes, I can.
Fat fight.
What are those things?
32A is a brown paper bag that contains a pair of gray sweatpants, and a brown sweatshirt.
With respect to the gray sweatpants, did you conduct an analysis of those
Yes, I did.
articles?
Yes, I did.
All right. Let me show you what's marked. The state's exhibit. (3-1) and the contents being what's marked as state's exhibit 383B, and ask whether you can identify these, please.
Yes, I can.
What are they?
It's a brown paper bag containing a pair of white leather Converse All-Star athletic shoes.
And with respect to what's marked as state's exhibit 3B, what relation does that have to what is marked as state's exhibit 32?
There was a portion of a question footwear impression on State's Exhibit 32, and I compared it to the left shoe submitted to me and is now State's Exhibit 3B.
They both make
And I
too much
determined
noise.
that the portion was consistent, had the same design, the same size of the elements of the design, and the same general wear as was present on the shoe.
Now let me show you what's marked. Well, before we go there, how did you go about that process of comparing what's marked as State's Exhibit 32 with what is marked as State's Exhibit 3B?
I took the pants marked State's Exhibit 32 and made a photograph of the portion of question impression that was on the pants. I then used the shoe and, turning it upside down, applied fingerprint powder to the bottom of the shoe, made a lift of the design of the bottom of the shoe, and placed that lift on a piece of clear acetate to make an overlay to use for comparison. When we do our comparison, we then place that overlay over the question impression, and we can determine if the design and the size and the wear are consistent.
And in that particular case, was the design of this shoe consistent, design, size, wear pattern consistent with the impression that you saw on what's marked as State's Exhibit 32?
Yes, it was.
And let me show you what's marked as State's Exhibit 3B3 and ask if you'll open that, please. And show you what the contents, which are marked as State's Exhibit 3B4, and ask whether you can identify this, please.
State's Exhibit 3B4 are two photographs of the portion of question impression that is noted on the pants. One is in color and one is black and white.
Did you take those?
Yes, I did.
Now, at this point, we move into evidence what's marked as State's Exhibit 3B3 and what is marked as State's Exhibit 3B4.
So,
I'm sorry. Sure. Now let me show you what's marked as State's Exhibit 3B1 and ask whether you can identify that.
Yes, I can. It's a manila envelope that has my markings of the laboratory case file number, the item number, the date I lifted it, and my initials.
If you would please open that envelope and recover the contents from it.
They left the bloody clothes there?
Now let me show you what's marked at State's Exhibit 3B2 and ask whether you can identify that.
Yes, I can.
What is it?
It is a lift of the outsole design, or the design on the bottom of the left shoe that is State's Exhibit 3B.
Now, at this point, we move into evidence what's marked as State's Exhibit 3B2 and what is marked as State's Exhibit 3B1.
Hello.
Your Honor, with your permission, could the witness step down and show the jury what is marked as State's Exhibit 3B2 and what are marked as State's Exhibit 3B4?
It's allowed.
Please show the jury how these items correspond.
Photograph of the question impression. And placing the lift of the known shoe over it, the elements of the top part of the heel match up in design and size from the general wear.
And which shoe is that?
The left shoe.
And Your Honor, with your permission, could Agent Pettis could take what's marked as State's Exhibit 32 and what's marked as State's Exhibit, it's going to be 3B, to show the jury how these articles correspond.
It's allowed.
The impression is on the bottom part of the right leg of the pants.
Is that the front or the back side, Gina?
It's on the back.
Okay. And if you would, please take what is marked here as State's Exhibit 3B and show the jury how that corresponds.
It would correspond as this way. The toe going towards the bottom of the pants.
Now, did you have the occasion to have one other item submitted to you for analysis with respect to the items that were submitted in this group?
Yes, I did.
And what was that?
I received an empty package for a Trojan Ease condom.
Did you compare that with known prints that you had at your disposal?
I processed it, but there were no prints of value for comparison purposes.
All right. And with respect to all of these items and the analysis that you conducted with respect to what's marked as State's Exhibit 32 and 3B, did you prepare a report reflecting those results?
Yes, I did.
Let me show you what's marked as State's Exhibit 3B5 and ask whether you can identify that.
Yes, I can.
What is it?
It's the report that I generated on February 11th, 2002, referenced the condom package and the shoes and the clothes.
Your Honor, at this point, we move into evidence what's marked as State's Exhibit 3B5.
It's allowed.
And again, what were the results as related to this comparison?
There was a question impression noted on the pants, State's Exhibit 32, and it was consistent with having been made by the left shoe submitted and State's Exhibit 3B.
Right, any other questions of the witness at this time?
Yes, thank you.
Good afternoon, Agent Prescott.
Good afternoon.
My name is Dave Rudolph, and I'm one of the attorneys for Mr. Peterson. You several times you use the term identifiable prints or prints of value, and that's a term of art in your field, is it not?
Correct.
And just for the benefit of the jury, a print of value or an identifiable print is a print that has enough detail that you can actually compare it to a known print and maybe, not necessarily, but perhaps at least come up with a positive match.
Correct.
There are lots and lots of prints, I think you said ridge detail or partial prints, that they're real prints from real people, but they don't necessarily have identifiable value, right?
That's correct.
So, for example, if I touch a glass, if I touch, not a cup because this isn't a good example, but if this was glass and I touched it, I might leave an identifiable print that you could then lift and compare to my prints and say I touched it, right?
Yes.
Or depending on how much I secrete, whether my hands are sweaty, whether they're dry or not dry, I might leave no print at all.
Correct.
Or I might leave what's called a partial or unidentifiable print, right?
Correct.
Okay. So whether or not, for example, on this glass that I picked up, whether or not you get a print from me that you can identify or a partial print that you can identify or no print at all doesn't tell you whether or not I necessarily touched it, except in the event that you have a positive ID, right?
Correct.
So if we then take that principle and translate it to what we've been talking about here, may I approach, Your Honor? Yes. And may I stand up here? Is that right? Yes. Thank you. With regard to this item, I guess it's 16B maybe. This is the glass that you took 2 lifts off of, right?
I took one lift and made one photograph.
I'm sorry. In other words, you identified 2 prints off here.
Yes.
Okay. And what that told you is that Michael Peterson had this glass in his hand at some point, right?
Correct.
Would it tell you that it was that night?
No.
In other words, he could have had this glass in his hand some prior night and that print could have just been left there.
Correct.
Okay. And you also found some ridge detail. I said some partial prints, right?
Correct.
Okay. And you don't know if those belong to Kathleen Peterson, right?
Right.
Or somebody else.
Correct.
And certainly you can't say from the lack of any identifiable print belonging to Kathleen Peterson that she didn't ever touch that glass.
That's correct.
Okay. Now with regard to this other glass, here's the one that's broken, so I'm going to be careful with it. I'm not going to unwrap the whole thing, but it's the same sort of glass, right?
Correct.
And you didn't find any identifiable prints on this one at all.
Correct.
In other words, you found ridge detail,
Yes.
which would indicate someone touched it,
Yes.
but you couldn't say it was Michael Peterson
Right.
or Kathleen Peterson
Correct.
or someone else.
Correct.
As a matter of fact, on this one, as I recall, there were actually 3 or 4 identifiable prints that you just couldn't match with anyone. Isn't that right? That Eric Campen found?
No.
No? Okay. In any event, the bottom line is that we know that Michael Peterson touched this one at some point. We don't know who else touched it, and we don't know who touched this one.
Correct.
Okay, except that somebody touched it.
Correct.
All right. And of course, are you aware that Kathleen Peterson had a blood alcohol content of 0.07 that evening?
I read that in the newspaper.
All right. Well, in any event, assuming that to be the case, then obviously she must have had her hand on some sort of glass that night to drink some sort of alcohol, right?
She drank some sort of alcohol. I don't know if she drank it out of a glass
Or a bottle or something.
whatever.
Now, with regard to this wine bottle right here, 16C, I think you said you found an identifiable print belonging to Michael Peterson.
Correct.
And of course, again, you can't tell whether or not it was from December 9th or December 8th or December 7th or some other time.
Correct.
And you found some other prints on here that had rich detail, but not enough to identify, right?
Yes.
Okay. So you don't know whether or not Kathleen Peterson ever touched this bottle.
No.
Or whether anyone else touched it.
No, I don't.
All right. With regard to this bottle, the champagne bottle, somebody obviously touched it because it was empty, right?
Yes.
But you couldn't find any identifiable prints on this one.
Correct.
So on this one, you couldn't tell whether it was Michael Peterson who touched it at some point, or Kathleen Peterson, or both, or someone else.
Correct.
And of course, you didn't find any bloody prints on any of these.
No.
And you didn't see any reports indicating that anyone found any blood or remnants of blood or, indications of blood.
I don't know what they found.
Okay. Now, let me mark. You know what Chambord is?
No, I don't.
You mark this as Defense Exhibit 166. To your knowledge, did anyone seize what's now been marked as Defendant's Exhibit 166 from the Peterson home and give it to you to fingerprint?
I never received it.
Okay. You're aware, are you not, that there was a little bit of reddish liquid in those two glasses,
Yes.
right?
Yes.
And are you aware that that liquid was not seized by anybody?
I didn't know. I don't know.
Okay, well, in any event, so you never saw any report about whether there was any kind of Chambord in that little bottom of the glasses, did you?
I didn't see.
Documentation.
I think she can answer whether she saw it or
I didn't see any other reports from any of the people in the lab.
Okay, I'm sorry. In any event, this was not given to you to fingerprint.
Correct.
All right, let me show you. Do you know whether or not Kathleen Peterson ever put Chambord in her champagne or in her wine, or did anybody give you any information about that?
No.
yes.
Let me show you what's been marked Defendant's Exhibit 167, which is a bottle of cognac. Did anyone ever give you what's been marked Defendant's Exhibit 167 to fingerprint?
No.
If these items had been seized from the house with their glass, right,
Correct.
you would have been able to search them for fingerprints, right?
Yes.
And you might have found prints or you might not.
That's correct.
Now, with regard to that shoe impression, what you have there is a portion of an impression, right?
Correct.
And is it fair to say that what we can tell from that is that the heel of a shoe, likely that shoe, came into contact with that section of pants after that shoe had some blood on the bottom of it?
Correct.
You can't tell exactly how that happened, right?
Right.
Or when it happened.
Correct.
But if, for example, the pants were moving, if Kathleen Peterson's leg was moving when that shoe came into contact with it, you'd tend to get a smear, wouldn't you? Like the edges might be smeared from the movement.
It could be.
Okay. Or alternatively, if Mr. Peterson's foot, or his hand, or that shoe was in movement across that particular area, then again, you might get a smearing of at least the edges, right? Because the movement would create some smearing.
If it did not come straight down on the pants.
Right.
Yes.
But in this instance, there wasn't any smearing around the edges that you could see.
Not that I noticed, no.
So what we can deduce from that is that there wasn't, or likely at least, wasn't any movement going on at the time that impression was made, correct?
All speculation.
Well, she's an expert, Mr. Harvey. She can tell us whether she can answer that question or not.
Over fair?
It was a very clear impression that matched the pattern of the shoe.
Right. And that would tend to indicate, I'm not saying it proves it beyond a reasonable doubt, but it would tend to indicate that there wasn't movement going on when that impression was made.
Not sideways movement, no.
That's all I have. Thank you very much.
Redirect? Yes, sir. All right, you can come down. Listen.
With the North Carolina State Bureau of Investigation, assigned to the crime lab in Raleigh in the molecular genetics section.
Tell us, please, how long have you been employed in that fashion?
Since 1995.
What do you do there at the SBI?
I'm a forensic serologist.
What is that?
A forensic serologist is one who analyzes evidence in a criminal case to try and determine if there's a body fluid present, such as blood, semen, or saliva. We do confirmation tests to confirm that and prepare a report to those results. We also do crime scene analysis. We do blood spatter and luminol interpretation. We have some training in that for crime scene work.
Tell us, please, about your education background.
I have a bachelor's of science degree in medical technology from Northern Illinois University with a biology minor and a chemistry minor. Upon being hired by the Bureau, I also attended some genetics classes, some graduate level classes at North Carolina State University.
And then what did you do after that?
With the Bureau, I went through a training program, an in-house training
What do you
program
mean,
for
what happened?
the serology, or now molecular genetics section, where I was given lectures by a senior analyst to better prepare me for the type of testing that I would be doing, and was given written tests on each of those to make sure that I understood the material. I was also given unknown samples, or unknown to me, and had to identify what body fluid was present on those to make sure that I was doing those procedures correctly. Upon completing all of those testing with 100% accuracy, I was then assigned to a different senior analyst where I completed a case internship program. That case internship program was basically analyzing the evidence that was submitted, and then that senior analyst would reanalyze that evidence to make sure that I was conforming to SBI policy and procedures. I also attended the SBI Academy, which the first half of it would be the BLET, or Basic Law Enforcement Training, where any sworn law enforcement officer in the state of North Carolina has to attend. The last half of that academy was dedicated to SBI policies and procedures.
Tell us, please, have you previously testified as an expert in the field of forensic serology before?
Yes, I have.
Approximately how many times?
Over 50.
Your Honor, I would tender her at this time as an expert in the field of forensic serology. Now, could you explain to the jury, please, what types of tests that you perform at the SBI in order to identify blood or body fluids?
The type of testing for blood would be looking for a stain. Each piece of evidence would be analyzed separately and at different times. The item would be looked at for a stain if I were looking for blood. If that stain is found, then an indicator test, which is called phenolphthalein, would be used to see if that stain could possibly be blood. Now, phenolphthalein doesn't mean that it's definitely blood. There are other things that can cross-react, so we call it an indicator test. If that test is positive, then we do the next step to try and determine if it is of human origin and also of blood. We have a test called Abicard hemotrace that is specific for human hemoglobin. And so that would be the type of testing that would be used to try and identify blood. Semen analysis, again, would have an indicator test, and then the confirmation test is looking under a microscope to try and see sperm or spermatozoa on the glass slide that was prepared from a swab. And then saliva testing is also something we can test for. Amylase is found in very high concentrations in saliva, so we have a test to detect the amount of amylase present on a sample to determine if it might have been from a saliva sample.
Specifically in regards to testing a condom for semen, have you ever tested a condom that you knew, for instance, for a fact that had been used during sexual intercourse but that did not have semen in it?
Check. Over.
What I'm trying to determine is if there's semen or spermatozoa present. If there was no ejaculation, then it would be very common for there not to be any semen or sperm present.
All right, now tell us, please, what were you asked to do in this particular case?
I was submitted numerous items and asked to analyze those items to try and determine blood in most of the pieces of evidence.
Could you tell us what items you received?
I received a sample from the steps, Diet Coke can from the table outside near the patio, a Diet Coke can from the kitchen, 2 wine bottles and 2 wine glasses, a green towel, a knife steel, hair and with fibers and material removed from the Diet Coke can outside, 2 paper towels, an empty bottle of window cleaner, 2 bed sheets, 2 pillowcases, and 1 towel, wood and metal paperweight, and then some swabbings from the stairway wall on the right side and a control swab, swabbing from the couch near the dining area and a control swab, a stain swab from the kitchen cabinet by the wine glasses and a control swab, a mop, a rag, an SBI suspect kit identified to me as collected from Michael Peterson, a pair of khaki colored shorts from Michael Peterson, a pair of white Converse All-Star athletic shoes collected from the crime scene, sweatpants and sweatshirt identified as collected from Kathleen Peterson.
She reminds me of Marcia Gay Harden. She was in, what was the name of that show? For the Love of Todd, which I never watched. I just saw the previews for it. Marcia Gay Harden was on Law and Order SVU, and she was an undercover cop with Olivia was undercover. So help me, Todd. Okay. I knew it was something like that. It was something with Todd. And she talked with a really thick Southern accent. I mean, sound just like her. Talked with a really thick Southern accent in that. And then later on, Olivia found out that she was really a cop. And then every once in a while, she would show up in the show in different undercover roles or whatever. And would cross paths with Olivia, and Olivia would have to like pretend, like she didn't know her and stuff. And then they would get together and talk about the cases. I didn't say Toad, I said Todd. I'm not that Southern. But that's who she reminds me of. And I don't know if that's the actress that you're talking about, because this actress does accents, so it could be the same one. I don't know. I'll have to find a picture of her. So Frida Black is her name. She reminds me of Marcia Gay Harden. And Marcia Gay Harden, and the other guy's last name is Harden, and he reminds me of Daniel Roebuck.
And then I also received a used condom, green towel, victim sexual assault kit from Kathleen Peterson, and a paper with advertisements for videos.
Now, there were several times you referred to terminology that you used, control swab. What does that mean?
Basically, a control swab would be a swab taken near a stain, but in a visibly unstained area, just to use to see if there is some type of interfering material that would show up when doing DNA. So it was controlled to make sure there wasn't anything inherently there previously.
Now, how did you go about performing tests on all these items?
Each item was opened individually, and those tests that I listed earlier were performed on them when the stain was found.
All right. Now, after doing testing on the items, did you actually end up with some results of your examination?
Yes, I did.
First of all, let me hand you some items. Can I folks with? Now, let's look at what we have here and tell us, please, in regards to the analysis that you did and the results that you had. First of all, do you recognize each of these items?
Oh, I know.
Tell us how you recognize them.
I love her.
Yes, I recognize this item. When this case was submitted to the laboratory, a unique case number was assigned to it. That case number is on these tennis shoes. The item number, my initials, and the date that I looked at these shoes are on these tennis shoes.
Now, when did you actually receive the shoes?
January 24th.
Of what year?
2002.
Let's look at the other items.
I recognize these sweatpants. Again, those same 4 identifiers are in the inside band. And January 24th, I received these as well.
Of what year?
Of 2002.
Did you receive the shirt too?
I do not believe I analyzed it, but it was in this bag. So my identifiers are on the inside of the shirt. Again, January 24th, 2002.
January 24th or 29th?
I'm sorry. It's written on the velour. I have to look at mine. January 24th.
All right. This item. Let's see, what's the state's exhibit number on that?
State's Exhibit 14A.
I would
a brown bag containing a Diet Coke can. And those same 4 identifiers are on the bottom of this can. And I analyzed this can on April 3rd, 2002.
How about this tube? First of all, what's the state's exhibit number on that?
State's Exhibit 38A is a sealed cardboard cylinder that I received on December 14th, 2001. And this contains the liquid blood sample from Kathleen Peterson.
All right.
What about that? Let's look at that white box right there. What's the number on that?
State's Exhibit 68 is a suspect evidence collection kit that I received on January 18th, 2002, identified to me as collected from Michael Peterson. Check out the contents.
Yes. What did you do with the contents?
Inside this,
What's rainbow? My mom used to dress me up like a doll. Oh. When I was a kid, I got dressed up like a doll. I was the only girl. I had 3 brothers. So that's why I say Easter Sunday dress, because that's the kind of things I got dressed up in for Easter Sunday. Only I had the matching hat and gloves. So that's why I'm like uber casual, like jeans, t-shirts, no makeup. Because I've done all that crap the first 21 years of my life. I'm done now. Oh, you're only allowed to wear dresses? Oh. Now, there are some dresses that are extremely comfortable. Just the straight dresses that are just, no belt, no nothing, just straight. It's like a long t-shirt. I love those. Unfortunately, I can't wear them right now because I've got a hernia that needs to be repaired. And you'd see it would stick straight out in that dress. I have to wear things that hide it right now. That kind of suck it in. But that's from my weight loss surgery. Everybody, well, I shouldn't say everybody. Everybody that I know personally that has had weight loss surgery has ended up with a hernia. But yeah, oh my God, there used to be these dresses. What was it called? Was it called locking? Oh, yeah, I bet. I remember taking ballet and wearing ballet slippers when I was little. But these dresses, I think it was called locking. It was across the chest, and it was like elastic was sewn through it to make like a crisscross pattern. And it itched. Oh my God, did it itch. I hated those dresses, and my mother loved them. I hated them. Oh my God, they were awful. I still remember the name of the store that sold them. Polly Flanders. Awful dresses.
box were the samples collected from Mr. Peterson, a liquid blood sample, a known saliva sample, pubic hair standard, and a head hair standard. My identifiers were placed on each of those items. The head hair and pubic hair standard were transferred to Trace Evidence Special Agent Jim Gregory for him to do hair analysis. And then the liquid blood sample, blood in its liquid state is not stable, so I prepared a blood stainer, basically taking a small sample of that and putting it on special filter paper and letting it dry. And then that was a sample that was submitted to DNA for determining Michael Peterson's DNA profile.
That next bag, what's the number on that?
State's Exhibit 1A is a brown bag containing numerous other brown bags, brown people.
I'm gonna take this out quick. I don't think they're gonna be right there.
Okay. Again, I can identify these khaki colored shorts. Those same 4 identifiers are on these shorts, and January 24th, 2002 is when I initially analyzed these. State's Exhibit 44A is a manila envelope containing other manila envelopes.
Okay, now as far as the contents of this particular envelope,
Are there some things in there that you actually produced yourself after testing the items?
Yes, there are.
Is there anything in this particular envelope that came from the police department or elsewhere that caused you to test that particular item?
Yes, there are.
Okay, tell us about it.
State's Exhibit 85H is a sealed envelope, and this contains the blood swab from the couch and the control swabs. State's Exhibit 85I is a brown paper bag that contains the swabs from underneath the wine glasses. And State's Exhibit 85G is the envelope that contained the swabs from the stairwell. So those were all submitted to me in this packaging.
All right, any other items within this particular envelope that were submitted to you for your testing?
No, the rest of them I repackaged.
Okay, for other analysis.
For further analysis.
Okay, well, let's set those aside just for a moment and let's talk about the testing. First of all, you've read aloud a number of items that you were asked to test. First of all, let's talk about any items where there was a negative result.
Examination of one of the wine bottles, a towel, the knife steel, the paper towels, the window cleaner, the paperweight, the mop, and the rag failed to reveal the presence of blood.
Now, how did you go about testing it, those types of items?
Those items would have been looked at visually, and then a phenolphthalein or an indicator test would have been done. The phenolphthalein test is a small filter paper that's folded, and you take a rubbing or basically cover the surface area of whatever item you're testing, and then you place 3 separate chemicals one at a time and wait for a color change. If there's a color change in 5 seconds, then there's an indication or a positive result. If there's no color change within 5 seconds, then that's negative.
All right, so all those turned out to be negative.
Yes, ma'am.
All right, tell us about any further analysis that you did of the towels and the bed linens that were submitted to you.
The towels, both sets of towels, and the bed linens were also analyzed for semen, and there was no semen stains found on those.
Now, how do you analyze things like that for semen?
The semen analysis would be using an acid phosphatase test, which is an indicator test. Acid phosphatase is found in really high concentrations in semen, but it can also be found in other body fluids. So we use this again as an indicator test. Several cuttings were taken from the green towel and tested, and were all negative. Several, let's see, the yellow towel and the fitted sheet and the flat sheet were all again tested with that indicator test, and there was no indication for the presence of semen on those samples.
Now, you've mentioned the word cuttings. Why is it that you take cuttings from items like this?
An acid phosphatase.
See, I was just going to say, if they take cuttings, because, if you watch Forensic Files, you know how they do the DNA testing and stuff, right? They take a cutting and then they put it in a solution that dissolves the cutting, and then they take the dissolved material and then they test that. What if they pick an area of the bed? Because when semen dries, it's clear, right? I mean, you can kind of see where it was, but blood's different. You can see blood. But a semen stain is not so easy to see. So what if they took the wrong cutting, like got the wrong area of the sheet? So it came back negative. That's because there wasn't anything there because they took the wrong part of the sheet. How is that telling them anything. I guess I should keep listening because maybe she'll explain that. Is there not a way to test the entire sheet? Because who knows? Maybe they don't. I mean, is there like a particular area of the sheet that they say this is possibly where the semen's going to be? I mean, maybe somebody's inventive and the semen's not in the regular area it should be. I don't know. Well, yeah, that's true too. Could be sweat, could be lubricant, could be who knows what.
Test actually has to use a sample of the sheet or of the towels. So a small cutting, less than 1 centimeter square or very small, is cut and removed and actual reagents applied to that material in order to see this color change for the acid phosphatase or indicator test.
In making the cuttings from any of the items that you tested, did you significantly alter any of the items?
Significantly, no, I wouldn't say significantly altered.
What size would the cuttings be?
Slightly smaller than 1 centimeter square.
All right, now, did you do a visual examination of the wine bottle and the wine glass?
Yes, I did.
For what purpose?
They were submitted to me for blood analysis. I looked at the sparkling wine California Brew Classic bottle, and it had stains on it, but those stains were phenolphthalein negative. The Italian wine bottle had no apparent red stains. Both of these bottles were requested for latent examination. If I were to have swabbed the entire bottle with the phenolphthalein, I could have destroyed some of that evidence. So I did a visual examination on these, looking for a reddish colored stain. Then I also looked at the glasses, and again, there were no apparent red stains on either one of these glasses.
With that in mind then, and knowing that they were to go to another section, did you do further testing on them?
No, I did not.
Tell us about a visual examination that you did on the pillowcase.
The pillowcases were looked at, and there were no semen-like stains, and so I didn't actually make cuttings to do acid phosphatase testing from the pillowcases, so there was no visual stains on those pillowcases.
Now, were there some items that you did not analyze that were submitted to you?
Yes.
What items were those?
The sample from the steps, the victim's shirt, and the control swabs that were contained with the swabbings from the stairwell, underneath the wine glass, and the couch.
Any others?
The liquid blood sample, blood stains, and saliva samples that were sent in the kit, there wasn't any actual analysis on any of those items either.
And why was that?
The blood stains and saliva sample are submitted as standards.
Urine glows under a black light too. Other things glow under a black light.
For DNA, and the DNA analyst would be the ones that would actually do analysis on those samples.
Now, based on your examination and the results of your examination, were there some items that did reveal the presence of human blood?
Yes, there were.
What items were those?
Examination of the khaki shorts, the Converse athletic shoes, the 2 Diet Coke cans, the shoe print on the victim's sweatpants, and the swabs from the stairwell, couch, and underneath the wine glass.
I'm going to object. There's a continuing reference to underneath the wine glasses, and I don't think that's where that swab came from. I think she's talking about the swab from the cabinet, and I just want to be clear about that.
I couldn't really tell you where she's getting that information within her report, but I would agree that it's from the cabinet.
By the wine glasses. I apologize.
All right. Now, first of all, let's talk about the shorts. Do you have those there?
Yes, I do.
You pull those out, please.
Yes.
May I approach? May she step down for the jury?
Yes.
Come down to it, Agent Barker. And using those shorts, could you show the jury specifically where you tested those shorts and found the presence of human blood?
These shorts, I just made a note that the front was basically covered and no analysis was done on the front. On the back of the shorts, there was a staining pattern that appeared spatter-like on the seat. And here, I removed a sample of this, first tested it for phenolphthalein, and then did the human blood testing, and then removed that for DNA testing.
Now, did you actually cut that little hole in there?
Yes, I did.
All right, let's come down and show the other half of the jury again, what we're talking about.
So again, this was the pattern that I observed, and there was another stain here, and that's the same that I tested and cut for further testing.
All right, let's cut those shorts up. Let's move on to, you mentioned something about cans. You have one of the Diet Coke cans up here. It's the can, it should have a sticker on the wall. Is there a label on the can?
States Exhibit 14.
All right. Do you remember where on that can that you tested for the presence of human blood?
Yes, I do.
All right, if you could stand before the jury, Mashi,
So,
and stand before the jury and point to them specifically as best your notes reflect where you tested that can. You may take them with you. It's fresh now.
States Exhibit 14, the Diet Coke can from the table outside near the patio had a stain. Here, you can see where I've circled. There's just it's hard with the other circles there, but there's a circle drawn here, and there's a circle drawn here. And at the bottom of the can, there's a circle here, and a circle here right by the label. Those were the 5 areas that I swabbed to remove the stain that was there, and tested that swab, and it was positive, and then tested that for human blood. Again, it was positive, and sent that swab for DNA testing rather than the can, just what I removed on that can.
So now, when you removed those stains from the can, had you already made a determination in your expert opinion that those stains were most likely going to be blood of some kind?
Each of the 5 stains were tested with the indicator test, the phenolphthalein. Then I removed them, combined them all together, and then did a testing of that swab to determine that it was human blood.
Okay, if you could now, let's go to this half of the jury and show them as best you can where those circled areas are.
1, 2, 3, 4, 5 right here.
Now, did you test anywhere the mouth area that came?
Yes.
A person might drink from.
We I swabbed in the region where it might have come in contact with lips or tongue to try and determine who might have been drinking from this can. So it was just. Pardon?
I'm sorry. What were your results when you swabbed them?
I just swabbed and it wasn't tested any further. To conserve basically anything that would be there would be epithelials, which is just the skin or outside layer, and we don't have a test to confirm the presence of epithelials.
Now let's move on to the tennis shoes. May she step down to display them? Just get ready. Take a good look at those. Did you test both tennis shoes?
I only tested the left, I think. Left shoe.
Why is that?
There was a pattern identified elsewhere that the left shoe became important, and so a swabbing of the left shoe to try and identify whose blood might be on the bottom of that left shoe was important.
So you all made a decision there within the state board investigation as far as which shoe you test for certain purposes.
Yes, ma'am. I'm sorry. Final number 16.
Connie?
Yes.
All right, let's take that shoe out if you would when you get ready and show the jury where on the shoe you tested.
This shoe on the bottom sole in areas that are in these two crevices, and then in between the sole and print, I took swabbings from that area, from those areas. First of all, identified that the red areas were indeed phenolphthalein positive, then removed a sample of that and tested that, and it was human blood. And then that swabbing was sent for DNA testing.
Now, Agent Parker, I want you to come on down here and make sure all these jurors have seen what you're talking about, please.
In this area here and in between here.
Now, how do you go about taking swabbing from an item like that?
Cotton sterile swab is slightly moistened and then swabbed in that area where the stain is, and the stain will then be on the swab. The swab's dried down and placed into its own envelope, sealed up so that it's never in contact with another type stain.
You kind of like a Q-tip?
Yes, it's basically like a Q-tip.
All right. Let's put that item up then. Now, you mentioned earlier that you had also tested on the other swabs. Could you tell us about that before we go further?
There was swabs submitted to me as collected under the wine glass cabinet in the kitchen. Another set of swabs collected from the couch, and a set of swabs from the right wall of the stairs, 7 steps up from the bottom. These swabbings were collected and identified as all containing an indication for the presence of human blood on the swabs collected, and the control swabs for each of those areas were not tested.
Now, which items are you speaking of there?
Takes Exhibit 85I.
I moved to introduce 85I and its contents and evidence.
So,
85H, is that one of them?
Yes, ma'am.
I moved to introduce 85H and the contents and the evidence.
so,
You've handed me 85G, is that one?
Yes, ma'am.
I moved to introduce 85G and the contents and the evidence.
so,
Just fill out of one of those.
This one.
I think it's this one. Yes, ma'am.
Yeah, 85I has contents. What else? Though?
Yeah. Swab paper.
Now, are these all the swabs that you analyzed?
Those are the swabs that were sent to me as swabs.
Right.
Yes, ma'am.
And you found human blood on all of these?
An indication for human blood on each of those.
All right, now, let's look then at 32. And let me make sure I understand you. You did not test Mrs. Peterson's sweatshirt?
No.
Was there a reason for that?
Our policy is not to analyze victims' clothing, especially if they've been bleeding a lot, unless there's an indication for a second bleeder. And I was given information that there was no indication of a second bleeder, and this sweatshirt was saturated.
All right, then you did process the sweatpants.
Yes, ma'am.
All right, let's look at that one more carefully. Next, you step before the jury.
so,
All right, let's take State's Exhibit 32 and show the jury what area of those sweatpants that you tested.
State's Exhibit 32 were sweatpants submitted as identified as collected from Kathleen Peterson. There was a track impression left on these sweatpants. I couldn't.
Did you cut a hole in that?
Oh, I thought I did. No, I didn't. I just swabbed. I didn't actually make a hole. I swabbed in this area right below this imprint here in this darker stain to try and determine if this was human blood that was in this stain. And it was human blood on at this stain, but I didn't actually make a cutting.
How can you be sure that that's the stain that you tested?
For my drawing, there is a drawing and showing this mark imprint on my drawing, and then my marking is right below that for the sample or the area that I tested for.
All right, let's move down here to make sure these two are solid.
I recognize this marking and I tested from this area, so it's not to disturb the marking, but something closely associated with that marking.
Thank you. Thank you, sir. Now, did you also test a material that had come from some hairs? Item 30 specifically.
Yes, I did.
Tell us about that.
There was an envelope that had a napkin folded up. Inside of it, I found a few hairs with, they were all in a knot, and there was some purple and red fibers and material caught up. And I tested that and determined that it was phenolphthalein positive, but there was very little sample, and so I didn't do any further testing than that indicator test.
Now, Agent Barker, after you completed, first of all, was what you told the jury thus far, does that pretty much sum up what you did with each of the items of evidence? The ones that we've spoken of at length?
Yes,
Okay. Now, you did test a condom in this case, and that came back negative. Is that right?
that's correct.
You tested for semen?
Yes, I did.
Did you test it for blood? For the presence of blood?
No, I did not.
All right. Now, after you finished your testing, what then did you do?
For the items that would be needing to go to DNA, I prepared samples of or swabbings or cuttings from different items, placed them into sealed manila envelopes, and prepared them for the DNA analyst, who was Special Agent Mark Baudet, to do DNA testing to determine the DNA profile on each of those items.
Now, why do you all go about doing it that way?
We found that it is easier and makes the case go faster. That way, one person is dealing with the bulk evidence, and the other person is dealing with just the DNA analysis. And we found that thus far, with only 10 agents to cover the entire state, that it works the cases through the fastest.
So, what different items did you send to different places for further testing?
I sent the khaki shorts to Special Agent Bendur.
Now, what type of work he did?
Special Agent Bendur works in the trace evidence section. He does. He has various job duties. He GSR.
What is GSR?
Gunshot residue testing.
Right.
He does paint chip analysis, and he also works with a scanning electron microscope.
All right. What else did you send into him?
I transferred the sample from the step and the hair standards from Michael Peterson to Special Agent Jim Gregory for hair analysis. I transferred the shoes and the sweatpants and sweatshirts from Kathleen Peterson to Special Agent Joyce Petska of the Latent Evidence section. And I transferred Kathleen Peterson's bloodstain, 3 separate cuttings from the khaki shorts from Michael Peterson, swabbing from the sole of the white tennis shoes, 2 swabbings from the Diet Coke can on the patio, 1 from the mouth area, and then 1 in the positive phenolphthalein areas. 2 swabbings from the Diet Coke can from the kitchen. Again, the blood on it was swabbed on 1 swab, and then again from the mouth area, that area was swabbed to try and figure out who might have been drinking from it. The swab from the stairwell and control swabs. The swabs from the couch near the dining area and control swabs. The swab from the kitchen cabinet by the wine glasses and control swabs. And the blood stain from Michael Peterson.
Where did you send all those?
Were transferred to Special Agent Mark Baudet of the DNA unit in the molecular genetics section.
Now, you previously testified that there were some items that you actually sort of had to create or produce in order for him then to do DNA analysis. Is that correct?
That's correct.
And those are within the envelope that we have not yet gone all the way through. Is that right?
Yes, ma'am.
Madam Clerk, those ones that you created. Would please. Created all of these?
Yes, ma'am.
Take a look through these and make sure that you're satisfied that you've had them, that you created them, that they're the ones you sent to DNA lab.
Yes, I recognize each of these envelopes. They all have those 4 identifiers, the unique case number, the item number, the date I prepared them, and my initials on each envelope.
Okay. Yes, 85.
85-1.
And now, taking each of these items out of an envelope that's now been marked 85-1.
Yes, I recognize this.
Okay. Now, Your Honor, I move to introduce State's Exhibit 85-1, 85A, 85B, 85C1, 85C2, 85C3, 85D1, 85D2, 85E1, 85E2, 85F1, and 85F2. Indictments.
So,
Thank you. Now, beginning with 85A, let's identify each of those numbers.
State's Exhibit 85A is a sealed envelope that contains the blood stain that I prepared from the liquid blood sample, State's Exhibit 38A, from Kathleen Peterson. Yes.
Okay.
Sorry. State's Exhibit 85B is a sealed envelope containing the blood stain that I prepared from the liquid blood sample identified to me as collected from Michael Peterson in State's Exhibit 68.
Now, each of these, do we find your handwriting and the date and your initials?
Yes, ma'am. State's Exhibit 85C1 is the cutting from the shorts in the seat area that I identified, the large cutting from the seat. That State's Exhibit 85C1. Again, my identifiers are on the outside of this.
Next.
State's Exhibit 85C2 and 85C3 are the small holes that were just to the right of that larger stain that was removed. 2 more stains that were removed from the shorts in the seat area. State's Exhibit 85D1 is the swabbing from the bottom of the white tennis shoes, the areas that I pointed out. That would be State's Exhibit 85D1, the sealed manila envelope. State's Exhibit 85D2 is a cutting from the inner heel area from that same left shoe. State's Exhibit. I'm sorry. 3B. State's Exhibit 85E1 is the swabbing from the mouth area of the Diet Coke can that was on the outside patio table. State's Exhibit 85E2 is a sealed envelope with the swabbing from the blood stains in the 5 different places on the Diet Coke can on the outside patio table. State's Exhibit 85F1 is a sealed envelope containing the swabbing from the mouth area of the Diet Coke can from the kitchen. And State's Exhibit 85F2 is a sealed envelope containing the swabbing of the blood stains on the Diet Coke can from the kitchen.
All right, then you packaged each of them in 85-1 and sent them to the DNA lab.
Actually, I placed them in that envelope unsealed, and Special Agent Baudet actually came into my office and received them in person and doing a transfer on our computer system to his possession.
So these are his initials?
Yes.
Okay, now, did you prepare a report of your findings in the case?
Yes, I did.
I'll show you what is the North States Exhibit 102. Do you recognize it?
Yes, I do.
What is it?
This is a copy of the report that I generated in this case.
And did you sign it after you made sure that it was accurate?
My signature is at the bottom of this report.
I moved it to States Exhibit 102 into evidence.
So,
No further questions?
Stephanie, let's take a 10-minute break, please. All right, Mr. Rudolph.
Yes, sir. Good afternoon, Ms. Parker.
Good afternoon.
We just met over the break, but I represent Mr. Peterson, as you know.
Correct.
My name's Dave Rudolph. Just so I'm clear about how the SBI lab is organized, there are various sections that various agents are assigned to, correct?
That's correct.
So, for example, you're in the serology section.
Correct.
That's also the section that Agent Deaver is in?
No.
Okay, what section is he in?
Special Agent Deaver is a field agent assigned to DECU, but he used to work in my section, and that's when he developed the expertise that he has now.
Okay, what is DECU?
Diversion and Environmental Crimes Unit.
Okay. So he's not actually assigned to serology anymore?
No, he's not.
All right. And how long has it been since he was assigned to serology?
I believe he left serology in 1995, but he did not stop doing blood spatter interpretation at that time.
I see. So he learned blood spatter interpretation as in the serology section,
That's correct.
but then continued to do it even after he left the section.
That's correct.
And are there other agents there in the serology section who do blood spatter interpretation?
Most of the agents that have the expertise for reconstruction are no longer in our section. We are just starting to train a new group.
Okay. But in other words, there's others besides Agent Deaver. They're just not in the section either.
I believe there are 4 in the state
Okay.
assigned to the SBI.
Okay. For example, when you found the shoe print on that pants,
Yes,
sweatpants, that wasn't something that you would compare to the actual shoe because that's outside your area of expertise.
that's correct. Outside.
You would send that to Miss Agent Pretzka.
Agent Petsko would be the footwear impression analyst.
Okay.
Yes.
Now, what is within your area of expertise are things like presumptive testing, right?
For blood.
And
Yes.
or semen
And semen.
or other bodily fluids.
Yes.
All right. And luminol.
Yes, we do luminol.
All right. And does the SBI actually go out and help local police agencies do luminol spraying?
We have a crime lab, and then we have the field division. Within the field division, there are mobile lab operators that are assigned to districts, and they receive training from the crime lab on how to do luminols. And if requested through the district special agent in charge, then a mobile lab operator would respond to a crime scene to assist.
So, for example, in this particular case, had Mr. Campen or Mr. George requested some help from the SBI with regard to luminol spraying, that could have been provided.
That could have been provided.
All right. And indeed, with regard to presumptive testing and just sort of helping them process the scene, SBI would help with that as well if requested, correct?
SBI is an assisting agency. That's our goal. Yes, sir.
So, for example, if you were home on Sunday, December 9th, 2001, but Mr. Campen or Mr. George wanted your help in testing presumptively with phenolphthalein or any of these other things you use, you could have come out of whatever you were doing and come out to the house, right?
There is someone from my section assigned to be on call 24/7, so there was someone on call that night, yes.
All right. But to your knowledge, no one requested any assistance at that point from the SBI?
They requested blood spatter interpretation.
Yes, but nothing else?
That's correct.
And for example, when you go to a scene, you do diagrams, right?
Yes.
Indeed, I noticed in your notes that you do diagrams even in the lab.
Yes, we do.
So, for example, if you examine a pair of shorts, even though you have custody of them, you're still going to do a diagram and show where you took the sample from and that sort of thing.
That so when I'm on the stand, I can better testify to it. Yes,
Exactly.
I would have a diagram.
So that you have a contemporaneous record of what you did.
That's correct.
And that's the real value of doing diagrams.
That's why I make the drawings.
Okay. And that's something that you as a trained agent have been trained to do as part of how you ought to function?
That's correct.
Same thing with luminol, right? I mean, if you spray luminol and you see some reactions, you're trained to do diagrams about that, correct?
Typically, with our luminol examination, it's when we're doing luminol, it's more of an investigative aid. So we would take notes where we saw it, and we would have a general sketch, outline of the scene, and like place numbers, make reference to what we saw, but we don't really make, we wouldn't sketch out the markings.
Well, indeed, lots of times you can't really get a distinct pattern from the luminol, right?
Correct.
Because it's a luminescence, you don't get that distinct an outline, right?
Right. There's a glowing area, and we would do that testing, but
Right.
We don't actually make a straight drawing of what we saw.
Right. What you would do is do a rough sketch showing here's where we saw some reactions.
Correct.
Okay. And you wouldn't do that 16 months after the fact, would you?
Not typically, no.
All right. Now, with regard to the testing you did do, I noticed, for example, that you got some specific requests from the Durham Police Department, right?
When we receive the evidence, as the evidence comes in, there will be a cover sheet, basically a request for physical examination. So they would detail what was needed.
May I approach you?
Yes.
Let me show you what I've marked as Defense Exhibit 168, if I could, and ask you if you recognize that package.
Yes, I do recognize this.
All right, and what is that exhibit?
Defendant's Exhibit 168 is a complete copy of all my notes, the SBI 5s, and the report that I generated in this case.
And it would include things such as the diagrams that you did of the various items of clothing.
Yes, it does.
And it also includes something that's called a request for examination of physical evidence, correct?
That's correct.
With regard, if you could turn to the fourth page of that exhibit. It's a request for examination of physical evidence from the Durham Police Department. Do you see that?
Which page of,
The
there's
fourth
3
one-
pages.
The fourth one
Okay.
of the exhibit.
Yes.
It's the one that reads, wine glasses appeared to have been taken out of cabinet after incident. See that?
Yes, I do.
So that was submitted to you to determine whether or not somehow after Ms. Peterson was already lying there, someone had taken out those glasses and laid them on the counter. Is that right?
The request for that item, which is, wait a minute, what's, is for trace DNA and fingerprints. So the item 16, the wine bottles and wine glasses, were trying to determine if someone had handled them, if someone had drank out of them, and if there was any trace evidence left on them.
Right. And in particular, of course, they were being looked at for blood.
Right.
And there was no indication that you were able to find of any blood on either the glasses or the bottles.
That's correct.
I think you said that there were a number of negative findings that you had as a result of your examination, right?
That's correct.
And just so we're all clear, by negative finding, what we mean is that you look for any indication of blood, either presumptively or otherwise, and saw none.
The ones that I reported as negative for blood were actually, and the entire area was swabbed with the indicator test.
Right.
The only things that were not tested that way were the one of the wine bottles and 2 of the wine glasses that I only did visual so as not to destroy any latent fingerprints that might be there.
Okay. And again, just so we're clear, there was no indication of any blood on the 1 wine bottle that you did test.
That's correct.
There were no visual indications or stains on the wine bottle and the 2 glasses that you didn't actually test with phenolphthalein.
That's correct.
There was no indicators of blood on the towel, the paper towel.
That's correct.
There were no indications of any kind of blood or blood residue on the bottle of window cleaner.
That's correct.
And then a mop and a rag were taken as well, right?
That's correct.
And with regard to that one, if you look at the next page of the request for examination of physical evidence, Coach Warner?
Yes, sir.
That deals with why they were asking you to look at the mop and the rag, right?
That's correct.
And whoever wrote this, do you know who wrote this out?
No, I do not. No, I don't.
Somebody from Durham Police Department.
Yes.
And whoever wrote it out indicated quote, 66 and 67, that's the mop and the paper towel, right?
I believe it was a rag. I
Rag,
called it a
I'm
rag.
sorry.
I'm sorry.
I'm going to object to him trying to elicit hearsay from this witness. She says she doesn't know who prepared the document.
Doesn't matter, that's not what he is. That was the last question. It's over.
Thanks. What they were asking you to do is, what they told you was the mop and that rag, quote, may have been used to attempt to clean up crime scene, right?
That's what this paper says. Yes,
Right,
sir.
and that's why they were giving it to you to analyze.
That's correct.
And what you found was that apparently was not accurate, right?
Objection.
Well, let me rephrase it. I'll rephrase it. You found no indications of blood in the mop or the rag.
That's correct. When I tested the mop and the rag, they were negative for blood.
And they also gave you some things that they at least apparently considered might have been used as a weapon, right?
That's correct.
For example, a knife or a knife sharpener.
A knife sharpener, a knife steel.
All right. And they asked you to test that for any indicators of blood,
Correct.
and there was none.
It was negative.
They gave you a paperweight,
Correct.
asked you to test that for indicators of blood.
Correct.
That was negative.
It was negative.
You were never presented with any kind of a weapon or item on which blood was found in terms of it being a weapon of some sort, correct?
I never received anything like a weapon. No.
That's all I have. Thank you very much.
Redirect.
Special Agent Parker, you were asked by Mr. Rudolph about luminol testing. Tell us, please, what type of training have you had in that particular field?
I am a trained analyst able to conduct luminol testing. I actually teach it to the new agents as they come through the Bureau and teach it to the new agents within my section. So I teach it to most of the new agents as they come through for the last 4 years.
So you've been actually teaching that subject matter for 4 years,
That's correct.
and that's at the State Bureau of Investigation,
Yes, ma'am.
an agency that services the 100 counties of North Carolina. Is that right?
That's correct.
Tell us, please, in teaching luminol to your students and even in performing that test yourself, do you photograph them?
We teach how to photograph. Photographing luminol is different in that you're trying to photograph something that is glowing in the dark. So exposure, or basically getting that image captured, is very difficult. So technically we teach how to do it, but the type of information that you would get from a luminol examination is basically as an investigative lead. If you have something like a footwear impression or some type of impression that needs to have microscopic detail, to try and do some type of comparison, you wouldn't use luminol. In order to photograph that, you have to continue to spray that chemical on that to keep generating that light, and that will destroy that marking because it will start to run. The image will run. And so typically we do not photograph luminols.
How about videotaping? Do you videotape it?
Again, videotaping a luminol, in order to do a luminol, it has to be completely dark. And so you're on night vision, and it is very difficult. And I've been on numerous scenes, and I've never videotaped a luminol.
If you had been the one on call on December 9th of 2001 to come into that household on Cedar Street and do luminol testing, would you have photographed it?
No, I would not have.
Would you have videotaped?
No, I would not have.
Would that be for the reasons you've just stated for this jury?
Same reasons.
No further questions.
Let's talk a little bit about photographing luminol. You have photographed luminol, haven't you?
I've been trained how to photograph luminol.
Have you ever done that?
I've never done it at a scene.
And is the reason you've never done it at a scene because normally when you get a luminol reaction, it's sort of a fuzzy reaction?
most of the time when we're doing a luminol examination, we're looking for investigative leads, like where someone might have walked.
Right.
If we find an impression that appears to be a shoe or something that we stop at that point and let someone process that with a different type of chemical.
Oh, what do they process it with?
It would be through the latent evidence could process with Kamasi Blow or Amido Black if there was the type of detail to actually make that print if it were necessary. But again, it would be an imprint that might be important, such as one walking out the door or one different than the persons that have been at the scene.
Explain to me how that other processing works. I mean, what do you do?
That would be through latent evidence examiner, and I'm not, all I know is I stop and I turn it over to someone else.
So, for example, this would be, I'm now showing you Defense Exhibit 116. That would be a photograph of luminol reactions, right?
Typically, it is a dark picture. The ones that we are, all of this background would be dark. They've done some other type of photographic exposure to get both of this in the light and that chemiluminescence. So I personally have never done photography like this for luminol nor been trained.
It certainly can be done.
Yes, I have read one paper on it.
Okay. In other words, the kind of luminol photography that you're used to seeing would be let me show you what's been previously marked with Defense Exhibit 117. And I think the jury can see it. See this sort of photograph over here?
Yes.
That's the kind of photograph you normally would get in luminol.
That would be a very good photograph as far as getting a good reaction. That's
Right.
not typical.
Or, for example, that one there.
Yes, that's looking more similar to what we would typically see.
And that's sort of the level of detail you normally get, right?
Yeah, very
If
little
that.
detail, very little.
And normally when you spray luminol, you don't get like 75 or 100 feet worth of steps, do you?
Typically, no, unless it's been contaminated. Like we've seen a lot of animals run through the blood. You know, if the so a lot of paw prints, and occasionally where someone is, even an officer has walked through an area, not realize that, and walked through the area, and so those usually are our best prints.
Right. Because normally what happens is with either blood or luminol, as somebody's walking, it gets fainter and fainter and fainter, right?
That's correct.
Until gradually what you see are maybe like little smears, right?
Correct.
And then it just disappears.
Right. The concentration would go down as that blood is left as the person continues to walk away.
So as the person walks, for example, you're not going to see the same exact pattern all the way through. You're going to see less and less and less and less. Right?
Eventually, as the concentration gets smaller, it should get less. It all depends on the concentration or the amount of blood left, because luminol detects 1 drop of blood in 1,000,000 drops of water. That's very sensitive.
Right. And what's the in terms of a trail of luminol footprints, do you have any idea what the longest trail you've ever seen of luminol?
No, I do not.
Print?
I don't recall.
More than 10 feet?
The amount would be how bloody those feet were as they left. If they were soaking, you're going to see visible prints initially, and then eventually the amount of blood left on the soles will get to a point that the concentration will not be to the point that a luminol will be able to detect.
From the time you no longer see visible prints until the time the luminol stuff sort of fades out so you really can't see footprints at all, What's the longest? Maybe 10 feet, 15 feet?
I don't know. I don't know.
No further questions.
Anything else?
A little bit,
How much?
just one.
All right.
Special Agent Officer, that I make sure that I understand. Mr. Rudolph is showing you Defendant's Exhibit 116, which is your testimony that this is not an accurate depiction of luminol testing.
You would not see luminol chemiluminescence and be able to see the floor and all the appliances in the room. It has to be completely dark in order to see a luminol reaction.
That's all I have to.
Anything else, Mr. Rudolph? Anything else?
Was that a no?
No, sir.
No. You can come down.
State your name, please.
My name is Mark Truman Baudet.
Spell your last name, please.
My last name is spelled Boodee.
How are you employed, sir?
I'm employed as a special agent with the State Bureau of Investigation, assigned to the DNA unit of the crime laboratory.
Could you give us a brief description of your job, please?
My job basically is to accept blood and other body fluids, to perform a forensic DNA test on that evidence, to write a report based on my analysis, and then to testify in court like I am today.
What is your educational background?
I received my bachelor's degree in biology from the University of Virginia in 1986. I then received my master's degree in forensic sciences from George Washington University in Washington, D.C. in 1989. I've also taken additional graduate level coursework in molecular genetics through North Carolina State University.
All right, what training and experience have you had in forensic DNA analysis?
Before I came to the State Bureau of Investigation, I worked for a company called Cellmark
We'd be
Diagnostics.
happy to stipulate that Agent Baudet is the expert in DNA if it'll speed things up. Ms. Black?
I would tender him as an expert in forensic DNA analysis.
So,
Now, Special Agent Baudet, did you bring some charts to educate us a little bit about DNA?
Is he seriously complaining about the speed of this trial? Oh my God.
And DNA analysis.
Yes, ma'am, I did.
May I approach the witness?
yes.
You need some help?
May you step down?
Yes.
Just for the record also, I've gotten these reports and I'm happy again to stipulate to the admission of the reports and the conclusions in the reports. We're not disputing any of the DNA evidence in this case.
Sure, I appreciate that. I would like you to be able to explain it to the jury.
All right. Well, you can accept it and he can still testify.
Ooh, I like that dress too. That's beautiful.
Yes, well, I'm eventually going to make a report in evidence.
So,
Thank you. First of all, we're going to use D12. With this exhibit then, tell us, what is DNA?
DNA is a chemical which is found in the cells of every living creature. It's found in plants and animals and viruses and bacteria. And inside of those living creatures is found only in those cells which contain a nucleus. Inside of those cells, DNA is spread out across 46 of what are called chromosomes. These chromosomes pair up to form 23 pairs of chromosomes. And basically what DNA is a genetic blueprint for you as a creature. It determines not only your physical structure, but also your chemical structure as well. It determines not only whether you're going to be a plant or an animal.
Have a nice nap, everybody.
A dog, a cat, or a human, but also the chemicals which are found inside of your blood, found inside of your semen, other bodily fluids like that. As I said a minute ago, DNA takes the shape of what's known as a chromosome and forms 23 pairs of chromosomes, half of which are said to come from one parent.
All right, you now are showing us D14.
That's correct.
All right, you make a 10.
Half of your DNA comes from one parent, and half of your DNA comes from the other parent. Half of your DNA comes from your mother, half of your DNA comes from your father. These 46 chromosomes again pair up. You have 22 of what are called bodily chromosomes, and then you have one pair of sex chromosomes to determine whether or not you're going to be a human, whether you're going to be a male, or whether you're going to be a female. Two most important things to remember about DNA. First of all, is that DNA is going to be the same throughout your entire lifetime. And only you are going to have that DNA. Everyone's DNA is different. My DNA is going to be different than your DNA. Your DNA is going to be different than the next person's DNA. The only two people who are going to have exactly the same DNA are going to be identical twins. Second of all, your DNA is going to remain the same throughout your body, throughout your lifetime.
You have another diagram here.
Yes, ma'am.
Let's refer then to D.
D13 is a diagram of a DNA molecule. And DNA in every living creature looks like a ladder which has been twisted to form a spiral staircase. The outside of the ladder is formed of interspersed sequences of sugars and phosphate groups. However, the most important part of DNA are going to be the rungs of the ladder. These rungs are made up of what are called nucleotide base pairs. Nucleotide bases are adenine, thymine, guanine, and cytosine. These four different nucleotide bases pair up to form what would look like rungs on a ladder, and what we can use to measure different sequences of DNA. For instance, this sequence of DNA might be approximately 17 nucleotide base pairs in length. The different sequences of DNA code for different things. You have a sequence that codes for your hair color, a sequence that codes for your eye color, for your skin color, things like that. Different sequences which code for things are called genes. In between genes, there are sequences which don't code for anything at all. These sequences of DNA are called non-coding DNA or junk DNA. And very often, they're very variable in length from one person to the next. Oftentimes, they're repeated like beads on a string. So these non-coded sequences, in me, they might be repeated 50 times side by side. Another person maybe 10 times side by side. Another person maybe 150 times. So what I do as a forensic DNA analyst is I measure these repeated sequences of DNA, and I compare them from question items, compare them back to known standards from victims, suspects, other people associated with a crime.
All right, and how long have you been engaged in this type of activity with SBL?
Since 1990.
Thank you. Your Honor, at this time I would move to introduce State's Exhibits D12, 13, and 14 and other. Now, Special Agent Baudet, were you asked to analyze some items with this?
Yes, ma'am, I was.
When did you receive that request?
I received the evidence from Special Agent Susie Barker on April the 10th, 2002.
What were you asked to do?
I was asked to perform a forensic DNA analysis on this.
On what items?
On our item numbers 6-1, 14-1, 14-2, 14-3, 16-2, 16-3, 24-1, 24-2, 25-1, 25-2, 37, 40, 41, 47-2, and then on May the 7th of 2002, I received from Special Agent Jim Gregory a root of a hair that was collected, and that was item 42-1.
All right, may I approach the witness? I'll show you an envelope that's marked 44A. Tell me if you recognize any of the contents of that.
I recognize, excuse me, I recognize State's Exhibit 44A.
How?
By the markings that are on the outside. Whenever we get a case, whenever we send back evidence, we not only put the case number on there, but also our initials plus the date of when we receive it and when it's sent back out as well.
All right, so you recognize the outer envelope.
That's correct.
Let's look at the contents, see if you recognize any of those items.
Yes, ma'am, I do.
What do you recognize?
It's a manila envelope, a container package, again, which has the case number, my initials, and the date on it, as well as a number of different coin envelopes.
All right, now what is the State's Exhibit sticker number on there?
On this manila envelope, the state's exhibit is 85-1.
All right.
Inside of 85-1 is our item 6-1, 47-2, 14-1, 14-2, 14-3, 16-2, 16-3, 24-1, 24-2, 25-1, 25-2.
And how do you recognize each of those?
Again, each item has the case number, the item number, my initials, and the date that I received them on there. On the back side is my seal, where I have sealed it with tape, my initials, as well as the date in which I made that seal.
Okay, let's look at the rest of the items then. Do you recognize any of them?
You will stipulate to the chain of custody on these items.
Okay. Your Honor, at this time I would move to introduce the entire contents of the envelope that has been marked 44A.
So,
All right, now, Special Agent Bode, tell us, please, once you received those items, what did you do?
I did a forensic DNA test on those items.
All right, if I neglect to do so, I intended to introduce the envelope and its contents and evidence.
No objection.
so
All right, tell us, please, how did you go about your analysis then?
Basically, forensic DNA analysis is a 4-step process. You start off first with each item, cutting each item.
I'm willing to stipulate to the accuracy of all of his findings.
let me talk y'all.
All right, tell us then, Agent Bode, how you went about your analysis and what your conclusions were.
Basically, DNA analysis is a 4-step process. First, we extracted the DNA. Each item gets put into its own special test tube. It's labeled with the case number and the item number on it. We add chemicals to that in order to allow the cells to lyse or break open, freeing the DNA to go into solution. We next amplify the DNA. We make up more DNA from a small amount of DNA. We then separate out the DNA by size through a process which is known as electrophoresis. Electrophoresis is basically just separation of charged particles within a medium. At the end of this 3rd step, we're left with a gel, which has our DNA separated across it by size. And then what we're looking for in the final step is just to identify the sizes of the different bands. Different bands of that profile, and comparing them by size from the question items back to the known items, either blood standards or saliva standards from each individual associated with the case.
All right, and then in this particular case, then, what were the results of your examination?
The DNA profile was obtained from the cutting from the khaki shorts of Michael Peterson, the swabbing from the sole of the left Converse All-Star athletic shoe, the swabbing from the stain from the stairway wall, and the stain swab from the couch near the kitchen. They all matched the DNA profile from the blood stain of the victim, Kathleen Peterson, and did not match the DNA profile obtained from the blood stain of the suspect, Michael Peterson. The DNA profile was obtained from the swabbing from the mouth area of the Diet Coke can from the table outside near the patio. Is consistent with being a mixture of at least 2 different individuals. The suspect, Michael Peterson, cannot be excluded as a possible donor. Additional bands are present on that Coke can, which cannot be accounted for by the standards which were submitted.
Now, let me ask you, as far as you saying that Mr. Peterson cannot be excluded as a possible donor in regards to the swabbing from the mouth area of the Diet Coke can, what do you mean by that?
In this particular case, there was a mixture of DNA from 2 different people, at least 2 different people, on the Coke can, on the mouth area of the Coke can. All of the DNA bands that were present in the profile from Mr. Peterson's standard were present there on the Coke can. However, there were additional bands that were present there as well. I think at 5 different chromosomes which we tested, which we couldn't identify. We don't know where they came from. They didn't come from Mrs. Peterson, and they didn't come from Mr. Peterson either.
All right. Tell us further then about your result.
The DNA profile that was obtained from the swabbing from the stains on the Diet Coke can from the table outside near the patio.
I know. I was thinking the same thing. What does he not want the jury to hear that this guy is going to say? Because he's like, oh, we stipulate to all this. Does he want him not to testify? Why does he? I did the same thing, Judy.
And the swabbing from the stains from the Diet Coke can in the kitchen is also consistent with being a mixture. The predominant profile, meaning the stronger profile, matched the DNA profile obtained from the blood stain from the victim, Kathleen Peterson, and the weaker partial profile is consistent with coming from the blood stain of the suspect, Michael Peterson.
All right. What else did you find?
Finally, no DNA profile was obtained from the cutting from the inner heel of the Converse All-Star athletic shoe, the swabbing from the mouth area of the Diet Coke can from the kitchen, the stained swab from the kitchen cabinet by the wine glasses, or the root from a hair that was collected from the second step of the stairwell. No DNA profile was obtained from any of those items. Therefore, no conclusion can be drawn as to the donor of the DNA on these items.
Now, did you further make some conclusions regarding the calculation of likelihood data?
Yes, ma'am, I did.
What does that mean?
Once we have determined that a match exists, we have to determine how frequently that profile is found in the population.
Again, for purposes of the record, I'm happy to stipulate that those matches are accurate. All right.
Yeah, I would like the jury to try to learn more and to try to understand this portion of his report. This is the last part of his report.
Well, I think the jury knows perfectly well what DNA is, and some of that might be interesting, but the defendant is not really contesting this witness's findings, so I'll allow you to let him explain somewhat, but we need to move on.
Yes, sir. All right, why do you do it?
Basically, just to determine, to put some sort of significance on that match. If everyone in the population had the same DNA profile, a match wouldn't be all that significant. But as I said earlier, everyone's DNA is different. So what we try and do is try to find out how frequently a DNA profile might be found in the population. In this particular case, this was done.
Okay, and that is the second and last portion of your report?
That is correct.
All right, Your Honor, at this time, move to introduce State's Exhibit 85K into evidence.
Hello.
No further questions?
Cross-examination?
Just a couple. Morning, Agent.
Good morning, sir.
Just to sort of get it down to sort of common terms, what you found was that the blood on Mr. Peterson's shorts and the blood swabbings from the Converse athletic shoe and the swabbing from the stairway wall and the swabbing from the couch all showed Kathleen Peterson's blood, correct?
It's scientifically unreasonable to think that it could have come from anyone other than Kathleen Peterson.
So we can say it's Kathleen Peterson's blood, right?
That's correct.
Okay. And with regard to the mouth area of the Coke can outside, we know that Michael Peterson drank from that Coke can from your analysis, right?
Michael Peterson, the defendant.
Yes.
That's correct.
And what you're saying is it appears that somebody else may have drunk from that, but you just don't know who it was.
That's correct.
Okay. And then with regard to the stains on the can, the blood stains, what you saw on there was consistent with DNA from Kathleen Peterson, which would come from the blood, right?
That's correct.
And then also DNA from Michael Peterson, which would come or could come from saliva or sweat or anything else for that matter, you know, any epithelial cells or whatever, right?
You're exactly right.
Okay. And then the final thing you found was that with regard to the swabbing from the mouth area of the Diet Coke can that was in the kitchen, that was not, you couldn't get anything that was consistent with Michael Peterson, right?
Or Kathleen Peterson.
Or Kathleen Peterson.
That's correct.
Same thing for the swab from the kitchen cabinet where the wine glasses were.
That is correct.
So, for example, we don't know that that's Kathleen Peterson's blood.
That is correct.
It could have been blood that was there for months.
That is correct.
Could have been the handyman's blood. I mean, we just don't know.
That's correct.
And then the final thing was that you got a hair from the second step of the stairway, right?
That is correct.
And sometimes if you have enough of a root, you can do DNA analysis and tell if the hair came from a particular person.
That's correct.
But you couldn't do that here.
Again, that's correct.
That's all I have. Thanks.
Redirect. All right, you can put down, sir.
Stop it, Spike. Why are you like that? You're driving me nuts. You're barking at me.
I'm currently assigned to the crime laboratory in Raleigh in the trace evidence section where I'm a forensic chemist.
He looks like the guy that voices Piglet. He doesn't sound like him, though.
Who specializes in hair, fiber, physical match, and gunshot residue analysis.
Could you tell us what you actually do in that respect?
I receive items of evidence from all the law enforcement community within the state of North Carolina, whether federal, county, city, and so forth. I examine those items for the presence in regards to hair and fiber, question hair and fiber evidence, and then I compare them back to known samples that are given to me, whether it's the head hair or pubic hair from the subjects or carpet or upholstery that was collected from the crime scenes. And then I disseminate a report as to the results of my analysis.
Tell us, please, about your educational and work background.
I graduated from North Carolina State University with a Bachelor of Science degree in textile chemistry. Upon transferring from the latent evidence section in 1993 to the trace evidence section, I underwent a 1-year in-house internship training program in hair analysis. After successfully completing that, I then began working hair cases and then training in fiber analysis, which again took another year, approximately training under the guidance of the senior chemist within those areas.
Have you received any specialized training in hair examination?
Yes, ma'am, I have.
What type of specialized training?
I've attended several workshops, such as an 80-hour course taught by the Federal Bureau of Investigation on the comparison and examination of hair and fiber evidence. I've also attended a workshop taught by Barry Gaudet of the Royal Canadian Mounted Police Laboratory, and which he's one of the leading folks in hair analysis. So I've attended one of his workshops and several other workshops and seminars over the last 10 years.
Do you spend most of your time at the SBI doing hair and fiber examination and comparison?
Yes, ma'am.
All right, and how many times have you testified as an expert in those fields?
Over 60 times.
Your Honor, at this time I would tender him as an expert in hair and fiber analysis.
Screwball. I have no questions. Hello.
Tell us, please, when you examine hair and fiber, what types of conclusions can you reach?
There are 3 basic conclusions that I can reach. The first one is that something is consistent with. Consistent with means that if I were to take that question hair and place it back within the known hair samples, I would not be able to disseminate that question hair from the known stamp. Same thing with fiber evidence. If I were to take that individual fiber and place it back in with the swatch of fiber that I used to compare it back to, I would not be able to discriminate any differences. The second one is not consistent with. That means that I can tell there is a difference and that did not come from that source. And the third one is inconclusive. That means that the hair or fiber has been damaged, was not sufficient in length. In regards to hair, there's certain hairs that we will not compare on a regular basis, such as blonde hairs because they don't have enough pigment pattern to them, or gray hairs because they don't have any pigment to them at all. So those are the 3 basic conclusions I reach.
Now, when you examine hairs, what characteristics do you look for?
The basic characteristics I look at, I can explain a lot easier if you were to consider this ordinary pencil to be a hair. Just like your hair has a given length, color, diameter, so does your hair. It varies from location, person to person on your body, what the length is and the color and so forth. First thing I do when I look at a hair, whether it's quest or known, is I look at the color, the overall length, the diameter, and so forth. But most of the characteristics, after I mount it on a microscope slide, the hair, and look at it, is underneath the microscope. After I mount the hair on the microscope slide, and then look underneath the microscope, is the internal properties of the hair. And that's where I get the bulk of the characteristics. The first characteristic I look at is just like if we were looking at the paint on the pencil. That is called the cuticle. The cuticle is made up of scales that look real similar to scales on such as a reptile, like a snake or a lizard, but they lay real similar to like the roof, the shingles on your roof. They can overlap at different parts, different distances. They can be thick or thin. Their pigment can be present or not. It can be clear, and it can be, sometimes the cuticle can also be yellow in color. So those are some of the characteristics I look at within the cuticle. The next thing is the lead of the pencil. The lead of the pencil is either present or absent within the hair, and it's called the medulla. Medulla can be running all the way through the hair, like I just said, or totally absent. It also can be translucent when I look at it through the microscope, which means it appears almost clear to the eye, or opaque, which means it appears black. It's just like if you were to drive down the highway and you look at the lines that split your side and the other side. Sometimes they are present depending on what roadway you're on or not. Sometimes they are continuous, which means you wouldn't pass, or they're fragmented like in a passing zone. It's a combination of those things, those characteristics I look at from the root to the tip of the hair. But the bulk of the characteristics come from the cortex. The cortex is be the same as the wood of the pencil. That is where you find the pigment pattern. And that will change from the root, which would be the eraser end, to the tip, which would be the writing end of the pencil. That'll change, the pigment pattern will change from the root to the tip. The pigment can be different sizes, it'll come in different clumps and patterns. Just like if you were to compare pine to cherry to oak, you'll see different patterns within those woods also. So I will take all those characteristics together with what I see with my naked eye and underneath the microscope and form a protocol that I'll compare back from the known to the question hairs.
Now, are there other things that you can determine during your analysis?
Yes, ma'am.
What types of things?
I can also look at the hair and see if it's been damaged, possibly determine it's been forcibly removed.
Did you bring some diagrams for us to better understand that?
Yes, ma'am, I did.
You want to approach the witness?
Yes.
Prepare diagrams D15 and D16 to help the jury better understand this.
Yes, ma'am, I did.
You want to make you step down?
Yes.
And I will move to introduce D15 and D16.
It's allowed.
Now, do you need these side by side, or do you want to use them one by one? We have two tripods if you need it.
I can use this one first.
Okay. Side then.
Everybody see this?
Here we go.
Okay. The first thing you need to understand is that hair grows in what we call hair growth cycles. And I'll basically touch on the three cycles real quick, then I'll go back and explain them. Anagen, catagen, and telogen. Anagen is the first stage that your hair grows in. Anagen is the growth cycle, and a head hair would last from between 2 and 6 years. If a hair is forcibly removed, you will see characteristics such as this in the picture here, where you can actually see the tissue. The reason that occurs is because the hair is still growing in the follicle. And when you extract that hair, whether you're combing your hair or get snagged on something, the hair will actually pull out and remove tissue with it, but not always. Sometimes it's kind of like, I use an example would be if you wear boots and if you just pull them out without pulling your boots off without untying them, sometimes that sock stays in the boot, sometimes it stays on the leg. And it depends on each person, each scenario. It's not always a given that we will get tissue. After a period of time, the hair will go into a resting stage, which is called catagen. Catagen will last a couple weeks or so. What happens here is when the hair is in the hair follicle during the catagen phase, the hair will start dying off. Then another hair will come in behind it and start getting ready to start producing another hair, and it will gradually, as this one goes into the final stage, the resting stage, telogen, it'll start pushing that catagen hair, which turns into a telogen hair, which is the last one you see. Telogen hair is the hairs that we naturally slough off. You naturally slough off approximately 100 head hairs a day. So that can occur where you take a shower, comb your hair, put on your clothes and so forth, or the wind blowing. It depends on, you never know what the circumstance is. And telogen can last for a couple weeks also. But those are the three basic stages of hair growth. And each hair follicle is independent of all the other follicles within your body.
Okay. Now, let's look at D15. You can title this Examples of Damaged Hair. Tell us what that means, please.
When I mount the hairs on microscope slides, I'm actually able to magnify them between 40 and 400 times and look at certain characteristics. Some of the things I can do is determine if the hair has been damaged, such as being crushed right here. This is an example I made myself where I actually took the hammer and just crushed the shaft itself. You can see it's broken right there. This is another example that I created where actually my hair was cut, and you can see a fine line when a hair is cut, how sharp it is right here. And another example during my training process is I burned some hairs. That also gives you this unique characteristic right here. Those are some of the things we can determine during the process of our hair examination.
All right. Thank you, sir. You may take your seat.
Now, were you asked to examine items in this particular case?
Yes, ma'am.
I'll show you a bag that's been labeled State's Exhibit 83.
Let's look at it. Let's get rid of this.
You recognize that?
Yes, ma'am, I do.
Yeah.
It bears the unique laboratory number that's been assigned to it, the dates, which I've examined it, my initials, and the item number that was assigned to it.
All right, let's go ahead and open that bag then.
Has it been opened already?
I believe so. And pull out the contents, please, sir. Do you recognize each of those 6 items?
Yes, ma'am, I do.
How?
Again, they bear the crime laboratory number assigned to this particular case, my initials, and the lab number that was assigned to these particular items.
Now, read for the record, please, how those items have been labeled.
They've been labeled as lab item number 50. The laboratory numbers are 2001 29757, and they all bear my initials and the date which I sealed them and created.
Okay, could you read the state's exhibit numbers for each of the 6 items?
We'll stipulate to the chain of custody on these as well.
I want to get the exhibit numbers into the record.
Oh, I'm sorry.
Okay. The exhibit numbers are 83A, 83B, 83C, 83D, 83E, and 83F.
All right, and what do these represent, or what's inside of here?
Each one of these containers contain microscope slides. Part of the process after I complete my analysis is to return the items that are removed from the containers, the evidence that was submitted to me, whether clothing or so forth, is to secure the evidence back as it's sent back. And we use these slide mailers or containers to send back. They hold approximately 25 slides each.
All right, Your Honor, this time I would move to introduce the bag, which would be 83 into evidence and the contents 83A, B, C, D, E, and F.
It's allowed.
Now, tell us please about the results of your analysis in this case.
specifically, ma'am?
Yes. Tell us what you did in this case and what the results were.
Yes, I received several items of evidence. The first item that I received was laboratory item number 35, which is the police department's item number 37, which was identified to me as the head hair standards collected from Kathleen Peterson, and then hairs that were collected from her right hand, and then hairs were collected from her left hand. I also received laboratory item number 38, the police department's item number 47, which was identified to me as hair collected from third step of the stairway. The next item was item number 39, which lab item number 39, which is identified to me as hair collected from the second step of the stairway, which is Durham PD's item number 48. The next item is laboratory item number 42, which was identified to me as hair collected from the second step of the stairway, which was Durham PD's item number 59. The next item was item number 43, which was identified to me as hair collected from the first step of the stairway, which is also Durham's item number 60. The next item is item number 44, which was identified to me as hair collected from the third step of the stairway, which is Durham PD item number 62. I then received lab item number 23, which was identified to me as stain collected from step, which is the Durham PD item number 12. Then I received the pubic hair and the head hair standard from Michael Peterson, which are items number 47-4 and 47-5. I also received laboratory item number 30, which was identified to me as trace evidence collected from Diet Coke can, which is Durham Police Department's item number 21. I also received laboratory item number 34, which was identified to me as the victim's sweatpants and sweatshirt, which is Durham PD's item number 32 and 33. And lastly, I received item number 57, which was a fiber standard collected from a dragon rug collected from the kitchen area in the front of the fireplace, which is Durham PD item number 77. And the last item I received was item number 58, a fiber standard collected from the Afghan blanket collected from the couch in the kitchen area, which is Durham PD item number 78.
All right. Now, first of all, was there one item that you, once you analyzed it, you decided was not suitable for further analysis?
Yes, ma'am.
What item was that?
I think you're referring to laboratory item number 23.
Okay. And that was identified to you as what?
The stain collected from the step.
Okay. Now, in regards to the rest of your analysis, tell us what your findings were.
I'll just read the list off here.
Okay.
The first item I have is examination of item number 30, hair collected from Diet Coke can, revealed the presence of 6 Caucasian head hairs that were found to be microscopically consistent with the head hair at Kathleen Peterson. Accordingly, these hairs could have originated from Kathleen Peterson. It should be noted that 2 of these hairs exhibited signs of being forcibly removed. It also should be noted one of these hairs exhibited signs of being broken and cut. Examination of item number 34, the victim's clothes, revealed the presence of numerous Caucasian head hairs that were found to be microscopically consistent with the head hair of Kathleen Peterson. Accordingly, these hairs could have originated from Kathleen Peterson. It should be noted that several of these hairs exhibited signs of being forcibly removed or broken and cut.
Now let me stop you there. When you say could have originated from Kathleen Peterson, what do you mean?
We'll be happy to stipulate that they're Kathleen Peterson's hairs. All right.
May he explain in his science what he means by that?
Yes.
Could have originated means that those hairs did come from that individual or any other individuals that has those characteristics.
All right. Tell us about the rest of your findings, please.
I think I stopped on item number 35-2.
That's right.
Examination of item number 35-2 is hair collected from the victim's right hand, revealed the presence of 11 Caucasian head hairs that were found to be microscopically consistent with the head hair of Kathleen Peterson. Accordingly, these hairs could have originated from Kathleen Peterson. It should be noted that some of these hairs exhibit signs of being forcibly removed or broken and cut. Examination of item number 35-3, hair collected from the victim's left hand, revealed the presence of numerous Caucasian head hairs that were found to be microscopically consistent with the head of hair of Kathleen Peterson. Accordingly, these hairs could have originated from Kathleen Peterson. It should be noted that several of these hairs exhibited signs of being forcibly removed or broken and cut. Examination of item number 38, hair collected from the third step, revealed the presence of 3 Caucasian head hairs that were found to be microscopically consistent with the head hair of Kathleen Peterson. Accordingly, these hairs could have originated from Kathleen Peterson. It should be noted that 2 of these hairs exhibit signs of being forcibly removed. Examination of item number 39, hair collected from the second step, revealed the presence of 3 Caucasian head hairs that were found to be microscopically consistent with the head hair of Kathleen Peterson. Accordingly, these hairs could have originated from Kathleen Peterson. It should be noted that 2 of these hairs exhibited signs of being forcibly removed. It should also be noted that 1 of these hairs exhibited signs of being broken and cut. Examination of item number 42, hair collected from the second step, revealed the presence of 1 Caucasian head hair that was found to be microscopically consistent with the head hair of Kathleen Peterson. Accordingly, these hairs could have originated from Kathleen Peterson. It should be noted that these hairs exhibited signs of being forcibly removed. Examination of item number 43, hair collected from the first step, revealed the presence of 10 Caucasian head hairs that were found to be microscopically consistent with the head hair of Kathleen Peterson. Accordingly, these hairs could have originated from Kathleen Peterson. It should be noted that 2 of these hairs exhibited signs of being forcibly removed. It should be noted that 3 of these hairs exhibited signs of being broken and cut. Lastly, examination of item number 44, hair collected from the third step, revealed the presence of 2 Caucasian head hairs that were found to be microscopically consistent with the head hair of Kathleen Peterson. Accordingly, these hairs could have originated from Kathleen Peterson. It should be noted that 1 of these hairs exhibited signs of being forcibly removed. It should be noted 1 of these hairs exhibited signs of being broken and cut.
All right, and you prepared a report that reflected these findings.
Yes, ma'am.
Now, folks, look.
This is one. Okay.
I'll show you what's the Mark States Exhibit 83G. You recognize that?
Yes, ma'am, I do.
What is it?
States Exhibit 83G is a copy of the report that I disseminated that lists the items that are received in this case, the results of my analysis. It bears the laboratory number R2001-29757 and my signature.
All right, I move to introduce States Exhibit 83G into evidence.
It's allowed.
Now, when you mentioned in your findings that hair showed signs of being broken, I believe your exact words were broken and cut or broken or cut?
And cut.
Okay. What do you mean by that?
When I examined the hairs underneath the microscope, when I looked at the areas that were broken and cut, they exhibited characteristics of a combination of 2 things. I showed you the ones that were cut where you could see the clean edge, kind of like at the edge of a knife and so forth. They also were ragged in part. So that indicates that the hair was broken. So it was a combination of those 2 characteristics.
I'd like to show you an item that has been marked. States Exhibit 72. You've seen this before, have you not?
Yes, ma'am.
Would an item like this be able to do that type of damage to a person's hair?
Yes, ma'am.
All right. Any other similar item might also be able to do that?
Yes, ma'am. It depends on how much force is applied with what item is used and the angle that it's used and so forth. There's many factors that can cause similar characteristics.
Could banging someone's head up against a stair, a wooden stair, do it?
It could be possible.
I'm going to show you an additional exhibit. Yeah, I'm going to need to look for this exhibit for 1 moment. I'll show you an envelope marked 12A and a box marked 12. Do you recognize these items?
Yes, ma'am, I do.
How?
They bear all my markings that I previously stated, the item number assigned, the laboratory number, the date in which I received it, and my initials on both items. States exhibit number 12A and 12.
Now, what was in that container when you received it?
And states exhibit number 12, there was not a whole lot within this container. It was some debris that was collected from the step. I used a specific microscope to examine such small particles. It's called a stereo microscope. A stereo microscope allows me to magnify things between 5 and 70 times, but it allows me to look at it with a 3D effect. I used that stereo microscope to look at it, and all I noted in here was a very, very small particle that was made up of blood and vegetable material.
When you say very, very small, just how small?
I didn't measure it. It was really hard to see with the naked eye.
Well, teeny tiny?
We'll stipulate it was teeny tiny.
Okay, well, with that in mind, there was evidence from this jury when Mr. Camden opened that canister is empty. Open it, please. All right, what's in it?
There's a couple small particles in here, some tape.
Now, is that the way you left that particular material after you tested it?
Yes, ma'am, without the tape being in here.
All right, so are there a couple little particles in there that are what's left of what you tested?
Yes, ma'am.
All right, and they're what color or what nature are they?
They're brown, a
They're like
brown
little
shade.
flakes?
They look like a little flakes of substance.
Okay.
When I actually analyzed this, I probed it and broke it apart in pieces, just trying to determine what it was. Looking underneath the microscope, it looked like blood and vegetable material to me.
All right, Your Honor, maybe he'd be allowed to step before the jury to show them what he's speaking of when he's saying there are some little flakes in there.
If he's capable. Yeah.
Are you capable of doing that?
I can try, ma'am.
Okay, let's try that.
If you look on the edge of my left thumb right there, there's a piece right here, then there's some on the interior. Flip right down in the center piece is a piece of tape. Again, right here, my left thumb there's a piece, and there's some down the bottom of the container. It's very small, less than a millimeter or so. Again, about my left thumb. And on the inside, the center piece is a piece of tape. Probably. Piece right there. Piece right there.
No further questions.
Before I leave this, Mr. Campen, crime scene tech, testified that he took a piece of something that he thought was either metal or wood and put it in here. You didn't see anything like that, did you?
I did not note anything like that in my notes.
You don't have any idea when you opened this, it was sealed, right?
That is correct, sir.
And chain of custody is supposed to be kept on something like this so that when you open it, it's because somebody supposedly put something in there and closed it up, right?
That is correct.
You mentioned some training you'd done. Ever taken any courses in which Skip Palahniuk was teaching?
Yes, sir, I have.
And Mr. Palahniuk is a pretty well-recognized expert in this field, is he not?
Yes, in microanalysis he is.
Yes, sir. Including hair and trace evidence.
That is correct.
He was certainly someone who you would respect.
Yes, sir.
Now, it's true, is it not? You talked about those three phases, anagen, catagen, and is it telogen?
Telogen or telogen, depending on what part of the world you're from.
So if Mr. Palahniuk pronounces it telogen, that's acceptable.
Yes.
All right. In any event, by the way, before I get to that, with regard to this material in here, when you said it was vegetable material, would that be sort of consistent, for example, with a piece from a Christmas tree, for example. Is that the kind of stuff you're talking about? Or
I didn't specifically note, sir. Okay. There wasn't a whole lot there to do anything with.
Gotcha. Okay. In any event, let me get back to those phases. You were talking about shedding hairs in that telogen phase. There's a little bit of a misconception about hairs just naturally falling out, is there not? In other words, even in the telogen phase, there has to be some sort of force applied, whether it's the wind or combing your hair or something that sort of pulls it out, right?
That is correct. In the telogen phase, until, I guess, if the hair growing behind it were actually to push it all the way out. But usually what happens is you lose that hair, whether you're putting on your clothes, taking a bath, combing your hair, and so forth. It requires a lot less force to remove it than if it's in the anagen or catagen phase.
Right. So in essence, there's a continuum. But even in, for example, the anagen phase, if you're combing your hair, you can sort of pull out.
It is possible. It does occur.
And of course, in this particular case, what we know is that there were a bunch of Kathleen Peterson's own hairs in her hand, right?
That is correct.
In both her hands, actually.
Yes, sir.
And a number of those had been forcibly removed.
Correct.
And when we talk about forcibly removed, that could be if she's putting her hands through her hair or feeling around, or there's blood adhering, you can forcibly remove hair that way, right?
It is possible.
All right. And we certainly know that at least a number of the hairs in her hand were forcibly removed, right?
Yes, sir. They were forcibly removed because I could tell that they were in the anagen or catagen phase. In some of the instances, I could actually see the tissue was there.
Right. And of course, when we're talking about whether or not a hair was forcibly removed, and I think you mentioned the catagen phase, obviously it would require less force to take a hair out in the catagen phase than in the anagen phase, correct?
Yes, sir.
What we're focusing on with regard to that is the actual root of the hair, right? That's what you're looking at in trying to determine whether something was sort of pulled out or whether it came out some other way.
We can actually look at the way the scales flow. If the root is there, that's the first thing we do, look at it, see if it's been forcibly removed. But if it's not there, if it's been broken or cut, you can actually determine which end would be the tip or the root of the hair closest to those points. And then if there is no root there, I can look at those areas like I explained to determine if it's been broken or cut or burnt or so forth.
Now, of course, there's two ends on any hair, right?
Yes, sir.
You've got your root end and then you've got your distal end, right?
Correct.
A number of these particular hairs on the distal end had, I think you said they were either cut or broken, correct?
No, when I referred to the areas where they were broken and cut, that's referring to the proximal area, which would be the root end of that.
Okay. Were there hairs that you found that had the distal end cut or broken?
I'm sure there were. She had cut hairs, and when I go through and do the actual examination, microscopic examination, I look at the whole length and look at it and see if the hairs are braided or cut at the root. At the tip end of the hair.
Right. And did you see cuts, evidence of cut hairs on the distal end?
Yes, sir.
And do you have any lab notes?
Yes, sir.
Do you have those with you?
Yes, sir.
Your Honor, I've not actually had a chance to take a look through those. If I might, perhaps we could take a short break and I can look through those and then we can continue.
All right, Stephanie.
Bundy had co-counsel. I don't think he ever got into law school. I think he was just pre-law. The judge that presided over the case, when he sentenced him, he told him that he would have liked to have seen him practice law before him. That he would have made a good lawyer. I don't remember his exact words. But he was he wasn't like Brooks. He was competent. He even married his girlfriend because he called her as a witness And there is a law in Florida. I don't know if it's still on the books, but there's a law in Florida where you can get married in a court of law if all you have to do is say, he did it wrong the first time, but then he fixed it. And so they were legally married. Do you want to marry me? And then they say yes. And you say, I want to marry you. I so do marry you, or something like that. And then it becomes a legal marriage. You just have to sign the thing. So he got legally married during his murder trial. And he would have the cops. I did a 2-part episode on Bundy. It might have some trial footage in it. I don't remember. It's been so long since I did it. But I'm sure it has trial footage in it. It probably has the wedding in it too. Shoot, what was I gonna say? I forgot now. I don't remember. But I did an episode. I did the 2-part episode, so it's like 2-ish hours about him. Bundy was probably my introduction into true crime. Oh, I remember what I was going to say. He would he had co-counsel that would do some of the questioning, but when it came to the cops, he would have them recount the crime scene, like every single thing in detail. Like he was reliving it the whole entire time. And it was the Florida trial. It was because the other crimes were out in the West. So the Florida trial was what was televised. And so there were survivors from that one. And he got to question the survivors, which I think is disgusting. So I've never watched the whole entire trial. I've only seen bits and pieces of it. He basically relived everything. That's why he wanted to represent himself.
We'll take a 10-minute break, sir.
We'll stand recess for 10 minutes. Everyone in the audience remain seated and allow the jury to exit.
All right, members of the jury, I have received a note from the juror about what our schedule will be, wanting to know whether we'll be here Thursday and Friday, and I will have some discussions with the jury in just a few minutes as to what our schedule will be. In just a few moments, we'll be finished probably for this week with your responsibilities as a juror. So just be patient. We'll get to it. Be patient. Okay. I told you the other day what our schedule was going to be. I'm gonna tell you when you got to be here and when you don't have to be here. You know, this is a smart jury. You know, I tried to get you to come that Saturday morning, and I tried to sneak that past you, but it didn't work. So you know what our schedule is going to be. I'm not gonna trick you. Ms. Rudolph.
Before I go on, let me just show you an exhibit, just to get back to this point just for a second. Can you put up Defendant's Exhibit 90? And you see that particular item there?
Yes, sir.
With some blood on it?
Yes, sir.
You didn't see anything like that in this container, did you?
It's hard to tell from that picture, sir, exactly if I did or didn't, because you never know what the camera flash did to it, what angle they took it at, and so forth, and how big it is. Actually, I don't know.
Because there's no ruler there.
That is correct, sir.
Should be a ruler there to give you a sense of size, right?
Objection.
Overrule.
Right.
If I was actually doing a comparison from the picture, but they gave me the item also, so not necessary, sir.
In any event, if that item was, say, I don't know, the size of around that size there, you didn't see anything that size, did you?
No, sir.
Now, with regard to, you can take that down, thank you. With regard to the hair, there were a bunch of hairs that were found in Ms. Peterson's hands, correct?
Correct.
And you analyzed all of those.
Correct.
And you had standards from Mr. Peterson, right?
That is also correct.
And you didn't find any hairs from Mr. Peterson's head in her hands.
No, I did not.
And the hairs on the Diet Coke can, those were all hers, right?
Yes, sir.
And you're familiar with a I won't call it a phenomenon, but I'll call it an occurrence, something that's called secondary transfer.
That is correct.
So, for example, if someone goes over to someone who's bleeding and puts his head on her face or in her hair, and hair can adhere to his hands and then be transferred to another object, correct?
That'd be secondary transfer. Primary transfer is when two objects actually come in direct contact. For instance, when I sit down in this chair, then get up, then if Special Agent Baudet were to sit down, he spoke before me, and if he left some hair here and it transferred to my coat, that'd be a secondary transfer.
Actually, there's a thing called Locard's exchange principle, isn't there?
Yes, sir.
Now, what Locard's exchange principle basically says is whenever two objects come into contact with each other, there's always a transfer of some sort of material, pretty much.
That is correct, but within our science, we're not always able to find them and identify them.
Right. But in any event, under Locard's exchange principle, if Michael Peterson comes in contact with Kathleen Peterson's hair or head or whatever, it's likely that something's going to be carried away by him, right?
It is possible.
And then if he's given a can of Diet Coke, a secondary transfer could put it on there, right?
That is correct.
Now, we talked about this poking at cut hair. When we're talking about cut hair, we're talking about something that's cut with a scissors or a razor or something that's sharp, right?
When I define cut hair, that's correct. That's why I combine broken and cut. There are objects, depending on whether it's this countertop or a baseball bat that's irregular shape, or anything that has any kind of sharp object, depending on how much force is applied and what it's applied to, can create a similar phenomenon to make it look cut, but it also has some ragged edges to it usually to look. That's why I call it broken and cut, because it's not coming from a device such as a knife or a razor blade or a piece of glass that gives you that clear cut line like you saw on my exhibit.
Okay. But on some of these hairs, you said cut or broken, did you not?
I think I said cut and broken and cut's what I said, sir.
Okay. It may just be a typo on here, but I noticed on some of them, let's just say, well, maybe I misread it. I apologize. So all of them, I see some of you say either
forcibly removed or broken and cut.
Okay, but it's always broken and cut.
That's how I describe it in this instance.
Okay, now, did you know anything about the environment? You were asked a question about whether that would be consistent with, or whether something like this could cause that, and you said, well, it could.
That's correct.
Were you familiar at all with the environment there in the stairway?
Yes, sir.
Do you know there's a chair, that metal chair right there?
Yes, sir.
And that's got some sharp edges, doesn't it?
It does.
And for example, if Kathleen Peterson's head hit that particular metal chair, that could cause a hair to be broken and cut, correct?
It could.
Indeed, the edges on that are sharper than the edges on this, aren't they?
Some of the edges probably are. I don't remember just distinctly what the chair exactly looked like. I didn't.
And of course, this is mostly rounded, isn't it?
That is correct.
And if you got hit with this rounded end, you wouldn't get broken and cut. What you get would be crushed, wouldn't you?
It depends on the force, and if there's nicks and cuts within that element that can form sharp edges. I don't know, sir, without performing specific tests.
Specific tests on the item?
On the item.
Of course, we don't have the item. You realize that?
Yes, sir.
This is not from the house, right? You know that?
Yes, sir.
But in any event, would it not be true that, I mean, what happens if something is shaped like this and it hits a hair? You talked earlier about that hammer. What happens is it sort of ribbons out, right?
That's correct.
And that's called a crush, right?
That's correct.
And if there was a hairline right here and I hit it like that, what's going to happen is that hair is going to get crushed, isn't it?
It's possible, sir. It depends on how much force is applied and so forth.
Well, it's a lot more likely to get crushed than it is to get cut, right?
I can't tell for sure unless it actually happens, and I examine it after that point.
I understand we're talking about probabilities, and I asked you whether or not it would be more likely. You know, if you had a hair right here, and if you hit like that, with this edge, what you likely get would be a crush, right?
Most likely.
Over, right?
Most likely.
Now, if somebody got hit with a poker, you see all this soot and stuff on here?
Yes, sir.
Now, do you know what soot's made up of?
Debris from the fire.
Well, it's actually two things, isn't it? It's first of all, it's fine wood charcoal that's sort of black and opaque, right?
Yes, sir.
And it's also condensed phase carbon, isn't it?
I'm not sure, sir.
You don't know anything about the microspheres that condensed phase carbon are shaped like?
No, sir. I don't understand that question.
All right. Well, using Lacard's exchange principle, if a used poker came into contact with a head and hair, and it had used soot on it, you might at least find some of that carbon or charcoal embedded in the hair, right?
It is possible that I could find that, but you also have to take in consideration what else happened to the hair. The hair was quite bloody.
Yes, sir. And you washed it?
Yes, sir. In some instances, I did to separate them out.
Yes, sir. So you could see better, right?
Correct.
And then under the microscope, if there was particles embedded, I mean, what would literally happen, I know we're talking about very small items, but what would literally happen is little tiny particles could get embedded into the root, for example, or the follicle that was pulled out, or the hair itself, right?
It is possible. I did not look for that.
You didn't look for that?
No, sir.
Well, that would be something that would be relevant if the prosecution is alleging that Ms. Peterson got hit with a blowpoke. Wouldn't you want to see if there was any charcoal residue?
If there was anything like that, I did not note it.
You didn't see any of that?
I did not note any of that in my notes. I did not see any.
Well, if you had seen some sort of strange particles, I mean, you're looking under a microscope, right?
Correct. I would have noted those and collected those.
And it was a scanning electron microscope?
No, the
stereo microscope.
The specific microscope that I use is a comparison microscope. A comparison microscope is basically two microscopes that sit side by side that come together with an optical bridge. It is attached to the top of that optical bridge is a binocular head. It allows me to place the question on one side and the known on the other side. It allows me to use the same illumination source on both the question and known hair, and allows me to use the same magnification on the question known hair, between 40 and 400 times.
You could blow up a hair 400 times?
Yes, sir, I could.
And did you do that in some of these hairs?
I'm sure I did, sir.
And you didn't see any evidence of any?
I did not specifically look for charcoal substance on the hair.
I didn't ask you whether you looked for it. You did say, did you not, that if you had seen some sort of strange particles, you would have noted it, right?
That is correct.
And you didn't.
I did not note anything like that.
That's all I have. Thank you.
Redirect.
Agent Gregory, as far as an item that, like the one that Mr. Riddoff is showing you, any charcoal or soot deposit that he might have been speaking of, would it depend, in your expert opinion, on the amount of the substance?
I'm going to object to leading at this point. Over.
Would it or could it depend on the amount of the substance that might be on an object of this sort?
Yes, that would be the same thing that was referred to earlier as the Locard principle. You have to have something there to transfer. The more that is present, more likely something will transfer, depending on what happens in the whole scenario.
And did you say in regards to that principle that although an object might transfer a substance or something onto another object, that there are certain things that your lab cannot determine?
That we don't specifically look for unless that's a tough question. I don't know if I've ever been asked to look for soot on hair before, so I did not examine those hairs for soot.
Do you feel like you would know what it looked like?
Probably not. It looked like dirt to me, most likely. I don't know. I've never looked at soot underneath the microscope.
Did you see anything that looked like even dirt when you've carefully examined the hairs?
I'm sure I did. I don't note those things because you expect to find debris in anybody's hair.
Okay, so those are the types of things that you normally would find.
Object to leading.
Sustained.
What other things might you normally find when you look under the microscope at someone's hair?
You usually can see some of the sweat, or I should say the oils and fats. You can also see some of the dirt and debris that's caught within the hair of the person. It depends on the hygiene that person has. When's the last time they took a shower? The last time they came in contact, anytime washing and cleaning their hair. It depends. It varies from person to person, day to day.
I don't have further questions.
Yeah. But what we were talking about was particles embedded inside, right?
I did not specifically note any particles bedded into the hair. If I did see them, I would note them.
Thank you. That's all I have.
Anything else? All right, so you can come down.
Thank you.
You can. All right, Mr. Deputy, members of the jury, we're going to need about 15 minutes so we can determine what our schedule is going to be. Mr. Deputy, we'll take a break at that time. 15 minutes, sir.
We're going to stand in recess for 15 minutes.
All right, ladies and gentlemen, we had an issue you wanted to discuss before we sent for the jury.
Your Honor, what we're going to do is talk about our request that Mr. Rudolph made first on Monday afternoon, I believe, to get a limiting instruction or direction to the jury at this clinical case about the evidence, the diagram, the rough draft of the diagram that was destroyed and not preserved by the state. For the record, we want to make sure that it reflects that there was an order in existence at the time, I believe signed by Judge Height, that rough notes were to be preserved, and there was a hearing scheduled in March of this year, and that we issued a subpoena for that particular document, among others, and that was all acknowledged on the record when Detective Campen was on the stand, that he knew the document had been requested, it was under subpoena, he didn't bring it. His explanation at the time was he felt like it would be misleading, and then after the hearing...
Well, the only issue for the court is whether to do it now or at the end of in the final instructions.
So I don't have to convince you that they need an instruction at some point.
Right.
All right.
You do not.
Okay, well, I accept that. I think we're entitled to an instruction now under Rule 105 of the Rules of Evidence that directs that a limiting instruction is to be given when requested by a party. And I think this is an analogous situation to a point where a limiting instruction is appropriate. Limiting instruction would be, for example, when 404B evidence has been offered and you want to direct the jury at the time that they hear the evidence that there is a limited admissibility for the evidence. What we have here is almost the flip side of that. We have something that the jury has heard, but they don't know that under the law, they can now draw an inference from what they heard, which is essentially evidence for the defense in this case. And since it is evidence that we're entitled under the law, under the McLean and the other cases, an inference that we're entitled to have the jury draw, I think it's like evidence that we are offering. And they need to hear now, when Detective Campen's testimony is freshest in their mind, an explanation from the court as to what inference they are permitted to draw. And that's why we think that we're entitled to it now under Rule 105 and not merely at the conclusion of the case. This is not where you're going to be telling the jury to decide how to assess Campen's credibility. It's not a credibility question about the witness. What it is what inference are they allowed to draw favorable to the defense from his destruction of that document. And so it's evidence, and we need the...
Mr. Whitehouse, let's not overdo it. I mean, I got your argument. I got it. Okay.
He didn't do it. It wasn't malicious. That was just his practice. He did a rough diagram that he later fleshed out. Therefore, he destroyed the original diagram. They have the diagram that was completed. This is ridiculous.
Now, I do want to bring to your attention the instruction doesn't say anything about a court order. It doesn't say court order. It just says, as requested, was not preserved at the request of the state. It doesn't say anything about a court order. So
that's correct. But yes. We're not suggesting that anything.
Well, you started your argument saying they need to know it was a court order.
No, I think they simply need to know what inference they can draw from his failure to preserve that diagram.
All right. Mr. Sachs, you've joined us again.
I have. Your Honor, I was actually, we actually object to the instruction as it is the whole issue of it. Number one, arguing that the diagram is even evidence, some kind of substantive or real evidence in this case. My understanding is that a diagram has been submitted that has arrows on it, that the only difference, the only missing item that we're talking about are pictures of shoe prints, which are in the same spots as the arrows and go in the same direction as the arrows. They substituted arrows for shoe prints. And so obviously, I would argue that this is not any kind of real or substantive evidence that we're talking about. Number one, it's demonstrative or illustrative evidence to start with. It's a trial exhibit. I mean, under this kind of analogy, any report that was made, any trial exhibit that was made, if there's any draft of anything that's been shown and prepared to help illustrate somebody's testimony, then all that is
the case that was handed up by Mr. Rudolph the other day, albeit a civil case, said as a matter of law, unless you got a good reason, you be in the state to explain what happened to the potential document. The reasons for the spoliation can be inadvertent all the way up to intentional.
That's correct.
And this jury instruction is designed like that one used in the civil case to cover all possible grounds, unless you have, as a matter of law, a very good reason for the court not to give the instruction. And the court probably shouldn't give it. But what is the very good reason the state has?
The very good reason
for the destruction of the document.
The very good reason was that the original diagram was misleading because there were no shoe prints leading in that kitchen. What you saw were footprints.
Mr. Sachs, you have to balance that with who was requesting the document not be destroyed, which is a Superior Court judge. The court said preserve your notes. Now, me and Mr. Rudolph, we talked about this the other day as to whether or not that is a proper order or one that this court would would side, because as I explained to Mr. Rudolph, the fact that he asked the document be preserved does not mean necessarily under North Carolina law he would be entitled to that. I mean, he in effect gave the defendant an extra right of discovery, which a normal defendant doesn't have. But that aside, it seems to me
I agree.
he should have done another diagram. You know, he's had one with the shoe prints on it. I do agree with Mr. Harden that he could have clearly explained why he did another diagram with the bare feet as opposed to the shoes, and had Mr. Rudolph wanted to force the state to introduce that in the evidence, or if Mr. Rudolph introduced the one with the boots in the evidence, the jury would clearly understand what had happened with Mr. Campion's explanation, but that's not what he chose to do. And when he destroyed that document, he, in effect, although it's not the most extreme violation of a court order I've seen, I mean, he destroyed the document. He had a better way of dealing with it. He had a better explanation as to why he would have two, than why he has one.
To what?
He would have had two. He should have had two diagrams. The one that he did with the boots on it, and the one that he did with the bare feet, which would have been his second one. And instead of destroying the one that he did do, first of all, on the computer, he could have introduced both of them and told the jury why he had a second one that had a different diagram on it. To me, that would have been a total explanation and not one that could have been misunderstood by the jury.
Well, yeah, I do think what we're getting off of, obviously, is we're focusing more on the court order than just the general issue of evidence being destroyed or whatnot, because it is significant that they submitted a civil case in this matter, because you won't find this type of instruction in a criminal case. In destruction of evidence in a criminal case comes under Brady, it comes under due process, it comes under those types of things. We have cases where tons of marijuana are destroyed, where rape kits are destroyed, things of that nature, and the cases still go to trial and the appellate courts do uphold them. This is a little different because you're dealing with a court order.
It depends on how you interpret Brady and the Pennsylvania case and some other, as you know, a lot of defense counsel, including Mr. Rudolph, have a much more expanded view of what is exculpatory than probably the North Carolina Supreme Court does. That's why I say it causes the court somewhat. You weren't in court. I told Mr. Rudolph it causes the court a little bit of problem when he has a judge to preserve the notes of the officers. As you know, our North Carolina Supreme Court is much more restrictive in what they consider to be exculpatory, or
that was going to be my next argument,
or Brady kinds of materials. And when you force the state to save the notes that they may not even be entitled to under our normal discovery statutes, and the North Carolina Supreme Court cases, which, as you very well know, North Carolina Supreme Court takes a somewhat restrictive view of courts outside North Carolina, even the federal courts. They believe they are the highest.
But that's not Brady. That is not Brady material. If it was Brady, it would have to be something that would exonerate Michael Peterson. The fact that the first diagram had shoe prints, and they were not shoes, they were bare footprints. And the second diagram just had arrows where the footprints were. That does not exonerate Michael Peterson. Therefore, it is not Brady material. Therefore, it should not matter to the jury. It's like it's the equivalent of semantics. Semantics is like you use one word instead of another word. It's shoe versus footprint. And it doesn't matter because the only bloody footprints in the house belonged to Michael Peterson because he was walking around in his wife's blood, and maybe Todd. It's not exculpatory evidence. It's not a big deal. Rudolph is making it a big deal for no reason. It's stupid.
judges of what the North Carolina law is. So it's not unusual that defense counsel might have an expanded view of some federal cases and some North Carolina cases than our courts have. So I understand what the issue is, but the principle, I think, is still the same. I don't think it matters whether it's a civil case or a criminal case. It's a destruction of evidence. And as I told Mr. Ruff the other day, there was no comparable pattern jury instruction that dealt with that. He may have seen it in the federal court, but there is not one in North Carolina. Nonetheless, I think the principle is the same. And this instruction that he's talking about, it's not the worst instruction for the state that I've seen. I mean, they can believe what happened to that document, or they can disbelieve what happened to that document. They can infer the harshest penalties upon the state, or they can view it as being not that big a deal. So Mr. Hard, and whoever makes the final arguments, Mr. Rudolph, they can argue the merits of these things to the jury. And the jury is very intelligent. As you know, Mr. Sykes, having picked numerous jurors in this county, they're very intelligent. I don't really see a problem. You know, the court in its discretion will give the instruction. I'll give it before they leave today.
Thank you. Thank you. Just as long as our objection was noted for the record, that's fine.
Everybody's objections are always noted in the record, Mr. Sang. Yes. Okay. Now, before we tell the jury what our schedule is, I'm going to give this instruction. Is there something else? Okay, let's bring him in, Mr. Deputy. All right, members of the jury, before we adjourn, and we're getting ready to adjourn in just a second, I'll tell you what our schedule is. I want the jury to consider this jury instruction at this time. Members of the jury, evidence has been introduced tending to show that the first diagram of the kitchen area done by Detective Campin is not available for your consideration because it was destroyed or not preserved at the request of the state. The law provides that when a party intentionally destroys evidence, the jury may infer that the destroyed evidence would have been unfavorable to that party and would injure its case. If you find that the state caused this evidence to be destroyed or not preserved, you are permitted, but not required, to infer that this diagram would have been unfavorable to the state. Now, members of the jury, that is the instruction I wish for you to consider. Are there any other requests from the jury as to that instruction? You want me to reread it? You got it? Anybody who wants me to reread it, raise your hand. Okay. I don't know what the first part is, so I'm gonna reread. Okay. All right, you ready? All right. Members of the jury, evidence has been introduced tending to show that the first diagram of the kitchen area done by Detective Campin is not available for your consideration because it was destroyed or not preserved at the request of the state. The law provides that when a party intentionally destroys evidence, the jury may infer that the destroyed evidence would have been unfavorable to that party and would injure its case. If you find that the state causes evidence to be destroyed or not preserved, you are permitted, but not required, to infer that this diagram would have been unfavorable to the state. Now, is there anything else from the jury as to this instruction? You want me to read it again? You You got it? Anybody wants me to read it again, just raise your hand. All right, I don't see any hands. Now, with that, members of the jury, we will take our weekend recess at this time. Remember the instructions I've given you throughout the course of this trial. Keep an open mind. Don't talk about the case, even among yourselves. Stay clear of the parties, the witnesses in this case. Don't read about the case. Don't watch television about the case. Don't do any independent research about this case. Now, you're going to get a somewhat extended recess, members of the jury. We won't meet back in court. Well, I will meet back. You won't be back in court until 9:30 Wednesday morning. Okay? Now count them. Today is Wednesday. That's Thursday, Friday, Saturday, Sunday. You don't have to come on Saturday this time. Monday, Tuesday, Wednesday. All right? 9:30. Oh, no. Let's get it straight now. Because I don't want anybody calling me at home talking about, Judge, what day did you say come back? Okay? Wednesday morning, 9:30. All right? Anybody understand that? Nobody? Somebody doesn't understand, raise your hand. We'll get it straight. Okay. We'll see you then.
Well, it is in the oven. You can't eat it yet. It's raw. Well, it's not raw. It's frozen.
Like to what I guess we could call a comfort zone. As I understand what he will be testifying to is two things. One is just what the temperatures were, at least in Raleigh, at the relevant time. And there's a chart that's been prepared that shows temperatures. That chart, however, also shows, let me hand up a copy of it. Here's a copy of what they've been using, and this is a chart that has a horizontal band labeled DOE winter comfort zone. That we object to, and it was clear from the voir dire that apparently was based on some study that Mr. Haggard himself had not read and did not have with him. We have since been provided the purported basis for that comfort zone, and I'll hand up a copy of that to the court as well. Is there a copy? I was provided this document by the state. What this is not a study at all. It's a educational worksheet apparently used by the, I think, Louisiana, University of Southwestern Louisiana in teaching. And it contains in here, several pages in, a diagram that appears on page, it's the date stamp number 10278. It's this diagram here, Your Honor. And apparently what Mr. Haggard has simply done is taken a point from this diagram that contains both winter and summer comfort zones and plotted it as a vertical bar on his chart to show where the comfort zone would be, and then contrast temperatures with that. We have two objections to this. One, of course, is that jurors are perfectly capable of their own, of determining whether a given temperature is likely to be comfortable to someone else, and don't need an expert to tell them what is comfortable and what's not comfortable. In addition, to the extent this purports to give any information to the jurors that they wouldn't know on common sense, there's no indication of the basis for the study. This chart simply thanks the Department of Energy for the chart. I'll tell the court that I went on the U.S. Department of Energy website and couldn't find any such study, so I don't know whether it's a U.S. Department of Energy or a Louisiana Department of Energy, but there's no actual study that shows where this comfort zone comes from. And this court, of course, has responsibility as a gatekeeper for reliability of any kind of expert testimony to determine whether there's some basis for determining its reliability.
Right. But Ms. Maher, what makes you think the average juror knows what's comfortable for somebody else. I mean, they may
I
know,
think they
may
have,
not know what's comfortable for them, but
and then that's exactly true. But there's without a reliable study showing that there is some scientific basis for determining what would be comfortable for Mr. Peterson or Kathleen Peterson, this study is misleading. And no indication that the study has any more information or reliability than the jurors on their own would have. Jurors, of course, have lived here, have a wide range of experience. 12 of them will go back to deliberate. And between the 12 of them, they will have as much information about whether a given temperature is comfortable or not as a study that has absolutely no showing of any reliability. We don't know how the study was done, how many people were questioned, how they were questioned. What we do know from the voir dire is it's an inherently subjective assessment, that people were simply apparently asked, do you feel comfortable at this temperature? And without some showing of reliability and given...
Okay, I know where this is going now. I was like, why? Why do we need a forensic meteorologist? Y'all, I have lived in the South my entire life. Spike, wait a minute. I'm talking. I keep losing the thingy off my microphone. Spike, stop. Michael Peterson said that they were outside by the pool and it was a nice night. It was 55, 60 degrees. This was December in North Carolina. When it gets to 55, 60 degrees here, we are freezing. Now, our winters are 55, 60 degrees. So there are times where it does get down into the 30s, 40s that last maybe a week, maybe. North Carolina is north of us. It gets much colder. 65 is shorts weather? Okay. I'm just saying, to me, 60 degrees is not sitting out by the pool weather. 55, definitely not. 55, we're starting to bundle up and turn the heat on. So this guy is supposed to say there's a comfortable temperature that everybody's comfortable at? I know. No, exactly. Yeah, you live in North Carolina, right, Paul? Yeah. So I know I'm not sitting out by the pool if it's 55 degrees, but in the way the documentary on this man opens up is we were sitting out by the pool. It was a nice night. Oh, Stephanie did. Okay. I thought that's where you guys live now. Where do you live now? Oh, don't say if you don't want anybody to know. That's fine. But 55 degrees? That was a nice night to sit out by the pool? Not in my book, it's not. So this guy is going to get on the stand and say that the comfort zone is the same for everybody? Oh, cool. Okay. Maryland. Well, it's cold in Maryland, too. Move down here. We can hang out together at Disney all the time. Yeah, so I don't buy it. I do not buy it. In fact, when I was at Epcot the other day, it was so nice. It was in the 70s. It was beautiful. And people walking around with fans. And I was like, these people are not from Florida. There is no way these people are from Florida if they think it's hot. Because it was beautiful. It was a wonderful day. It was like low 70s. Very, very windy. But it was not hot. It was a nice day. And all these people are walking around with, the little battery-powered fans. And I'm like, these people are not Floridians. There's no way. Because they were hot. There is no comfort zone that everybody's comfortable in. It's impossible. So if that's what this guy's going to get on the stand and say, if there's a study that study's flawed. It has to be flawed because there's no all comfortable temperature for everybody. It's not. It's subjective. There's no way. When they were talking about the forensic meteorologist, I was like, what in the world is this guy supposed to say? This wasn't even something that happened outside. This was inside. What is a forensic meteorologist going to do for this trial? Now, if it'd been the Karen Reed trial, because, it was snowing, right? If we learned anything from the Karen Reed trial, we learned it was snowing.
This is something that jurors don't need expert assistance on. We would object to any testimony that's based upon this comfort zone.
Joe Sudley?
Ms. Hart.
Are you a mushroom?
Actually, Ms. Black. Ms. Black.
Judge, I would argue to the court, I would just simply disagree with Mr. Maher. The testimony was clear from Mr. Haggard, first of all, that he is an expert in the field of forensic meteorology. He has vast experience in that field. And this study, according to his testimony, is reliable. It is relied upon by a number of individuals. It makes sense, and it makes sense for the jurors to hear this information and to help them to sift through the rest of his testimony. So I would argue that it should be admitted before the jury.
All right. Anything else, Mr.
Well, I don't know how Mr. Haggard could say that a study he's never read is reliable. So I would dispute that. And as a proponent of the evidence, I think the state has the burden of showing reliability. They simply haven't done that.
Well, the court finds, based on the voir dire and the arguments of counsel, that this witness will be allowed to testify about the comfort zone that's been the subject of this voir dire. The court finds that this testimony is well within his expertise as an expert witness. The court finds that the studies that he has used are reliable. Of course, counsel can cross-examine the witness about those things, and it will probably not go to its admissibility, but to the weight that the jurors would give it. The court also finds no undue prejudice to the defendant by this testimony. And of course, Mr. Maher, the defendant's objection is noted for the record.
Two things. One, that we have continuing objections, and secondly, that the document I handed up, which is the energy conservation enhancement project, be marked, made part of the record, so it's clear what the testimony is based on.
All right, sir. I'm not exactly sure what you mean. You mean part of the voir dire or part of the?
I guess we could mark it.
Assuming he uses it in his testimony.
Well, I guess even if he doesn't use it in his testimony, in case there's ever any later review of whether there was in fact a substantial basis for that comfort zone, what maybe makes sense is if I just mark that as Defense Exhibit 169 and ask that it, at this point, be admitted for the limited purpose.
Yes, sir.
State your name, please.
My name is William H. Haggard.
Tell us about your educational background, sir.
I have a Bachelor of Science degree from Yale University in 1942. I have a certificate of professional meteorology from the Massachusetts Institute of Technology, also in 1942. I have a master's degree in meteorology from the University of Chicago in 1946. And I have a year of graduate work in meteorology at Florida State University in 1958-59 under a government scholarship.
Tell us, please, about the types of degrees that you have. In what field?
Types of degrees that I have?
The different degrees that you have. Yes, sir.
Well, a Bachelor of Science in Physics from Yale, a Master of Science from the University of Chicago in 1946, all in meteorology.
All meteorology.
Yes.
Meteorology. All right. Now, Mr. Haggard, tell us, please, about your work experience. I entered the Navy in 1942 during my senior year at Yale at the beginning of World War II, and was immediately sent to the Massachusetts Institute of Technology
where I became a professional meteorologist on active duty with the Navy. I had spent a year in aviation meteorology at the Naval Air Station in Jacksonville, Florida, and then a year and a half on an escort carrier in the Pacific, the Atlantic, the Mediterranean. I was discharged from the Navy in December of 1945 and entered the University of Chicago for a year of graduate study leading to my master's degree. Then I taught physics and meteorology at North Carolina State University in 46, 47. I joined the U.S. Weather Bureau in 1947. It later became the National Weather Service under the National Oceanic and Atmospheric Administration, NOAA. I had a series of assignments in that, mostly in the Washington, D.C. area, a forecaster, a researcher. I was recalled to active duty in the Navy in 1951 to 54 and assigned to a weather research project in Norfolk, Virginia for 3 years. Then when I was released from the Navy the second time, I rejoined the Weather Bureau in the Office of Climatology, which is the study of past weather. I had a number of assignments in that office in 1961. I had the scholarship in 58, 59. And then I was assigned in 1961 to 1960 to the Office of Plans in the Weather Bureau, where we developed a 10-year strategic plans for weather observing, weather forecasting, satellite service, things of that type. Then in 61, I was assigned to what was then called the National Weather Records Center in Asheville, North Carolina, which is the archive, quality control, processing, publishing, distribution of all of the nation's weather records. I went there as a deputy director in 61. I became the director in 63 and retired from that job in 1975. I formed the Climatological Consulting Corporation and offered my services to attorneys in litigation where weather was a factor. And I have done retrospective reconstructions of weather and presented testimony to assist the courts in a number of states during the period 76 to 99 when I sold the company and became a consultant to it. I'm semi-retired, but the company assigns a limited number of cases to me, such as this one.
Tell us, sir, about how many times have you testified as an expert in your field?
Several hundred, probably 250 to 300 times over 27 years.
In what types of courts?
In federal and state and local county courts, from Anchorage, Alaska to St. Croix.
And in what field are you an expert, sir?
In meteorology. I'm a certified consulting meteorologist. I'm board certified by the American Meteorological Society and have appeared as an expert in meteorology, mostly retrospective reconstructions, looking back and deciding what the weather was.
All right. At this time, I tender him as an expert in the field of forensic meteorology. Now, Mr. Haggard, tell us, please, what is forensic meteorology?
Well, forensic means of or pertaining to the court, and meteorology is the study of weather. So it's weather for the courtroom.
All right. And in your field, how do you go about analyzing weather?
Well, you get all of the data. You have the advantage of hindsight. If you were a forecaster, you would have data up to a point. You would do an analysis of it, and then you would try to make a prediction to the future. In forensic meteorology, you are working with past data, so you have the data up to the time of the event, and then you have data beyond that. So you don't have to leap into the future. You simply have to build a bridge between the last previous and the next after data. And you simply take all of the operational data that were archived and then reconstruct for the specific purpose what the conditions were.
All right. Now, were you asked to do something in this case?
Beg your pardon?
What were you asked to do in this case?
I was asked to find out what the weather was in Durham, North Carolina for the date 8th and 9th forgive me, I forget the month and the year.
All right. December 8th and 9th of 2001?
Yes.
All right.
And to do that, I used the data from Virginia and North Carolina, the operational data at the time as it was archived, and then reconstructed what the weather was at this specific point by analyzing the data over a much larger area.
And why was that?
Well, sometimes there's a steep gradient. The weather may be different in Greensboro than it is at the Raleigh-Durham Airport. And if it is, then you have to figure out what it was at any of the intervening points where you don't have the specific data. In this particular case, the data were different ahead of a cold front at Rocky Mount and Fayetteville and Goldsboro, but were consistent behind the front at Raleigh-Durham, Greensboro, and Danville, Virginia.
All right, and why did you include Virginia in your analysis?
As you go across a line, the next station past Greensboro happens to be across the Virginia line in Danville.
All right. Now, did you use certain records to go about this process?
Yes, I did.
May I approach the witness?
Yes.
I'll show you what we marked sections at 141 and 156. First of all, let's look at 141. What is that?
This is a Department of Commerce certified record of the weather observations at Raleigh-Durham Airport between Raleigh and Durham, North Carolina for the 8th and 9th of December 2001.
All right. Now, were these part of the records that you used when you were doing the analysis in this case?
Yes.
I move to introduce State's Exhibit 141 into evidence.
It's allowed.
Now let's take a look, please, at State's Exhibit 156. Tell us what that is, please.
These are similar records for the same dates for Fayetteville, North Carolina, Greensboro, Winston-Salem, North Carolina, at the airport. Rocky Mount, North Carolina, Danville, Virginia, and Seymour Johnson Air Force Base at Goldsboro, North Carolina.
Did you also use those records?
Yes.
We have no objection to those documents being introduced.
All right, then. I move to introduce State Exhibit 156.
It's allowed.
Tell us, please, then, Mr. Haggard, what your findings were.
What my findings were?
As far as the temperature?
Well, a cold front had moved across western North Carolina and Virginia and the central part of the state, and the temperatures ahead of it were warmer than the temperatures behind it. The front had passed the Raleigh-Durham Airport, and the conditions at Raleigh, Greensboro, and Danville were quite comparable, but different from those in the other air mass further to the east. The results, the thing that I focused on particularly was wind speeds and temperatures.
And what was that?
Well,
let me ask you this way. What does wind speed have to do with the temperature?
Wind speed doesn't have anything to do with the temperature itself, but it has to do with the perception of temperature. A person feels a certain comfortable or uncomfortable at a certain temperature, but at that same temperature with a stronger wind, they may no longer feel comfortable. So there's an item called wind chill. The stronger the wind blows, the cooler you feel. In this case, there was no wind, so the temperature was representative of the conditions that an individual would sense.
So wind chill would not have come into play in the
Not
analysis
in this case, no.
All right, how about humidity?
Humidity is a factor in comfort. The higher the humidity, the more you sense discomfort at both hot and cold temperatures.
All right, now did you actually analyze these dates, December 8th and 9th, during the time periods in regards to comfort?
Yes, I did.
All right, how do you go about doing that?
Well, there have been a number of studies. The principal ones were conducted by the American Society of Heating, Refrigerating, and Air Conditioning Engineers, a society called ASHRE, which is the professional society that provides information to heating and cooling engineers and provides the information for the American National Standards Institute for the national standards on heating, cooling, and dehumidifying or humidifying of air for human comfort.
One right one.
Now, Roger,
Yes.
take a glance at States Exhibit 157. What is this?
This is a
Wiggles, do you know the theory about the fountain of youth? The theory about the fountain of youth is our natural springs in Florida. I live in Gilchrist County, which is the natural springs capital of the world. There are natural springs all over the place around where I live. Some of them are state parks, some of them are privately owned, which I don't know how you privately own a spring, but anyways, and those people that own the campgrounds, man, they charge an arm and a leg to get in there too, which I don't think it's right owning nature. That's not fair. But anyway, I guess the conquistadors, is that what they were called? The people that came over here with Ponce de Leon, they were called conquistadors, right? So the theory is that they watched people jump into our springs and come out and like be jumping around and having all this energy and everything. So they thought that the springs had restorative powers, and that's why they called it the Fountain of Youth. But that's not what was going on. Oh, really? Well, these aren't hot springs. These are cold. Very, very, very cold springs. If anybody tells you that we have warm springs, they're lying. Because they're 72 degrees year round. But 72 degrees sounds warm, but not to a human. You get in that water, it is so cold. It is freezing cold. Freezing cold. So, yeah, humidity makes a big difference. My stepdaughters get so mad at me because I just walk right into the water and they go in a little bit and go, and then they walk in a little bit more and go, and walk in a little bit more and go, and I'm like, just get in already. They're like, I hate you. Because of the arthritis, it's like full body ice pack for me. I love it. I don't hurt when I'm in the springs. It's amazing. But it is cold. But the manatees in the winter, they come up in the springs and I love it. You're not allowed to touch them. Oh, yeah. Cool. I need to come visit you. I don't have the money to travel though. Maybe one day. When Travis retires. What is that? I don't even know what that is. But so yeah, that's how the Fountain of Youth came to be. It's a myth. It's just the natural springs that we have in Florida. They're all over the state, but where I live is where most of them are. But yeah. Oh, it's a giant volcano. Underground? So wind chill, what he's talking about is like it's 57, feels like 51. That has nothing to do with comfort. It just means that it feels like 51 instead of the actual 57 because of the wind. That has nothing to do with comfort. Comfort is a personal preference. And I know that from personal experience because my husband keeps it too dang hot in this house and I'm always hot. It doesn't matter what the temperature is. I'm always hot and he's always yelling at me because he's cold. It's a personal preference. I don't even understand how they're letting this man testify to this. I will never believe there is a scientific comfort zone that everybody's comfortable in. It's not possible.
Graphic called Human Comfort that comes from the Department of Energy, and it shows two comfort zones, a summer zone, which is warmer, and a winter comfort zone, which is cooler, which relates dry bulb temperature, the temperature of the air, on a vertical scale versus relative humidity on a horizontal scale.
All right, did you use this chart?
Yes, I did.
I moved to introduce Text Exhibit 157 into evidence.
It's overruled. It's allowed.
Now, Mr. Haggard, did you actually prepare a chart regarding the temperatures and the comfort zone for our use?
Yes, I did.
Let's look at 138. Please, sir. Is that the chart that you prepared for our purposes?
Yes, I did.
I moved to introduce Text Exhibit 138 into evidence.
Objection. It's overruled.
So I have charts for the jurors if that, I may use them.
It's allowed.
Now, Mr. Haggard, could you explain this chart for us, please?
Certainly. On the left-hand side of the chart, going from 0 at the bottom to 100 at the top, is the temperature in degrees Fahrenheit. And across the bottom of the chart, from 12 a.m. midnight at the beginning of December 8th to 12 p.m. Midnight, the end of December 9th, is time. There's a vertical yellow line from 11 p.m. on the 8th to 2 a.m. on the 9th, which is the time that I'm told that Mr. Peterson was at the pool. So that's labeled at pool with a vertical yellow bar. And there's a horizontal bar labeled DOE, Department of Energy Winter Comfort Zone at 75% relative humidity, which goes from 66 degrees to 71 degrees as a horizontal green bar. Then there's a graphic in red starting at 1 a.m. on December 8th and running until midnight at the end of December 9th, which represents the temperature as it was measured at the Raleigh-Durham Airport, which is representative of the temperature at the Peterson residence.
So in using the chart then, could you tell us please what was the temperature at midnight?
At midnight, the temperature was, I have a table of these, and it's hard for me to read it off of here, but basically it went from 55 to 51 degrees.
And it was 51 degrees at what time that night?
At 2 a.m.
What was the comfort zone?
The comfort zone was from 66 to 72.
And now what would that mean, 66 to 72, as far as the comfort zone?
Well, above 72, normal individual would feel warm, increasingly warm as the temperature went higher than that. And below 66, an average individual would feel cool and increasingly cool to cold as the temperature went below that, outside of the horizontal green bar.
All right, so is it your testimony that between 12 midnight and 2 a.m. that it dropped from 55 degrees to 51 degrees?
Yes.
And throughout that time period was 66 degrees to 72 degrees. Would that be the appropriate comfort zone?
Yes.
I don't have further questions.
Thank you, Your Honor. Good morning. My name is Tom Maher.
Good morning, sir.
Mr. Peterson here.
Guy up,
Let me
Maher.
ask you first, when were you first contacted about preparing the chart that you prepared?
I'll have to look for the date. It was a few months ago.
Was it June of this year, probably?
Don't get me wrong. I think Peterson did it, but this guy's ridiculous. This is ridiculous.
Yes.
Okay, so after the trial, this case had already begun.
Oh, yes.
Okay, and for your services, the company that you are now a consultant with is paid $160 an hour?
Yes.
And then you get some portion of that paid directly to you from your company?
Yes.
Okay, and for that $160 an hour, you understood that your task was to develop information about whether it would have been comfortable for Michael Peterson and Kathleen Peterson to be sitting out by their pool the evening hours of December 8th over to December 9th of 2001.
Well, it wasn't those particular individuals. It was normal individuals, any individuals.
Okay, did you understand that the particular individuals that this jury has to consider were Michael Peterson and Kathleen Peterson?
Yes, I do.
And of course, there isn't a weather station at Michael Peterson's house, is there?
That's true.
In fact, what you ended up using was information from Raleigh-Durham.
Yes.
And you looked at some other areas, Danville, Virginia, Greensboro, Fayetteville, et cetera, to see how the variations were to extrapolate what might be at Durham.
That's correct.
Okay, and in fact, there was some variation even between Greensboro and Danville and Raleigh-Durham.
And there were small variations, yes.
And there can be variations in weather even within different parts of Durham on a given time and date.
Yes.
And elevation, for example, how high up you are may affect the temperature as opposed to another location that's lower down.
There's small variations with height, yes.
Okay. But the ultimate issue here was whether that temperature would have been comfortable to people at Mr. Peterson's house out by the pool, correct?
I assume so, yes. The study was to determine the temperature and to compare it with various measurements such as the ASHRAE comfort zone.
Okay, and one way of determining whether people outside Mr. Peterson's house felt comfortable was to find out who'd been at the house during those hours and how they felt, wouldn't it?
That seems reasonable, yes.
And did anybody tell you that there was a large number of law enforcement, and EMTs, firemen, and civilians who had come to the house that night shortly after Mr. Peterson called 911?
No one told me that, but I presumed that that was the case.
Okay, and based on that presumption, you didn't make any effort to contact any of them to find out how they perceived the temperature that night.
No.
And you have no information about whether any of them would have described the temperature as, in fact, not being too cool, being comfortable.
I have no idea what any of those individuals said their temperature experience was.
Okay, and in fact, if Officer McVeigh testified before this jury that when he was outside the house with Mr. Peterson during those hours that it was comfortable to him and not too cool, nobody from the state informed you of that?
No.
And of course, you don't know anything about Michael Peterson or Kathleen Peterson, do you?
No, I don't.
You don't know where they had lived in the past, do you?
I understood that Mr. Peterson had lived a number of places, but I do not know his life history.
Okay, and one of the things that affects whether somebody perceives the temperature is comfortable is how they're dressed.
Yes.
And you didn't do any investigation into how either Kathleen Peterson or Michael Peterson had been dressed when they were out by the pool, did you?
No.
So, for example, if Kathleen Peterson was wearing a sweatshirt and sweatpants, that might affect how she perceived the temperature when she was sitting outside.
That's true.
And if she had an additional jacket on, then an even lower temperature might be comfortable to her.
That's true.
And depending on what Michael Peterson was wearing, his perception of what was comfortable would be affected.
That's true.
Now, one of the things about temperature is that if you walk out of a hot or warm house into, say, 52 or 53 degrees, you may perceive that as colder than if you walk out of a cool house into the same temperature because you're experiencing the relative change.
The relative change will be affect your perception of temperature for about 15 minutes.
Okay, and you have no information about how cool the Peterson house was.
No, I don't.
And one of the things, of course, you could look at in determining an individual's comfort zone is how cool they normally keep their house.
That's true.
And if somebody keeps their house cooler than the Department of Energy comfort zone, that would be an indication that they enjoy cooler temperatures than the, quote, normal person studied by the Department of Energy.
Sure.
And you didn't make any effort to determine how the house was heated in assessing the comfort of either Kathleen or Michael Peterson, did you?
No.
And did anybody from the state inform you that the inside temperature at the time law enforcement arrived was 65 degrees?
That's not particularly surprising.
My question to you was, had anybody from the state informed you of that fact?
No.
Did you ask what the temperature was inside?
No.
Okay, and 65 degrees is actually below, at least by a degree, the bottom of the comfort zone.
That's correct.
Now, let me talk a little bit about comfort and comfort zone. It's true, is it not, that this chart basically reflects subjective assessments of a group of people about whether they feel comfortable at a given temperature.
That's true.
And there is a variation among individuals as to what temperature feels comfortable for them.
That's true.
So, for example, in this room, let's assume there's a relatively uniform temperature. All the different people here may have very different perceptions of whether it's comfortable or too cold or too hot.
I would believe that, yes.
So, for example, you could look at the jury and see that some people appear to be comfortable in a sleeveless shirt and other people are wearing sweaters. Correct?
Yes.
And that would indicate that they may have different perceptions of the exact same temperature.
That's true.
Now, this study, let me approach, if I may. You referred to this Department of Energy study. You haven't actually read that study, have you?
Well, the Department of Energy comfort is based on the ASHRAE studies.
Is there all one study then?
No.
Okay, so there are, and I'll get to ASHRAE in a second, but if I may approach, the Department of Energy let me hand you what I marked as Exhibit 169, if you could.
Yes.
Now that document, which is titled Energy Conservation Enhancement Project, is where the chart that I believe was State's Exhibit, was it 157?
Yeah, 157.
157 was pulled from.
Yes.
Okay, and this is what you use to create this green band on your chart.
That's correct.
Okay, Your Honor, I would move the introduction of the Exhibit 169. Now, what you basically did was simply look at the chart and find the point for the relative humidity and draw a green line.
Well, I drew a green line at 75 because that was within the comfort zone. Right. The actual relative humidity that night was 85.
Right, but so the green line simply represents a point off of this chart that you had.
2 points, yes.
Okay, and an upper and a lower
yes.
of the band. And you didn't go and actually read the research, whatever it may have been, that led to the creation of this graphic chart.
Well, I was familiar with the research that was done by ASHRAE, and I was aware that the Department of Energy basically relies upon the ASHRAE information.
So is the answer to my question, yes, I did not read the Department of Energy report that was the basis of this chart.
Objection.
Your Honor, I asked the question, I didn't get an answer.
I object. You're arguing with the witness.
Well, I wouldn't pose a question quite like that because it's a confusing answer, but I'll let you ask him.
Sir, the study that was used as the basis for this Exhibit 157, you have not reviewed, have you?
The specific Department of Energy publication that has this graphic in it, I have not seen.
Okay, and that is where that green band comes from.
Well, that's where that particular green band on this diagram comes from, yes.
And you don't know how that particular study was conducted.
I'm aware that it came from the ASHRAE studies.
Sir, you haven't actually read the study, so you don't know how they conducted that particular study, do you?
Objection.
I don't know how to answer it other than how I just did, that it's dependent upon the ASHRAE studies, and I'm totally familiar with the ASHRAE studies.
Sir, if you haven't actually read the Department of Energy study, you wouldn't know how many people, for example, were involved as subjects of the study, do you?
Objection.
No, I do not know how many people were referred to in the Department of Energy study.
And you do not know, for example, the demographics of where they were pulled from.
That's true.
You don't know how the study determined whether they felt the given temperature was comfortable or not.
They were asked.
You don't know, for example, the measuring instrument or how that was tabulated to determine their level of comfort, do you?
The level of comfort was a subjective response to a question.
You don't know how they went about determining that subjective response, do you?
They asked them.
Well, sir, you don't know, for example, whether they were asked, are you comfortable, or can you describe the temperature you're experiencing, or whether there was any fine gradations between the level of comfort and discomfort, do you?
All of that's true.
And you don't know what percentage of people said they were comfortable at temperatures that were either higher or lower than the comfort zones that are depicted in that chart.
Well, the comfort zone is defined by ASHRAE. Includes 80% of the people.
And that's, when you say ASHRAE, that's another organization. That's not affiliated with the Department of Energy.
That's true, but the Department of Energy is dependent upon the ASHRAE study.
Okay, and ASHRAE is the professional organization for engineers who work in the heating and cooling industry.
That's true.
Okay, and this study was funded by that industry.
That's true.
Okay, and what that study was to come up with a consensus standard for a comfort zone, correct?
That's true.
And what they agreed upon was that the comfort zone would be defined by what 80% of the people subjectively said was comfortable.
True.
So 20% of the people had either a higher or lower comfort zone than is depicted in their study.
That's true.
And so you would be wrong 1 out of 5 times for a given individual if you said their comfort zone was within that graphic band.
Objection.
Overruled.
If the comfort zone includes 80%, then 20% are outside of it. That's true. And that's 1 in 5.
And that study, for example, didn't examine things such as whether the consumption of alcohol, which affects judgment and perceptions, affects how people perceive temperature.
Hey, there are a whole flock of things that affect how people perceive temperature. And their metabolic rate is one of them.
Right, but for example, the metabolic rate is not necessarily dependent upon how alcohol affects your perception of your surroundings, correct? Those can be 2 separate issues.
I doubt that they're totally separate issues, but they may be.
Okay, so for example, somebody who has been drinking wine and having kind of an elevated mood may be more tolerant of temperature variations than somebody who has not been consuming wine.
That's possible.
And of course, you don't know anything about Michael Peterson or Kathleen Peterson's metabolic rate or how they perceive temperature.
No.
One of the things the study does say is that where people have lived affects their perception of whether a given temperature is comfortable, correct?
That's true.
So for people, for example, who grew up in the South, where it's generally hotter or even more humid than parts of the North, may be more comfortable in a hotter and more humid environment than somebody who lived in the North.
That's true.
And you have no information about, for example, whether Michael Peterson has lived for years in Germany.
I understood that he had it sometime left in Germany.
And temperatures in Germany may be cooler than they are in Durham, North Carolina.
That's true.
You also don't know anything about Kathleen Peterson's history in terms of the various places she's lived or what temperatures she was comfortable at.
That's true.
The truth is, in fact, you don't have any real information about whether Kathleen Peterson or Michael Peterson were comfortable sitting out by the pool that night in Durham, North Carolina.
Objection.
Well, he does what he does. Or
That's their specific personal reactions. I cannot answer. As to what the temperature was, I have provided you that information. And as to how most people feel is shown on the record.
But as to the specific reactions of Michael Peterson or Kathleen Peterson, you have no information as to how they perceive those temperatures.
It may have varied a few degrees from the norm.
Well, sir, 20% of the people aren't within the norm even for these studies, are they?
That's true.
No further questions.
redirect.
Sir, you were asked about the effect of where a person has lived.
Yes.
What that effect would be as far as their comfort zone.
Yes.
And you were asked about Officer McVeigh. It would make a difference, or it could make a difference, that Officer McVeigh grew up in Rhode Island. Couldn't it?
Who grew up in Rhode Island?
Officer McVeigh. You were asked about Officer McVeigh, and he said that he was actually comfortable. Well, if you were to learn that Officer McVeigh grew up in Rhode Island, that would make a difference, wouldn't it?
Well, his temperature, his life history might make him more cool temperature tolerant than if he had grown up in Alabama.
And that would apply to any and all of us.
Yes.
Right? So when
within a small range, the Department of Energy has a summer comfort zone and a winter comfort zone. And the summer zone is a few degrees warmer than the winter zone.
And when you prepared the chart, you say you were preparing that with information as far as what the average or normal person would be based on the studies and based on your analysis.
But that's what the study was based on. 80% of the people fell within the comfort zone.
All right. No further questions.
Just very briefly following up. By the way, these zones are for inside the house, correct?
They are, yes.
And the zones are controlled for temperature and humidity, yet there is in fact a difference between people's perception of winter and summer comfort zones inside their house.
Yes.
And these zones didn't take into account things such as consumption of alcohol in terms of perception, correct?
Objection.
Only metabolic rate.
And for example, you've seen pictures of people who go to football games and have been drinking or out in the cold with showing their painted chest and dancing around who appear to be tolerating the cold, haven't they?
For brief periods, yes.
If Officer McVeigh's opinion of the temperature was affected by where he grew up, that's simply an example that you'd have to know more about a person to know whether their personal comfort zone was within or without the chart you provided.
I don't know about individual comfort zones, which may vary a few degrees from the standard.
No further questions.
Anything else, Ms. Wilson?
Yes.
All right, you can come down.
Thank you.
Hey,
Can I be excused, Your Honor?
Yes, sir.
Thank you.
we have 5 minute recess before we call the next witness.
All right, Mr. Evans, 5 minutes, sir.
We'll stand recess for 5 minutes.
Kenneth S. Snell.
How are you employed?
I'm currently employed as a medical examiner and forensic pathologist by Mecklenburg County in North Carolina.
Now, with respect to that particular position, how does that relate to the medical examiner's office in Chapel Hill?
Our office serves as a regional office as part of the medical examiner system based out of Chapel Hill. We also perform autopsies for Chapel Hill for 5 surrounding counties to that of Mecklenburg.
Now, with respect to that position, please describe to the jury what your educational background has been in that field.
I originally obtained a biomedical sciences degree as a BS degree as undergraduate, then obtained a medical degree at the University of South Alabama Medical School, then did an internship in internal medicine, which is a 1-year program, then completed 4 years of general anatomic and clinical pathology at the same university, then transferred to the Office of Chief Medical Examiner in Chapel Hill to do a fellowship in forensic pathology.
So I take it you're a licensed physician in the state of North Carolina?
Yes, sir, I am.
And exactly what is the specialty that you work within in the field of medicine?
My specialty is in forensic pathology.
All right. And with respect to that, if you would, please, would you describe, are there different subspecialties within the field of forensic pathology?
In forensic pathology, you have general forensic pathology, and then there are specialists that we consult with, such as a toxicologist, such as a neuropathologist, 4 different fields that we need expert help in.
And with respect to those other fields, do you have any training in those other areas?
Not outside of my basic training.
All right. Now, if you would please, you had indicated that you work in the Charlotte-Mecklenburg area. What is in particular your position with that field office of the medical examiner's system?
I serve as a medical examiner for Mecklenburg County and then as a forensic pathologist for Mecklenburg County and for 5 additional counties for the Office of the Chief Medical Examiner.
And exactly what are your responsibilities there?
As the medical examiner, my job is to investigate and certify the cause and manner of deaths. As a forensic pathology, my obligation is to perform autopsies to determine the cause and manner of death and work with local law enforcement to obtain that setting.
Now, with respect to the field of pathology, do you hold any board certifications?
Yes, sir, I do.
If you would, please describe to the jury what those are.
I'm board certified in anatomic and clinical pathology. Anatomic pathology is the study of tissues that have disease processes, such as tissues removed from surgeries. Also, I'm board certified in the clinical pathology, which is blood banking, microbiology, and those type of clinical fields.
Are you yet certified in the field, the specific field of forensic pathology?
I'm to sit for my boards at this time, no.
Okay. Now, with respect to any professional organizations that would relate to your field, are you a member of any of those?
Yes, sir, I am.
If you would, please describe to the jury what those organizational relationships are and what those memberships are, please.
I'm a member of the National Association of Medical Examiners. I'm a member of the American Academy of Forensic Sciences. I am also a member of the American Medical Association and also a member of the College of American Pathologists.
Now, have you had the opportunity to testify as a forensic pathologist in other cases in the state of North Carolina?
Yes, sir, I have.
On how many occasions have you done that?
A total of 6.
And you've actually been qualified as an expert in the field of forensic pathology?
Yes, sir, I have.
Well, at this point, we'd move to have Dr. Snell considered an expert in the field of forensic pathology.
So,
now, with respect to what you do at the field office of the medical examiner's office in Mecklenburg County, approximately how many autopsies do you perform a year?
Approximately 240 or 50 autopsies a year.
Are there other related activities to determining cause of death that don't rise completely to the level of autopsy?
Yes, sir, there are.
If you would, please describe to the jury what that is.
The initial part of any medical examiner's case is to do an external examination, and then based on that external examination, determine whether or not an autopsy would be necessary to help determine the cause and manner of death.
Okay. Now, if you would please describe the distinction between your work as a forensic pathologist with the medical examiner's office and exactly what a medical examiner for a county does.
The difference is that as a forensic pathologist, I perform autopsies, forensic style autopsies, where a medical examiner basically investigates the information around the decedent, determines whether or not an autopsy would be necessary to help determine what the cause and manner of death is. So the distinction would be is that a medical examiner can only do the investigative part, whereas the forensic pathologist would take that information and then go on and do the autopsy to further help delineate the cause and manner of death.
And with respect to the system in North Carolina, please generally describe the interaction between the forensic pathologist and the medical examiner, if you would, please.
Yes, sir. The medical examiners are contract with the state and the local county that they're in to investigate the deaths, and they take the information they gather, no matter what that information may be, and relate that to the forensic pathologist to help them to perform their autopsy. The pathologist will then take the results of their autopsy and give that information back to the medical examiner so that the medical examiner can complete out their investigative form and the death certificate.
Now, with respect to the different disciplines, a forensic pathologist then has to be a physician, is that right?
Yes, sir.
Does a medical examiner in the state of North Carolina have to be a physician?
Not necessarily.
But in this particular situation, as it relates to North Carolina, you can be a non-physician and actually perform medical examiner responsibilities. Is that right?
Yes, sir.
All right. Now, with respect to how North Carolina is arranged, do medical examiners typically have credentials as physicians?
A majority of them are, yes, sir.
Okay, but there are still some in North Carolina that are medical examiners that are not doctors. Is that right?
That is correct.
Okay. Now, you talked about the fact that you worked in Chapel Hill for some period of time and that you moved over to the field office in the Charlotte-Mecklenburg area. Please take a moment and describe for us exactly how long you worked at the medical examiner's office over in Chapel Hill and then how long you've worked in the Charlotte-Mecklenburg area.
Yes, sir. I was in Chapel Hill as a fellow in forensic pathology for 1 year. During that 1 year, I also served as the medical examiner for Orange and Durham counties. I've been in Charlotte as the combined medical examiner forensic pathologist for approximately a year and a half. I moved there in July of 2002.
Now, in addition to performing responsibilities as a forensic pathologist in the Charlotte-Mecklenburg area, do you have other responsibilities out of that office as well?
No, sir.
In terms of teaching medical examiners?
Yes. Under the direction of Dr. Butts, who's the chief medical examiner in this state, I am the coordinator and also the person that kind of helps the local medical examiners in the 5 counties that we service. Part of that is responsibility to teaching new medical examiners their roles, their duties as a medical examiner, and then helping them with any problems they may have.
Okay. Now, let me come back forward. In December of 2001, exactly what was your role as it relates to the chief medical examiner's office out of Chapel Hill?
Directly relating to that, as I mentioned, I was a medical examiner for Orange and Durham counties, and then I was a forensic pathology fellow in that program.
All right. At that point, had you received any board certifications or anything like that?
No, sir.
Okay. Now, I want to direct your attention to December the 9th of 2001 and ask exactly what you were doing as it relates to the field of forensic pathology out of Chapel Hill on that occasion.
Yes, I was, that day was the day that I was supposed to work that weekend as a forensic pathology fellow performing autopsies for the chief medical examiner's office. As well, I was on duty that day for the Durham and Orange counties as the local medical examiner.
Did you have the occasion to receive a call and respond to 1810 Cedar Street on the 9th of December of 2001?
Yes, sir.
If you would please describe to the jury when that happened and what you did in response response to that call?
Yes, sir. I was on my way that morning to work when I received a call from Durham County's 911 dispatch to respond to a phone call about a scene. I received a name and a phone number, which I then called that name and phone number and got information and direction as to where I was supposed to go.
Okay. Did you go to that location?
Yes, sir, I did.
Go ahead and describe what you did once you got there, please.
Once I arrived at the scene, I met with multiple law enforcement agents. I was directed to who was in charge of the scene at that time. I was informed that they had a female at the bottom of a staircase. It appeared that she had fallen down the staircase. The reason they wanted me to come and look at it was that there was a large amount of blood that they were concerned about, and they wanted me to come and look at that, look at the decedent, and then determine what would be the best route in regard to the medical examiner system. Since it would have been in our jurisdiction, I would have received the phone call anyway. After having discussed with them at some length about the case, making sure that the scene was secured from a crime scene tech and that I wouldn't be disturbing anything by entering the crime scene, and because of the large amount of blood that they were talking about, I put on a set of booties to keep my own personal shoes from getting bloody, went in the house. To go in, we went in the back door, turned left towards the stairwell. At that point, I could see the decedent lying on her back, partially on the floor, partially on the stairs. I proceeded to look closely at her, did not touch her at that point, looked over the scene, discussed some of the scene with the detectives and with the crime scene techs. At that point, bypassed the decedent and walked up into the stairwell and then up the stairwell looking at the blood that was there. Again, trying to determine and answer the question they had was, could this have been a fall down the stairs? We discussed where the blood was on the different steps, went all the way to the top of the stairwell looking to see if I could see any blood other than at the bottom of the stairs. Came back down. The only blood I saw on the stairs and noted was at least on the last 3 steps before the landing, or 2 or 3 steps before the landing. Noticed that there were paper towels around her. I'd been told that there were some paper towels around her, and there was what appeared to be some smearing of the blood on the wall, and some of the paper towels were bloody. After that, and discussing the initial, what I saw with the detectives, brought in a body bag and laid it down in the hallway there. Moved her from there to the body bag and rolled her on her right side, which would have put her back towards the stairwell. Looked at, with a set of gloves on, looked at her, looked at the back of her head, and then noticed 2 lacerations that appeared to come together, making a V, with a flap of her scalp being able to be freely moved, which we call an avulsion. At that point, I quit looking at her. I didn't remove any of her clothing or anything else. I felt at that time to better determine what was going on, because she had a lot of hair. There was a lot of blood in her hair that was matted. I felt an autopsy would be necessary to determine what other injuries were on her, if there were any more injuries on the back of her head. So put her back in the body bag and closed up the body bag at that point. From that point, I asked, had anybody looked at the blood that was in that area, and did anybody have an opinion? I was told by someone, I believe one of the technicians, who was not certified in blood spatter but said he had some training, it appeared to him that it came from 3 different steps. I told the detective that was responsible at that time for the scene that based off of that and based off my findings, it appeared that she had hit the back of her head on these steps, had caused the lacerations, and that based off what I was told, that it could have been a fall down the stairs and therefore could have been an accidental death. However, since I couldn't see the rest of the back of the head, I informed the detectives they should look for some sort of an instrument that could have been used to create these lacerations, should there be more lacerations once the back of her head was fully examined. At that point, I left the scene, and the decedent was shortly thereafter transported off of the scene as well.
Okay. Now, approximately when did you receive the call to go to the location of 1810 Cedar Street?
Approximately 7:19 on the morning of 12/9/01.
And what time did you get there?
Approximately 7:40.
All right. And you'd indicated that in your testimony up to this point that you talked with several folks from law enforcement outside the residence before you actually went in.
Yes, sir, I did.
At that point, did you see any photographs of anything, or did you just have discussions with some of the officers that were in that location?
I did not see any photographs or anything, and we just had conversation on the outside of the house.
Okay. Now, you indicated that once you've had those conversations and you received some information from them, that you actually went into the house, turned left, and then described seeing what you've already testified about. Is that right?
Yes, sir.
Now, you had indicated that you went in. Did you go in by yourself, or were there others with you?
No, sir. There was at least one, if not two different people. I believe at least the detective that we talked to mainly was there, and I believe there was also one of the crime scene techs with me as well. So I was never by myself at any time.
All right. Now, I want to be clear on exactly what you saw when you got into that area. You turned left down the hall, and exactly what did you see once you made the left turn pointed in that direction, which would be, I guess, the north side of the house?
Okay. Once I turned left, I could see the decedent lying on her back with her feet out into the hallway, and basically from about her mid-back up to her head, being up into and on the stairs and up into the stairwell area there.
Okay. And at that point, you'd been informed that the area was secure so that you could go down and actually physically deal with Ms. Peterson?
Yes, sir.
Okay. I think you'd indicated that you walked up into the stairwell before you even touched her. Is that right?
That is correct.
If you would please describe exactly what you saw as it relates to the location of the blood and the towels that you were talking about earlier.
Yeah, there was a roll of paper towels, I believe, between her leg and the wall. And then there were several crumpled up paper towels with blood on lying on top of her and on the floor beside her. And then there was blood where she was lying on the double, I think it's a double landing type still, if I remember correctly, as it's turning and going up the stairwell. There was also some blood on the last 2 or 3 steps as it started going up. There was blood on the wall. Once you turn into the stairwell, there's a wall there on your left. There was blood on that. I can't remember how far up, but I can notice there was some going up a distance. There was some blood facing forward where there was a black metal chairlift, I believe. There was some blood around that. And then there was a small amount of blood on the wall, I believe, just above that, again, on the wall opposite of where she would have been lying.
And with respect to the blood on the stairs, go ahead and describe exactly what you saw on those various locations.
Predominantly what I remember seeing on the steps is the 3 bottom steps I mentioned, mostly were drops. I believe there was a little bit of smearing to that point, but mostly it was just drops of blood in that area. The rest of the area, it was large amounts of blood. There was some smearing on the wall to the left, and there was just a fine coat of blood, I believe, on the 2 sets of landings that make the turn up.
Now, you had indicated that once you looked at the blood in those various areas that you had some discussions with one of the other persons present about the possibility of Ms. Peterson striking those steps. Is that right?
Yes, sir.
Now, once that conversation was had, what exactly did you do?
That conversation took place about her striking her head after we'd already moved the body and everything. After that conversation, I backed out of the area, met with the detectives again, and discussed the possibilities that if this turned out to not be her head striking the stairwell, that a possible instrument would have been used, and they needed to see if they could find that instrument. After answering any other questions they had, I left the scene at that point.
Did you express any opinion about what they should look for?
In my opinion at that time, based off the limited thing, I would have thought that it would have been a rod of some sort, something long, round, possibly narrow, because it looked to me like at that time it was a narrow type laceration. So I told them to look for something along those lines. I may have told them examples would have been something like a crowbar or the fire pokers that you have with fireplaces, simply because those are some I've seen in the literature.
Okay. Now, once you got there and made all the assessments that you described, about how long did you take to do that?
I don't really remember. Probably would have taken me at least a half hour to an hour to have completed everything that I was there doing.
How long do you believe that you examined Miss Peterson's body?
The total time I spent looking at her would have only been maybe 10, maybe 15 minutes at the most, because once I saw the lacerations, I realized that it was going to go beyond the scope of what I could do at the scene and that it needed more detailed work. So I didn't spend a tremendous amount of time looking at her.
And I think you indicated that you all had jurisdiction for this subject. Would you please describe to the jury how the medical examiner takes jurisdiction over a body and makes a decision about whether to perform an autopsy?
Yes, sir. The state statutes give the medical examiner the ability to take jurisdiction of a decedent at a scene once we're notified. Once we're notified, the body can't be altered until we arrive at the scene or give permission to move that body. We do not have permission, we do not have jurisdiction over the scene itself, just over the body. And then what the guidelines allow us to do is to examine that body and then determine whether or not an autopsy is necessary to further determine what the cause and manner of death is.
And I think earlier in your testimony, you indicated that you found 2 lacerations based on your observations right there at the scene.
Yes, sir.
All right. And that you determined that it was necessary to perform an autopsy to see if there was any additional injury.
Yes, sir.
Now, and exactly why did you make that decision?
Well, but her hair was kind of thick in the back, and there was a lot of matted blood in her hair, and then I couldn't see the rest of the back of her scalp because of that. But also, in my opinion, had I continued to handle the back of her head or manipulate it, that I could have created an artifact that would then have made it difficult for a pathologist if I had chose to do the autopsy. So my goal was to do a limited evaluation at that time, see if anything further needed to be done. Since I felt that something further needed to be done, I felt that if I continued to look at her, I would have created artifacts, which would have potentially been a problem for the pathologist of that case.
And when you say artifacts, what do you mean as it relates to your examination?
Well, an artifact, in my opinion, in this case was handling her. I could have made the lacerations that were present larger. I've created avulsions myself by handling those things that wouldn't naturally have been there. So I felt that I could have made the injuries that were present or potentially present worse and have appeared worse when the pathologist got to them if I continued to work with her.
Okay, and you chose not to do that.
That is correct.
Okay. Now, you had indicated that once you made your observations, had other conversations with the folks that are present, you left the scene. Is that correct?
That is correct.
Now, did you have the occasion to witness aspects of Miss Peterson's autopsy?
Yes, sir, I did.
When did that occur?
That morning after I went to OCME to see if there was autopsy responsibilities for me that day, there wasn't. So when it came time to do the autopsy on Miss Peterson, I was able to stand there and watch the external examination and part of the evisceration. I didn't stay for the complete portion. I went down to my office and did normal routine paperwork.
Now, when you're talking about the external aspect of the autopsy, exactly what does that mean?
In any autopsy, there's an external examination where the body is evaluated for marks, scars, tattoos, for injuries, for medical therapy, for clothing, valuables. Anything that's on the outside of the body is documented, not simply from a scar all the way to any kind of injury. Also make note of the body habitus and those kind of things. So just general information about the outside of the body.
Okay. And you had talked about the internal aspects of the autopsy, and I think you indicated you weren't involved in that.
I watched a portion of it only.
Okay. If you would please describe generally to the jury what you're talking about the external examination, and you're talking about the internal examination, generally what goes on in an autopsy as it relates to that aspect of that procedure.
An internal examination is where we open the body cavities. We open the chest, abdominal, and pelvic cavities with a standard Y incision. We remove the chest plate. We examine all the internal body cavities for free fluid or adhesions. organs. We then will remove all of the internal organs for evaluation. We remove them in set patterns. Those then are taken and separated into individual organs and sectioned and evaluated for anything that's considered pathological, anything that's not naturally there. And then small sections of each one of those organs will be placed in a container, which then glass slides will be made of that to be looked at under the microscope. After the chest, abdominal, and pelvic cavities are done, the scalp is reflected and the top of the skull is removed and the brain is then removed, and the same thing is done in that. However, in this case, because it went to neuropathology, the brain was not sectioned. It was placed in formalin for the neuropathologist to evaluate, which is a routine thing whenever there's potentially head trauma.
Okay. Now, we'll make sure I'm clear on exactly what you saw. You saw the entire external exam and a portion of the internal exam. Is that right?
That's correct.
With respect to the portion of the internal exam, exactly what did you see? At what point did you leave to go back to your office, as you indicated a moment ago?
In this case, because of the injuries to the scalp and the concern of internal brain injuries, they did the head portion of the autopsy before the chest, abdomen, and pelvis. I watched them do that, watched them remove the brain, and then when they changed over and started doing the internal examination of the chest cavities, at that point, I watched probably a portion of that evisceration and then left. I did not watch any of the cutting of the organs.
With respect to the external exam that you observed during the autopsy, can you generally describe the injuries that you saw from the top of the head down?
Yes, sir. She had some, I believe, to be bruising and maybe some abrasions to the front of her face, I think predominantly on the left side of her face. She also had some bruising to the back, I believe, of both of her arms from about the elbows down to the backs of her hands. Predominantly, if I remember correctly, on the left side. I don't remember right off the top of my head any injuries to the chest, abdomen. I think she had maybe one to the back or in the area of the shoulder blade, I believe, on the left side. Then they should roll them over and started to look at the back of her head at the scalp laceration. They shaved the back of her head in what appeared to be multiple, probably around 7 lacerations, with multiple of those being parallel to one another. I believe there was one laceration running perpendicular at the top of her head and one running perpendicular at the base of the neck. There was at least the one that I had seen at the scene where 2 of them came together in a V shape and had what we call the avulsion or the flap of the scalp. Several of these was a long linear laceration with what looked like a fork or a splitting at one end. And then there was a fair amount of bruising all in this entire area of the back of her head where all these lacerations was.
Now, at the scene, you had indicated that you saw the 2 lacerations that formed an avulsion on the back of her head. At the scene, did you see any of these other injuries that you've just described that you saw during the external exam?
I didn't look for them because once I saw that and decided that further evaluation needed to be done, I didn't do anything. Plus, since I didn't take any of her clothing off, I didn't see those. Again, she did have blood on her, so I didn't clean any of that up at the scene. So I pretty much limited myself to the back of her head and saw those 2 and then stopped.
All right. Now, once the autopsy was completed, even though you didn't completely participate in it, were you made aware of the findings of the autopsy?
Yes, sir, I was.
Who informed you of those findings?
Dr. Deborah Radish.
And who is she as it relates to this autopsy procedure?
She is the forensic pathologist of record for the case.
All right. And with respect to those findings, did you have an opportunity to review the autopsy with them?
I reviewed the written autopsy report, but I have not reviewed the glass slides from the case.
Okay. Your Honor, at this point, may I approach the witness, please?
Yes.
With respect to your activities, did you prepare a report?
Yes, sir, I did.
Take your place at bench for a moment. Sure. Dr. Snell, let me show you what is marked in State's Exhibit 158 and ask whether you can identify that, please.
Yes, sir, I can.
What is it?
This is the report of investigation by the medical examiner that I completed in regard to the death of Kathleen Peterson.
Now, that's different from an autopsy report, isn't it?
Yes, sir, it is.
With respect to what's marked as State's Exhibit 158, that being a report of investigation of medical examiner, describe what the distinctions are.
The report of investigation by the medical examiner is simply a form that the medical examiner fills out based off the information they obtain regarding the death of an individual. It does not discuss the findings of an autopsy in particular. It may list the probable cause of death based off of either the initial findings or off of the autopsy report, but in detail it does not discuss the autopsy report. It's simply to provide information about the events surrounding the death of an individual.
With respect to the report of the medical examiner, again, that you prepared, would this be done prior to the autopsy then?
This case in particular, I did do it. But it depends on each individual medical examiner. Some will fill it out before, some will fill it out after. There's not a requirement. The only requirement is that it be filled out within 14 days of the death of an individual.
Okay, Your Honor, at this point, we'd move into evidence what's marked as State's Exhibit 158.
So
Now, I'd like to publish that to the jury with your permission, please.
yes, so
Now, Dr. Snell, again, looking at what is marked as State's Exhibit 158, jury now has that. I want you to walk us through how you prepared this document.
Yes, sir.
And we'll be discussing what you were thinking about as you did this, okay? So I'm looking at page 1.
Okay.
Walk us through all the information. Some of it's self-explanatory, but I want you to walk us through all the information so that we have a clear understanding of the form.
At the top of the form, it talks about who the decedent is that you're investigating. It gives the address at which that person resided. This is not necessarily the address at which the death occurred. Age, sex, race, and then it goes into the information about the actual occurrence.
Now, before you go there, with respect to this information that identifies Ms. Peterson, who did you receive that from?
Would have been from law enforcement that I interacted with at the scene.
Okay, so with respect to, say, her age, for example, that may or may not be correct. Is that right?
Actually, any of this information may or may not be correct because this information is what's gathered initially. Later, for whoever it is to determine what actually is accurate and not accurate, because the role of the medical examiner initially is simply to gather any and all information available. It's quite routine that information on this report gets changed or rewritten in some form or fashion.
And with respect to the information that you receive are you concerned with whether it's 2 or 3 levels of hearsay or even at that point whether it's absolutely accurate?
Initially, there's not that concern. Initially, it's simply to gather as much information so that when you certify the cause and manner of death, you have information. Usually, you don't certify the cause and manner of death immediately. Usually, there's conversations over a couple of days, and you're able to find that. However, sometimes it may be a month down the road that it comes to light that the information you had is not accurate, and usually we'll go back and do some form of an addendum to make a correction.
All right. Now, go ahead and walk us through the next section of this form, if you would, please.
Yes.
Beginning where it says information about occurrence.
Yes. The next section is the onset or the injury of an illness. This is, say, like somebody's in a car wreck. They survived the wreck long enough to be carried to the hospital and then died in the hospital. The injury or the onset would have occurred where the wreck was. Since in this case, the injury and the death occurred in the same place, there was not a distinction made. The next is the death. The information that I have here is information that I was given by police as to when her death was certified by the EMS that responded, the address, and then the county.
And I noticed that with respect to the line where it says death, you've got the date as 12/9/01, and then it looks like you've got a question mark and then the time of 2:40. Is that correct?
That's correct.
And again, you would have received that from somebody at the scene.
Yes, sir.
Why did you put a question mark out beside that?
Because at that time at the scene, they weren't for sure as to what time she'd actually been pronounced dead at that point. They simply gave me the time that EMS got the call. They couldn't remember. None of them at that immediate time that I was standing with had that information. They said they would get it later for me so that when I did the death certificate, which they did then provide me with the time for the death certificate.
Okay. Now, well, that raises a question. If at approximately 2:40 7:40 a.m., based on what you were told, is the time that Ms. Peterson is pronounced dead. Is there a way that you're aware of to be specific about exactly what time she died?
No, sir. There's no way in this case to know exactly the moment that she died. All I know is the time at which she was pronounced dead by probably in this case the first responders or EMS.
Okay. Now, then it goes on and gives the address, and then you've got the view of the body. And I can't read exactly what this says. Can you decipher that?
Yeah, originally I wrote down 7:30, but 7:30 was by my notes the time that I arrived at the scene, not at the time that I actually went inside and looked at her. So originally I wrote 7:30, but then when I was finishing going through my notes from the scene, I realized that it was about 10 minutes of a delay from standing outside talking to law enforcement before I actually went in and saw her. So one thing that I don't do in these reports, and we'd encourage none of the medical examiners to do, is to white out. Simply either you write over it or you draw a line and change it. So in this case, I made the simple change on the form by changing it from 7:30 to 7:40. I checked scene of death because that's where I saw the decedent. And then I wrote down the time at which that I was notified, which I have down as 7:19. That would have been based off the time that my pager would have showed on it. The next section is law enforcement. This is not necessarily the law enforcement officer that I talked to at the scene. This would have been who I was told was in charge of the case. Simply, I don't remember and didn't have in my notes who the actual officer that I talked with. Could very well have been Mr. Holland. The phone number that I was given would have been the phone number that I could have reached him any time of the day, which would have been his office. Next is whether or not I ordered an autopsy, and of course I did. It says ME authorized autopsy. Blood sample would have been obtained by a pathologist. If I had obtained it, I would have checked MELD, which is usually what that happens. A clinical alcohol, which is something that's done by a hospital. One wasn't done in this case, so there's no information there. The next section is the probable cause of death. This is not actually what is the actual cause of death. It's what at that time you deem to be the probable cause of death. Now, since some medical examiners wait to fill this section out until the autopsy has been completed, that may reflect the actual cause of death. In this case, I filled it out before the autopsy had even been started, and that's the reason I have down the information I have.
Now, is that your practice?
Not currently, no, sir.
Was it your practice then?
At that time, it was.
Okay. And why did you decide to change your practice?
I changed my practice based solely off of this case because of the fact that I put down closed head injury due to blunt force injuries due to fall down the stairs. After having reviewed the complete the autopsy report itself, I changed that opinion as to the cause of death. Based off of that and potential problems that may have arisen for law enforcement who was investigating the case, I feel now that it's better to wait at least until I have the preliminary autopsy findings. So again, it's still a probable cause of death, but at least I have the autopsy findings if an autopsy is done.
And this was based exclusively on about a 10-minute exam then of Ms. Peterson?
Yes, sir.
Okay. Now, if you would please go ahead and walk through the probable cause of death and down to the area where it says manner of death.
Yeah, the probable cause of death, as I mentioned, is at that time I listed as closed head injury due to blunt force injuries to the head. And a blunt force injury is something it's blunt, not a sharp force like a knife. It's something other than that, something that's blunt. And then a fall down the stairs, which is the thought process that was at the scene that I had at the scene. The manner of death, because of the fact of the lacerations and not knowing the extent of any more injuries that were there, and then also because of the large amount of blood and my concern that there may have been more injuries that led to that, I felt it was best to put the manner of death pending until I had the full autopsy report to determine that. So that's the reason that is pending.
And then there's a strike through that whole area. Why was that put there?
Yes, once an autopsy is completed and the case goes for review by the forensic pathologist or by a separate forensic pathologist, the section to the far bottom right says OCME review. The pathologist at Office of Chief Medical examiner review cases. They review this report from the local medical examiner. If their final opinion differs from that of the initial opinion of the medical examiner, they will draw a line through it and then write what their opinion as to the cause of death and the manner of death is. If you notice, it says SDC on the far right and AL is checked. That means automatic letter, which is the way they respond back to me as the local medical examiner in this case to tell me that there is a change in the cause and manner of death from what I initially had down.
Okay. And then again, that's based on the autopsy finding.
Based off a completed autopsy.
And then with respect, you've got signature line down there. I assume that's your signature.
Yes, sir.
And the date that you prepared, at least the front part of this document.
Yes, sir.
Okay. Let's move on to the second page where it starts medical history at the top. I don't see any indicators there. No one gave you any information about any medical history. Is that right?
I didn't receive history about medical disease processes that she had. I did receive information about medications that were known at that time that she had, which I have on the back page, which we'll get to. But at that time, nobody knew of any actual medical diseases that she was being treated for that they could tell me.
And then the means of death.
The means of death is where we talk about how the person actually died, what was involved with that. In her case, because the information and the thought process at the scene was that this was a fall, therefore I have fall checked and I have from stairs to the floor. At the time, I didn't have a good feel from the scene as to exactly how far down the stairs she would have fallen, whether it had been simply the last few where I saw the blood or whether it had been all the way from the top all the way down. So at that time, I just put stairs to floor because I didn't know that height, and I left where it says approximate distance. I left it blank because I didn't have that information.
Going on down the form, activity of the
next
decedent.
section is the activity. This is what the decedent is doing if known at the time of their death.
And
so,
who gave you the information in this section?
it would have been from the local law enforcement that it was the scene. It was what they were thinking was happening at the scene, and also based off the initial evaluation, to me it would have been obvious that she would have had to have been walking down the stairs to have gotten these had it been from a fall.
Okay.
So again, that's the reason there's a question mark in front. You see that question mark walking down the stairs. That was a supposition that I made, and that I also, told law enforcement that I'm making about this case because it's presumed she fell down the stairs. The place was her home, and then the specific location I gave the address that took place. There's nothing talking about whether it occurred on the job because this was her residence. And then we go into death. This is, again, like we talked about earlier. If the injury's in one place and the death is in a different place, you would list the two different places. But since it was the same, the information is the same. Next section, I'm sorry.
Go ahead.
The next section is the description of body. If I simply was going to do an external in this case and there had been no autopsy, this would have been the section I would have filled out along with the next page, which says body diagrams, documenting all of the external aspects of the body. As you can see, it says condition, whether there's any rigor, which is the stiffness of the body, any livor, which is the settling of the blood, their height, weight, body temperature, eye color, hair color, teeth, clothing, and valuables. But since I was sending this for autopsy, and my practice currently is that information be left blank and be filled out on the autopsy report as it was in this case.
And then go on to the next page where it says body diagrams.
As I mentioned, at the top of that, it says see autopsy report. If this is going to be an external exam, as in this case, I won't document any of the injuries or any of the things that are on the body, whether it be scars, medical therapy, or injuries. I'll leave it blank because I can't see always what there is. In this case, she was clothed. I didn't take her clothes off. There was blood present. I didn't clean the blood, so I couldn't see everything. So I felt it was best to leave it blank and leave it for the autopsy report.
All right. Now moving to the narrative summary of circumstances surrounding death, which should be on your last page.
Yes, sir. The narrative summary is based off of information that I was able to gain at the scene from law enforcement and from the crime scene technician that I talked with, and put all that together into a form. At the scene, I didn't write this. I wrote it on a little notepad that I had, and then I transferred that into some form or fashion that would make sense to me onto this form. And then at the very, very bottom is an addendum that I did after completion of the entire autopsy, and it was signed out by the forensic pathologist, Dr. Radish. I then wrote an addendum on this case, changing, as you saw on the front, the probable cause of death to something different.
Okay, now I want to walk through exactly what you put down here and what your thought process was as you did that. We want to take it line by line. If you start with found at the bottom of the stairs.
Yes, sir. The first sentence is found at the bottom of the stairs by the husband or son, having parentheses unclear. At that time, when I asked them who found them, they said they weren't for sure at that moment because this was still in the initial phases of the investigation. They weren't sure whether it was the husband or the son, and so therefore I put both down, again, to gather all the information possible. I have down that multiple friends and families were notified before EMS was notified. Again, that was information that I was told up front. Have the EMS received their call at 2:40.
Remember, excuse me, with respect to any of this information, you don't have any way of knowing even today whether this is accurate. Is that right?
That is correct.
This is information you just received at the scene.
That's correct, because I haven't gone back and
I object to whether there's any way to know. You can check the phone records that the district attorney has and determine it.
With respect to the knowledge of this particular witness. What? Just commenting on Mr. Rudolph's objection, Judge.
I didn't hear you, Mr. Hall.
I was asking whether this witness had any way to know, whether he had any knowledge about whether any of this was.
My objection is to any way to know.
I overrule the objection.
Yes, sir. Now, you were at the line where it says, where it begins, EMS received call.
Yes, they received. I was told they'd received their call at 2:40, which was the time that I put on the form as the time of death, because that's when they received the call. That's not necessarily the time they got there and pronounced her dead. Then I have upon arrival, the husband admitted to having put towels under the head. That was information that was provided to me by the law enforcement who was there. I started to write supposedly only then was going to finish the sentence, but I felt that was not necessary at that point, and I finished that later. I have that blood had been wiped up partially in the stairs with paper towels. That was based off of my exam of bloody paper towels that I saw at the scene and what I thought to be smearing of blood on the wall. There was alcohol consumption the evening before. This is what I was told by law enforcement because they found glasses and I think a bottle of alcohol in the kitchen. I never went into the kitchen, so that was what they told me. The next section is the blood is present in the bottom of the stairwell and the last few steps. That was based off what I could see, the blood there. It appears that she hit her head on the step above the corner and then hit the floor in the corner of the stairs, and I looked at the base of the stairs of her back. That was helpful. I could tell where she was, and the information I have there is based off the information that the technician that had some training in blood spatter but was not certified as an expert. He walked me through this saying, I think she's hit here, and that's what caused this blood spatter. I think she hit here. That's what caused this blood spatter. Based off of that, that's how I got that she hit those different areas and then ended up where she was. And again, it says blood spatter appears to support that scenario. I was going with this in the mindset of this is a fall because that's what I was being told. So I was looking, is there information to support that? And again, based off what was being told to me and being advised to me at that time, it did support it. Again, you have to remember, my goal at this point was simply to gather any and all information to help the forensic pathologist who's going to do an autopsy.
Now, do you have any formal training in blood spatter at all?
No, sir, I do not.
And I think you had indicated that the person that gave you this information indicated that they had some training but weren't certified.
That is correct.
If you would, please go ahead to the next line.
Then I go, basically, I kind of backstep and say I was called to investigate the scene. My findings suggest her head striking the stairs at least twice with scalp lacerations and avulsions. The reason I say twice was based off of the interpretation that was given to me based off of the limited blood spatter. And then also the scalp laceration and avulsion, that was something I actually saw that I mentioned, the V-shaped on the left side of the head. Then I say my findings suggest an accident because at that time I didn't have anything else to say otherwise other than that scalp laceration. Had that been all that she had and the pathologist might not have found anything else, that's still a possibility that could have been it. But since there were more findings, which I didn't know at that time, that phrase has been changed in the addendum. Then I said, discuss my opinion with the Durham Police Department. This is where I told them that based off of what I've seen, everything suggests this is an accident. But I went on to tell them, which I don't have written down, that if they turned out to be more than these single two, then they need to be looking for an instrument that would have caused these lacerations. And like I said, I didn't know if there were more or not. I was simply telling them what potentially would need to be done if more stuff was found. Then I list the medications. I don't know if these are all the medications she was on or if these were medications that would have been old and simply left lying around the house with her name on them. These were the medications that law enforcement gave me that had her name on them. At the very bottom, I have listed an addendum.
Now, before you added this addendum, did you actually have an opportunity? I mean, you viewed part of the autopsy.
Yes, sir.
Did you have an opportunity to review the results of the autopsy?
Everything but the glass slides, yes.
Okay. And I want to make sure I'm clear on exactly when this addendum was placed on this narrative.
The original narrative was written on 12/9. The addendum was written on January the 15th of 2002.
Okay.
More than a month later.
All right. And if you would please, with respect to the addendum, what does this say?
The addendum says, after completion of the autopsy exam and review of scene photographs provided by Durham Police Department, they had come to the Office of Chief Medical Examiner, and I was allowed with Dr. Rash to see the scene photographs. I don't know if that was all the photographs. I don't know. I just know they let me see some of them. Based off of those, I felt that the injuries were not consistent with an accidental fall downstairs. I did feel that the findings were suggestive of blunt force injuries that could be seen either with the head striking or being struck by a blunt object. And then I signed off on it.
All right. Now, with respect to the addendum being created, I want to make sure I'm clear. You saw part of the autopsy. You didn't see all the internal exam. You didn't see the slides, but you did see the final version of the autopsy.
Yes, sir.
And you had an opportunity to see photographs, or at least some photographs from that scene.
Yes, sir.
All right. Now, based on all that you saw at the scene, the photographs that you've seen from the police department, the portion of the autopsy that you saw, and a review of the autopsy report itself, do you have an opinion with respect to whether Ms. Peterson's wounds were consistent with a fall?
Yes, sir, I do have an opinion.
What is that opinion?
My opinion is that the injuries are not consistent with a fall, but consistent with an assaultive beating type pattern.
All right.
Mr. Harden, let's stop right here.
Yes, sir.
Once members of the jury will take our lunch break. Remember the instructions the court has given you throughout the course of this trial. Keep an open mind. Do not discuss the case. Stay clear of the parties, witnesses in this case. Don't read about the case. Don't watch TV about the case. Don't do any independent research. We'll see you at 12:50. 12:50. All right, Mr. Rudolph, did you want to be heard outside the presence of the jury by way of voir dire or some other method as to the
Yes, sir.
ability of this?
I want to first make sure that those are the only opinions, rather than breaking it up. I wanted to make sure that that's the only opinion that Mr. Harden intends to elicit. If he intends to elicit any other opinions, I'd like to get those elicited outside the presence of the jury so I can voir dire on those as well.
Do you intend to elicit any other opinions? Sorry. All right. All right, Doctor, if you will return to the witness stand, and of course, he remains unnoted.
Dr. Snell, right before the break, you indicated that it was your opinion that the injuries on Ms. Peterson's body were not consistent with a fall. Is that right?
Yes, sir.
And that they were consistent with some sort of an assault.
Yes, sir.
Now, the basis for that particular opinion are the number and location of the lacerations?
And the fact that you have multiple that are parallel in one plane.
Okay. That's what I said by location, right?
Well, there's a difference between location and plane, in my opinion.
Okay. In any event, the fact that they're all on the same plane, as you put it, and the number of them. Is that what it is?
Yes, sir.
And I think at one point you, for example, expressed to Detective Holland that if she had had 2 lacerations, then that might have been consistent with a fall, right?
It might have been, yes, sir.
Okay. And in terms of when you say it's not consistent with a fall, do you have a particular kind of fall in mind?
Well, the fall that we're talking about, potential fall down the stairs.
Okay. So in other words, what you have in your mind is a fall from somewhere up the stairs, tumbling down?
Yes, sir.
And in reaching your opinion, did you consider any other fall scenarios?
Well, just that, but also a fall in general, based off of information, whether you fall down, hit the back of your head, that kind of fall as well, producing injuries.
Well, when you say a fall in general, tell me when you say it's not consistent with a fall, tell me what kind of fall we're talking about specifically.
Well, it's not specifically. I mean, you talk about a fall, it's a fall in general, whether it be the fall down the stairs or whether she'd been standing up and falling back and hitting her head on one of the steps.
Okay.
It's a fall in general, namely the stairs, because that was the one I asked to interpret, but also just a generic fall of her standing there and falling back and hitting the back of her head.
All right. So you didn't sit there and try to imagine various fall scenarios that could be consistent with this injury, correct?
Not when I saw multiple of them, no.
Right. And how many fall cases had you handled as a forensic pathologist at that time?
At that time, only 2.
2. And were these falls down steps?
Yes, sir.
And did they involve wooden steps?
I didn't ask.
You didn't know?
No, I did not know.
Do you know how many steps that people fell down?
It was not known.
And do you know whether or not there was anything in the area of the steps like the chairlift that was in this particular area?
I was not told that there was anything there other than the railings on the side and the stairwell itself.
Okay. And when you say, in your opinion, it's not consistent with a fall, do you have any experience with falls other than those 2 cases?
Since that time, I've had other cases, yes.
How many cases have you had?
I think I've had 4 more since that time.
Okay. And again, let me ask you, do you know whether in those 4 cases they were wooden stairs or carpeted stairs?
Most of those falls were onto cement.
Onto cement. All right. And from what height?
Standing height.
So not on stairs?
No, sir.
All right. So have you had any other staircases?
No, sir.
All right, so you've had 2 staircases in your career?
That's correct.
And is your opinion then based on those 2 staircases?
Those, and also reading textbooks.
Okay. And what textbooks did you read that indicated to you that these injuries were not consistent with a fall?
DeMaio's textbook on forensic pathology and Warner Spitz's textbook on forensic pathology.
Oh my God!
And what in particular about that you read indicated that these the plane and the number of lacerations here were not consistent with a fall?
The ones in those literatures don't point out that you can have multiple parallel lacerations and it be a fall. The case examples that they have in those are either predominantly due to abusive injuries or assaultive type injuries where the individual struck.
Let me mark this as, what number are we up to here? Let me mark this as Defense Exhibit 170. Can I approach it? Yes. Thank you. Is this the DeMaio book you're talking about?
No, sir.
Which one are you talking about?
The new edition.
Okay. And do you know what section in this book it would be in?
I'll have to look in this book.
Okay. First of all, let me ask you, are the sections in the new book, do they correspond to what's in this book?
I don't have the section memorized, so I can't answer that question.
Well, what's your best memory?
I haven't looked at the sections in a long time by the index, so I can't answer your question.
You have no memory at all?
Again, I haven't looked at the index in a while, so I can't answer your question. I believe in this chapter, it'd be chapter 6.
Chapter 6, the chapter on trauma to the skull and brain.
Yes, sir.
And why don't you take a look in there and see if you can find the section in there that talks about falls and why you couldn't have multiple lacerations.
He doesn't say that you can't have multiple. He simply, his case examples don't have multiples. The case examples that he has are of assaults. I didn't say that it couldn't happen with a fall.
Okay, so there's nothing in this book that says it can't happen with a fall.
That's correct. Nothing in Spitz's either, as far as I know.
Okay, well, then I was going to mark that one.
Yes.
This is the edition you have in Spitz, right?
Yes, sir.
He doesn't have the 4th edition yet.
It's not out.
Right. And is there anywhere in there that it says you can't have multiple lacerations from falling?
Not to my knowledge.
Again, it's just that in the section dealing with skull and scalp injuries, all the examples are from intentional assaults.
Yes, sir.
All right, so let me ask you again, what do you base your opinion on other than the 2 cases you've seen?
The 2 textbooks you have.
Because neither of them talk about falls?
No, because the case examples they have in there are very similar to this case. And if I assume that these authors, which are being very good authors and have multiple textbooks, that if they had case examples of falls with multiple lacerations that could be confused with assaultive injuries, that they would have went in and discussed those. And since how they didn't do it, then my assumption is that they haven't seen them either.
So you're making assumptions based on what you've read?
Yes, sir.
Well, did you see any example in either of these textbooks? Well, let me back off for a second. Did you personally have any experience with someone being beaten in the head multiple times?
Yes. I'm sorry.
You have?
Yes.
With some sort of a blunt object, right?
Yes.
Without suffering either a skull fracture or any brain contusions?
Actually, I have one where the person didn't have skull fractures. They had facial fractures, but not skull fractures.
Fractures of the bones around the eyes?
Yes, sir.
All right. And what kind of brain injuries did the person have?
The only brain injuries were due to an internal carotid artery dissection. There were no other brain injuries except for that.
Well, that's a pretty significant brain injury, isn't it?
Yes, sir.
Can kill you.
Yes, sir, it did.
It did. So you haven't had any cases where there was a lack of injuries from a beating like there was in this case in terms of brain injuries, correct?
I've not had a case like that.
And have you been given Dr. Spitz's report in this case?
No, sir, I've not.
I think
You know he's an expert for the defense?
You told me that.
And would it surprise you then if it would be his opinion that these injuries were not consistent with a beating?
Yes, sir, it would.
Because your assumption from his book was something different, right?
No, sir, because he actually has one there where it says that you can have multiple scalp lacerations with no skull fractures and little to no internal skull injuries. And the pictures he showed that I think correspond to this, he presents as assaultive injuries. So therefore, I mean, I would be very surprised if he goes against that.
Mm-hmm. Can you show me in here what you're talking about?
It'd take me a few minutes to find it.
That's fine, we have plenty of time.
I found some of the references that I had for you, including the pictures and the fact how he describes the difference between a fall on the back of the head and being struck by an object. I found those things at this moment.
Well, that was your reference.
That was part of what I was referring to. Yes, sir.
Why don't you find the one that you thought was similar?
Well, this is it. Here's the pictures I was talking about.
Okay.
And also how he describes the impacts of falling versus being struck.
Okay. So the pages you're talking about, in your opinion, is similar, or what pages?
We start with 216, 217.
Now, there's a bunch of different cases here. So what I'm asking is which case in particular?
Okay, starting on 217, he starts a paragraph talking about in the case of a fall to the back of the head. He then finishes discussing that on 227 and then goes into how that would differ from being struck by a blunt object, how that abrasion or laceration would be different. His case examples of being struck by an object. I believe this was one of them.
Well, you're going to need to identify for the record what this
is. Yes, sir. Figure, I believe that is 7-39. Also figure 7-46, 7-47, 7-48, and 7-49.
Okay, so in your opinion, all of those are consistent with the injuries to Kathleen?
Yes, and the fact that there are multiple of them with a linear laceration and splitting at the ends of them. Also how he talks about the difference when you would fall, how it would be one way versus a different one. I believe those things support the fact that he is saying that those are from an assaultive type injury and not from a fall. The picture he has does not, I don't see the picture he has of his fall in here. And I was here's a fall. It's a single laceration, as he points out, round with a single one. Excuse me, figure 7-39 is his fall. It's a single to the back of the head, not multiple, not parallel. So that is a very different.
Let's take a look at that laceration right there.
Yes, sir.
How is that laceration different, in your opinion, than any given laceration on Kathleen's head? Just one-to-one.
Except for the fact that it is shorter and has a circular abrasion and contusion around it. That would be it. But of course, that is differences.
Well, now, there were abrasions and bruises on her scalp, weren't there?
They were not circular around the actual point of laceration that I remember seeing. Since I don't have those in front of me to answer that, I have to defer that to the pathologist of record.
Okay. What about the shape of the lacerations? Anything about the shape of that laceration that's any different from the laceration that was suffered by Ms. Peterson?
To the best of my knowledge, hers were not split on both ends. Hers were only split on one end, and this is much shorter than hers.
Okay. So now you indicated that in your addendum that the wounds were consistent with either being struck or striking a blunt object, right?
Yes, sir.
And if her head struck the stairs, that would be a blunt object, right?
The corner of the stairs, yes, sir. And that was what I had in mind when I made that comment.
Right. And how would that produce a wound that's any different? Just a single wound now. We're just talking about a single wound than any of the ones that you've identified in this book.
Well, it would not be the same as the one that he has here from a fall because you're landing on the corner of an object, not a flat object. So therefore, it would not be identical to this because this is by a flat object. Whereas the corner of a stairs would be much more like that in 7-46 where you got a sharp corner or a rounded corner striking. So it would be very similar to those in 7-46.
Exactly. So, for example, this 7-46 is very similar to what it would look like if a head had fallen and struck the corner of the stairs, right?
Yes, if you had a single fall, yes.
Right, that's what I was saying. So ultimately it boils down for you to the number and location or plane of the lacerations as opposed to the shape of the laceration.
No, I think the shape is important as well because you have to say that she landed on the corner, which if it's a fall, she would have had to land multiple times, got up and fallen again multiple times to have gotten them all in the same plane.
Well, how many lacerations do you think there were?
I think there was at least 7 based off of what I've seen in the photographs and talking with Dr. Radish, the pathologist of record.
And you think that other pathologists could differ about that?
To be honest with you, the pathologists that I know of that seen the photographs haven't differed. Not saying there's not a pathologist out there somewhere that wouldn't disagree.
Let me mark this, please. By the way, you and I spoke last Thursday, didn't we?
Yes, sir.
And I asked you at that point, well, how sure are you that this was a beating instead of a fall, right?
Yes, sir.
And what you told me was it was like 75-25, right?
At that time.
Oh, you've changed since then?
Well, you told me to go do some reading and do research. So as you suggested, I did, which provided me with the knowledge base to change that and become more believable in myself and in my decision.
I see. So, and was that based on these books?
Yes, sir.
Let me show you what's been marked Defense Exhibit 172. I'm sorry. It's a Spitz opinion. Has anyone shown you that?
You have just now.
Well, I meant before right now, sir.
No, sir. Okay.
Now, can you tell me where in Dr. Spitz's book there's something that's inconsistent with his opinion here?
I don't see where, from what I've read in his book, he's getting that opinion. If he's willing to show me, then I could understand where he's getting that opinion, but I don't know. He doesn't refer to things that you asked me to do. Therefore, based off my reading, I don't see where he's coming up with that opinion.
He wrote the book.
Yes, sir, he did.
And that is his signature on the opinion, right?
I don't know. I don't know what his signature looks like.
Would you, would you agree or disagree that the nature of the wounds themselves are not consistent with an object striking them?
Do you mean individually or collectively?
Yes, sir, individually.
Individually, it could be either an object striking or her striking an object with a rounded edge.
Anything else, Tom? By the way, you told the police after the autopsy that there were 3 or 4 lacerations, didn't you?
I don't remember, sir. I don't have notes to that effect.
Well, by the way, had you read either of those books before last Thursday?
Yes, sir, I had.
Let me mark this. Yes. Let me show you Exhibit 173, Defendant's 173, and ask you if that refreshes your recollection about what you told the police officers after the autopsy had been completed.
At this point, we would object. It seems that this kind of inquiry is outside what was originally going to be a Daubert hearing.
Well, he's tested.
What date is he referring to? He talked to me. I can't figure that out based off of this.
I believe it's 12/11.
Okay, because he's got 12/11 and he has 12 March the 12th, so I'm trying to figure it out. Well, I have to say that there's a mistake in this because it says that Dr. Butts was present when Dr. Ash performed the autopsy. And if I told him that, then that was a mistake on my part because Dr. Butts wasn't there on that weekend.
Well, I wasn't asking about what you said about Dr. Butts. I was asking about what you said about the number of lacerations.
But I felt it was important to point out a potential mistake.
Are you saying he's mistaken about the number of lacerations you told him?
I'm saying there's a mistake, in my opinion, in the report. It doesn't mean that he necessarily wrote down what I said wrong or vice versa.
Well, I'm asking you whether that refreshes your recollection about whether you told Lieutenant Bullock that there were 3 or 4 lacerations, 3 in one direction and 1 in another direction.
It does not refresh my memory, no, sir.
As you sit here right now, do you know what you said to him?
No, sir, I don't.
That's all I have.
Mr. Hard, questions? Just a few. Let me make sure I'm clear. In your direct examination, you had indicated that you formulated this opinion about whether these lacerations were consistent with the fall from your review of the autopsy, discussions with Dr. Radish. Is that right?
Yes, sir.
With your observations of the external examination of the autopsy and a portion of the internal examination.
Yes, sir.
Based on what you saw at the scene, and in cross-examination, you've indicated that there are other things as well, those being your review of some manuscripts written by DeMaio and Spitz.
That opinion is after the fact. The original addendum was not based off of those readings.
Okay. So all of those things together now make up your opinion?
Today, yes.
All right. Are you basing that opinion on, excuse me, I think you also said that your opinion was based on some experience that you'd had with a couple of fall cases?
Yes, sir.
Yeah, I like him too. He's not backing down. Word of advice. Bacon ice cream is nasty. I like bacon. I like candied bacon. I like chocolate covered bacon. Bacon ice cream is gross. Belle was sleeping and I took her ice cream to her and I set it next to her on the bed. And she didn't want it. Or she didn't act like she wanted it. So I took a lick. It's not good. Then she wouldn't get up. She made me hold it for her. And then after I put it on the bed and walked away, she was still on her side trying to lick it. I said, lazy dog. I have. I don't remember what trial it was. Oh, I think it was a Karen Reed trial. I think it was Jen McCabe. Yeah. I think it was Jen McCabe. Because I think she stuck to her story. No matter what was put in front of her. She stuck to her story.
2 in particular that you had before this event, and now 4 that you've had since that event. So that's 6 total.
Yes, sir.
Is that right? Okay. Is there anything else that you can recall at this point that you have used other than your training as a forensic pathologist specifically to cause you to formulate the opinion that you've had and given today?
Forensic training and reading of textbooks and talking with forensic pathologists with more experience than me, then no.
Now, you say you've talked with other forensic pathologists that are more experienced than you. Have you talked with them specifically about this case?
No, I'm just asking them, with your experience of falls, what have you seen to gain a better knowledge base of what can be seen in falls?
Okay.
Because as Mr. Rudolph points out,
Well, when you change your story and they confront you with what you originally said, of course you have to say it doesn't refresh your recollection if you want to stick with the story you've made up after you've already told the truth.
There's nothing directly in those two textbooks that addresses specifically falls downstairs. And with my lack of knowledge, I've asked other pathologists, if you've had falls downstairs, what have you seen? And so, that's it. That's nothing that's written down or anything. That's just personal opinion, just like I'm giving.
And what are the kinds of injuries that you've seen or they've seen and related to you in fall cases?
Predominantly, they're single lacerations, maybe a couple, but never in one plane. The one case I had a broken nose with a laceration across that. They can have multiple bruises or abrasions on the arms or the face or on the back or legs as they're falling. If they fall downstairs, a simple fall, usually not. Broken ribs, broken necks. Those are predominantly the main findings.
Okay. Your Honor, I have another question.
When did you have these discussions with other pathologists?
At national meetings since the date of this case.
And who in particular have you spoken to?
I believe one was a Dr. Andrew Baker.
Where is he?
Currently, I think he's in Minneapolis.
And tell me what you said to him and what he said to you.
To be honest with you, I don't remember the conversation in particular. I just remember asking him what was his experience with falls, and he told me.
Well, what did he tell you?
Similar things that I just said.
What did Dr. Baker tell you?
Like I said, similar type things I just referred.
Well, what I'm asking you is, do you have a specific memory of how much experience he had, how many fall cases he had, and what he specifically told you?
No, sir. Like, I don't have a specific memory of our conversations on Thursday. I don't keep specifics about conversations unless I write them down in my mind. And I don't have any of that written down, just like I don't have anything from our conversation. So I couldn't answer the same questions about our conversation on Thursday that you're asking me about my conversations with Dr. Baker. I remember the gist of those conversations, and to me, that was what was important.
And who else besides Dr. Baker?
Another colleague that's a friend, and I cannot think of his name other than Campman is his last name. I've talked with Dr. Sullivan, Dr. Butts, Dr. Clark.
Well, Dr. Sullivan, Dr. Butts, and Dr. Clark are all in the same office.
No, they're not.
Well,
Dr. Sullivan's in Mecklenburg County.
And Dr. Clark and Dr. Butts are in the Orange County Medical Examiner's office.
Yes, sir.
Okay. Outside of that group of people, we have Dr. Baker, right?
Yes, sir.
And Dr. Campman?
Campman.
And where is he?
I believe he's in California.
Where?
I don't know. Since he left D.C., I don't remember where he moved to.
You don't remember his first name?
I believe it's Steve.
Steve. And do you know if he's in Northern California or Southern California?
I didn't make a point of finding out exactly where he lives, sir.
Who else?
Those are the two main ones I would talk to because those are two of my friends that are in this same field. If I talked with others, I don't remember them at this time.
And what did Campman tell you specifically, if you can remember?
Don't remember specifics, just the general gist.
That's all I have. Thank you.
Further questions? No, sir. Additional evidence?
No, sir.
All witnesses are like him. Just cut through the BS.
Any arguments?
No, sir.
Don't get intimidated.
All right. Bring Drew back. Are you have further questions?
Don't know.
I may need a little bit of wait to look at some of this stuff. So.
Okay. Well, he says he doesn't have any.
Yeah. Once he said no.
It's not a character assassination.
If I could have maybe 15 minutes just to look over this and talk with Dr. Spitz, I appreciate it.
All right, 15 minutes. You can tell them they can take 15 minutes to be back.
Court will stand in recess for 15 minutes.
1:45. You can come down. Further questions from the state, Mr. Hall?
No, sir.
All right, cross-exam.
Dr. Snell, my name is Dave Rudolph. We've met before, correct?
Yes, sir.
Now, when you got to the scene, it was, I think you said about 7:30 or thereabouts, 7:40?
7:30 roughly.
And at that point, the information you had was that Mrs. Peterson had been deceased for approximately 5 hours.
Yes, sir.
And what the police told you at that point was that it was an accident, but they were concerned about the amount of blood, right?
Yes, sir.
And they called you because they had questions about the amount of blood.
Yes, sir.
Your job was to try to answer those questions when you got there.
Yes, sir.
And in doing that, while you were there, of course, you discussed the possibility that it was something other than an accident, right?
At the end of my investigation at the scene, yes, sir.
So when you wrote your initial report, and I understand the limitations on it as you've described them, but at least when you wrote that, it was considering whether it was a fall versus something else, right?
Yes, sir.
Now, the police told you when you got there that Mr. Peterson had made calls to family members or friends before he called EMT, right?
That was what one of the officers there. I don't remember which officer it was, but one of them did say that.
And you wrote that down because you thought it might be significant?
Yes, sir.
And despite that, you still came to that initial opinion that it was a fall or an accident?
Yes, sir.
Did anyone ever tell you that the telephone records show that that statement is not true?
No, sir.
Would it be fair to say then that if the telephone records show that that's not true, that no one was called before 911, that both the police and you at that point were acting on incorrect information?
I'm sorry, I didn't understand the question.
Yes, sir. If the records, in fact, show that no such calls were made to anyone before 911, would it be fair to say that the police and you, therefore, were, if not acting on it, at least relying on, to some extent, inaccurate information?
It's quite commonly happens, yes, sir.
And did you put in your notes, by the way, did you say that you wrote some notes there at the scene?
Yes, sir, on a notepad.
And were those then, was the notepad or the individual notes then put into the file?
No, sir, because those are mine as a medical examiner, not as part of the OCME file. Those were my notes to myself at the scene, so I didn't carry this yellow form into the scene, which is easier for me to carry, so that's the reason I do that. Once I transferred the information to the yellow sheet, I discarded that sheet.
Was there any information on the sheet that you had that wasn't transferred?
No, sir. I usually would transfer everything that's on my sheet over there. Usually there's less information on that sheet than there is on the yellow sheet in the end.
Because what happens is the notes sort of refresh your memory as you're writing out the report?
Yes, sir.
And I noticed that there was nothing in your report or your notes about dried blood, was there?
They didn't make any comments as to the stature of the blood.
That wasn't sort of on the radar screen at that point for the police, at least in terms of what they said to you.
Well, the question dealt with simply was it an accident, not was it an assaultive type injury. So at that time, I didn't think that the state of the blood was significant.
Well, my question was whether any police officer ever mentioned to you anything about the blood and the state of the blood being dry or wet or anything else when they got to the scene.
No, sir.
Now, before you went in the house, you specifically asked whoever you were talking to there, and you don't remember who it was?
No, sir.
Did you make any notes about who you were talking to when you were there at the scene?
The only note I made was who was going to be the lead detective of the case.
Okay, and that was Detective Holland?
Yes, sir, according to my notes.
And looking at Detective Holland now, do you know whether he was the person who you were communicating with when you got there to the scene?
I don't believe Detective Holland was the initial group of people that I talked with. I did meet up with him later during the investigation at the scene, but not initially, no, sir.
All right. And whoever you were dealing with, before you went inside that house, you specifically asked if the police had finished processing the scene. Did you not?
Yes. Well, not actually the scene, but actually around the body. That's where I was going to be at.
Right. The stairway area.
Yeah, where she was in the stairway area.
And that was important for you to know whether they had finished processing it, right?
Yes, because if they hadn't, I would have had to put on full trace evidence type gear. Whereas if they have, all I wanted to do is keep my own shoes from getting bloody.
Right. And one of the things that you have to be concerned about if they haven't finished processing a particular area is contaminating things, right?
Or altering what's there.
Right. And what they told you at that point at 7:30 in the morning was that they had finished processing that stairway area, right?
Yes, sir.
And because of that, you walk down that hallway leading to that stairway right to the left of the front door, or the door that you entered, right?
Yes, sir. Not the front door. I'm sorry. I think it was the rear door to the house, not the front door.
Yeah, but the main door that was used, the one that sort of comes off the driveway, right?
I didn't know that was a driveway. I thought the driveway was in the front of the house.
Okay. Well,
because I parked on the street. I didn't park in a driveway.
All right, well, just so we're clear. Let me show you what's been marked as State's Exhibit D2. If you came in down some steps into this, what they call the main entrance here at Kent Street, you would have walked down the front hall to the left here to where the stairway was?
Yes, sir.
Is that right?
Yes, sir.
And you had on booties, I think you said?
Yes, sir. I put them on before I went in.
And the body was still lying in that area there, right?
Yes, sir.
And you wore your booties the whole time you were inside the house?
Yes, sir.
And when you came out of the house, you took them off and threw them away?
I believe they had a biohazard bag laying there that I asked where could I put them, and I think they had a biohazard bag that I put them in.
And you didn't particularly inspect the bottoms of your booties before you threw them away?
No, sir.
So you don't know if you got any blood on the booties?
No, sir.
And by the way, when you got to the body, you don't recall seeing any towels under the head, do you?
Not off the top of my head, no, sir.
Now, as I understand it, the first thing you did in examining the body, I understand you did some other things before you actually examined the body, but the first thing you did to examine the body was to roll the body on one side?
Yeah, after we'd moved her from the place she was lying to a body bag, then yes, I rolled her onto one side.
All right, and there were, somewhere around 4 or 5 people helping to move the body at that point?
I believe there would have been, because it would have taken that many most likely to have moved her in the position she was at.
And then you examined her scalp for wounds, right?
What I could see of it with her hair, yes, sir.
And her hair was matted with blood.
Yes, sir.
And so you would have had to have moved the hair to some extent to see what lacerations were there, correct?
Actually, the ones that I saw, I didn't have to move them because it was on the side of the head and I could easily see one of them. And then when I went to inspect that one, that avulsion lifted up and I could tell there was another one on the other side of it. Okay. I didn't go through the rest of her hair.
All right. Now, you told Art Holland, did you not, that there were, and I'm talking right at the scene there now, you told Art Holland that there were 3 or 4 lacerations on her head and that her scalp was torn severely, did you not?
According to my notes, I did not say that. So if I told him that, I don't know why I would have disagreed with my notes.
Well, let me have this marked.
Yes.
Let me show you what I've now marked as Defense Exhibit 174. And show you an entry for December 9th at 7:41 relating to you, and ask you whether that refreshes your recollection about whether you in fact told Art Holland at about 7:41 or thereabouts anyway, that there were 3 to 4 lacerations on her head, scalp torn severely.
Well, the scalp was torn severely. That's the avulsion. So that part I don't have a problem with. And then appears 3 to 4. I mean, I could have told him there were 3 or 4. I don't remember. I know that there were 2 that I looked at predominantly, the 2 that formed the V. I might have seen more and just don't remember that.
All right. Now, I think you said that you were concerned about artifacts, right?
Yes, sir.
About creating artifacts.
Yes, sir.
And just so we're all clear, creating artifacts is a real problem in what you do for a living, right?
Yes, sir.
And artifacts, when we're talking about artifacts, what we're really talking about are changes in the body in some way that are post-mortem, right?
Yes, sir.
And it's sort of the equivalent of contaminating a crime scene, right?
Okay.
Well, for example, you can have artifacts created during an autopsy, right?
Yes, sir.
For example, when you lift the dura off the brain, you may tear some blood vessels, right?
Yes, sir.
And that may create, for example, an appearance of a subarachnoid.
I've never seen that.
All right. But that when we're talking about artifacts, that's the kind of thing we're talking about, where something you do in the autopsy can actually create the appearance of something that would be significant, right?
Yes. Well, not necessarily has to be significant, but it can create something that wasn't there before you started.
All right. So, by the way, I think you said you observed the autopsy here?
Observed portions of it, yes, sir.
Who was actually doing the cutting?
I believe.
Was that Natalie?
I don't have an autopsy report in front of me, so I can't answer that off the top of my head. I don't remember the name of the individual.
All right, hold on one second. Where's that touch? Just more here.
Let me show you what's been marked, I think, 151. And ask you whether
this would refresh your recollection about who was there doing the autopsy.
Yes, sir. It says up here, persons present would have been Dr. Kenneth Snell, myself, Dr. Deborah Radish, Mr. Kevin Garrity, and then, of course, the person that would have done the actual cutting would have been Natalie Depchick-Smith.
Okay.
And had she been there for some period of time at that point, do you know?
I believe she'd been there for a while, yes, sir.
Do you know how long she'd been there?
Off the top of my head, I think in that office, I don't remember, but she was a resident at that university. So I don't know how long she'd been at that university.
Okay. Do you know, was she a fellow?
Not at that time, no, sir.
Okay. In any event, artifacts, even with well-trained pathologists, can happen on occasion, right?
Yes, sir.
Artifacts can be created, for example, at the scene, right?
Yes, sir.
For example, how people at the scene handle the body can create an artifact.
Well, it depends on what you mean by handling the body, but if you put a body upside down, that can create an artifact.
Sure. How the body is handled by mortuary drivers can create an artifact.
I assume it could.
And I think the example you gave of the kind of artifact that you were concerned about was making the laceration larger.
Yes, sir.
By touching the hair or pulling the hair or something like that.
It would have had to have been pulling the hair apart with the matted blood that I was concerned if there were there that I could have extended them.
Exactly.
Because it was matted.
Right. And I think you said you could have even created an avulsion.
That would have been a possibility, yes, sir, if I had pulled hard enough.
Right. And are you aware that Mr. Peterson at one point had to be pulled off his wife's body?
I don't believe that I was told that because it's not in my notes.
Okay. If that happened, if he was holding on to her body or her hair, that can create an artifact, can it not?
He would have had to have a hold of the hair in the area of one of the lacerations, particularly where you would have had two of them coming together to create that. And it would have, in my opinion, if he had done that, to do that, he probably would have come away with bloody hair in his hands.
Mm-hmm.
So, you know, if we're being told that he came away with bloody hair in his hands where he pulled the hair out of her hand, pulled the hair out of her head, then I would say, yes, it's possible he did that. But if he didn't do that, then I'd say it'd be very unlikely that he would have done that.
And if no one knows whether that happened or not, then we're just left to wonder.
Well, if none of the detectives wrote it down, then I would agree with you.
Right. And in fact, you had blood on your gloves after you finished your examination, did you not?
Yes, sir.
And that was like 5 hours after Mr. Peterson would have found the body, right?
I don't know what time I assume he found the body at approximately the 2:40. So yes, sir, it would have been 5 hours.
Are you aware that, for example, there was hair from Kathleen Peterson on a Coke can that Mr. Peterson had drunk from?
No, sir, no one's told me that.
When you looked at the steps, you didn't see any blood on the upper steps, right?
I don't recall seeing any, and I didn't note any in my document.
And one of the crime scene investigators told you that he had had some blood spatter training?
He had some training in it, yes, sir, but he was not certified in it.
Yes, sir. That's what he said to you?
Yes, sir.
How many times can I ask
And that was Eric Campen?
I told you I didn't remember who it was earlier. I'm sorry. I told I told DA Harden I did not remember the individual's name that told me that.
Well, does the name Eric Campen ring any bells for you?
No, sir.
And whoever it was told you that what he thought from the blood spatter was that Kathleen Peterson's head had hit on the bottom couple of steps there?
Yes, sir. That was what he thought had happened.
And you did, in fact, walk up those steps with one of the techs, did you not?
I believe it was one of the technicians and one of the detectives, but I can't be for certain because I didn't make a note to who it was I actually walked with.
You had come through the bottom of the stairway, right?
Yes, sir.
Past where Kathleen Peterson was lying there.
Yes, sir.
They hadn't brought you up top to come down to inspect the stairway.
No, sir. I didn't go anywhere other than the stairwell and from the door to the stairwell.
All right. So you walked in past the body and then you walked up the right side of the stairs, did you not?
I believe it was the right side.
Can we put up on the screen D146? Do you recognize that as the stairway that you walked up that night?
I can't tell the orientation of this, but I mean, it looks like the stairwell would have looked.
And assuming that the bottom portion of the photo is the landing at the top of the stairs, see
okay.
that? You would have been walking up on that side over there, right?
Yes, sir.
And do you have any idea what that white powder is there?
No, sir, I don't. It looks like a glare to me, so if you're saying it's powder, I'll take your word.
All right. You don't know anything about luminol, I take it.
I've heard of it. I have no personal experience with it.
All right, sir. Now, you've testified at some length about this report of investigation by medical examiner that you did in this case, right? You can take that down. Thank you.
Yes, sir.
And I think you said that you've now changed your practice about when you fill this out.
Yes, sir.
And if I wrote it down right, I think you said the reason you changed your practice was because of potential problems it might cause law enforcement, right?
If I said that, I can understand why I said that, and there's other reasons as well.
Well, you said it changed it specifically because of this case, right?
Yes, sir, I did because of this case.
And when you say problems that it causes law enforcement, this was an honest opinion that you gave at the time, wasn't it?
Yes, sir.
It's what you believed at the time, right?
Yes, sir.
Do you feel like a jury is entitled to know what you believed at the time when they're assessing the facts of the case?
I think they were better served by having an opinion at the end of it, but yes, I'm sorry.
Well, we'll get to that. My question is whether or not you don't feel it's appropriate for a jury to have the benefit of your initial opinion when they're deciding whether someone should go to prison for life.
Objection. Sustained.
When they're deciding the case, do you think they ought to have the benefit of your initial impression?
Well, my opinion is they should have what my opinion is when I finish evaluating it. And that's the reason I do it the way I do it now, because things change. And I've realized that since things change, they're dynamic, it's better for all people involved if they have as close to the final opinion as possible, which I think is better. And therefore, since I think it's better, that's the reason I practice that way now.
Yes.
I'm not trying to hide anything from the jury by doing this way.
Well, see, regardless of what you're trying to do, if this report was filled out now, I wouldn't know, and the jury wouldn't know, that your initial impression and opinion, your probable cause of death when you went to the scene and inspected it, was a fall downstairs, would they?
Not necessarily, because in the discussion point in the back of it, I probably, and I still do, list the things that are being thought from initially, and then I go on to discuss how that has changed. So that opinion is still in there, but it's not on the front page like you're talking about.
Right. And there's no problem, is there, with you listing an honest opinion on the front page and then coming in and explaining to the jury why that opinion wasn't accurate, is there?
I think it's better to give a more well-knowledged opinion than an initial opinion that may not be based on enough information.
I see. Well,
I'm trying to impugn its work.
when you, I think you said you were present for the autopsy, right?
I said for portions of it.
Yes, sir.
Oh my
And
God.
you spoke with the police. I think the portion you were present for was the portion relating to the lacerations on the scalp, right?
That was part of it, yes, sir.
And I think you said since most of, by the way, there was no skull fracture found.
As far as I know, no.
Okay. No brain contusions found.
As far as the neuropathologist says, no.
You didn't see any.
I didn't look at the brain, sir.
Okay. Well, generally we can rely on the neuropathologist for finding brain contusions, can't we?
That's what I said, sir. Yes, sir.
And no swelling of the brain.
According to the neuropathologist, no.
Okay. Now, after you observed these particular lacerations, that was on the 9th of December, right?
Yes, sir.
Autopsy started around noon?
According to the autopsy report that you showed me, I believe so.
All right. And how long would you have been in there, do you think?
I didn't keep track of it. I don't know.
Can you give us an estimate?
I'd rather not.
Okay. Now, after you witnessed that, you spoke with the police again, did you not?
I've been told by you that I did. I don't remember exactly those conversations.
You don't remember any conversations with any police officers after you?
No, sir. I didn't make notes about it, so therefore I don't remember them.
Well, let me see if I can refresh your memory at all with a few notes. Let me show you what's been marked. I think it was previously marked Defendant's Exhibit 8. And here it's marked Defendant's Exhibit 175. And let me show you, and I think it's already in evidence, so let me show you Detective Holland's notes from the 10th of December. That would have been the day after the autopsy, right?
Yes, sir.
And you see he has times down here?
Mm-hmm.
Can we put this up on the board here so that, can you blow up the bottom third of that, please? You see the date there, 12/10/01?
Yes, sir.
Okay. And if we can go to the next page at the very bottom entry. At 1351, do you see CT Dr. Snell?
Yes, sir.
4 blows. See that?
I can read it right here. Yes, sir.
Waiting on us and SBI agent's result.
Yes, sir.
Advised him of what SBI agent said 4 distinct blows?
Yes, sir.
Now, does that refresh your memory about whether you ever told Detective Holland that you were waiting on information from the police and the SBI?
I remember I was waiting. I was told at some point they were going to illumine all the house, as you showed, and I was waiting for that blood spatter information. Also, I was told that the blood spatter expert would be coming in, since the guy or the technician that was there was not certified in it, that a technician would be coming in for that. So that was the information that I was waiting on from the police. I don't remember the exact conversation that you have there highlighted, having it with him.
So you don't remember telling him that there were 4 blows?
No, sir, I do not.
Or that you were waiting on the police and the SBI agents' results? Or you do, that part you remember?
Yeah, because I know I was waiting on the blood spatter expert to evaluate the scene.
And is it your testimony then that what the blood spatter expert found or didn't find was going to somehow impact your findings as a forensic pathologist?
Well, as we talked about earlier at the scene, the initial spatter information I was received suggested there were multiple steps it had landed on. But since he was not an expert, the question was, did it truly involve multiple steps or only one step or no steps at all? And so that was a question, because if it's a fall and none of the steps are actually where the blood spatter originated, then it couldn't have been a fall. So I was waiting on that information.
Well, so in other words, after the autopsy was completed, after you looked at all these lacerations, you still hadn't made up
I
your
wasn't
mind?
the forensic pathologist of record to know. I was waiting on the information from the forensic pathologist, their final interpretation, which would have been after they got glass slides and neuropathology consultation.
Wow.
So I wasn't going to make a final decision just based off of that. I was waiting on multiple pieces of information to determine whether or not, because I had to do a supplemental death certificate anyway, since I put the initial one pending.
Mm-hmm.
So I was waiting on lots of things, not just that information.
And you were told on the 10th what the SBI agent had said, right?
According to that, I was.
And then, do you remember, if we can go two pages further on that, the 4361. At the very top there. This would have been about 4:30 in the afternoon that same day, December 10th. Do you see where it says here 4 main injuries, 3 parallel, 1 horizontal?
Yes, sir.
And is that what you told Holland the day after the autopsy?
According to that, that's what I told him.
And did you say the same thing to Bullock?
Who is Bullock?
My approach. Yes. Let me show you Defense Exhibit 173.
Okay, who is Bullock?
Bullock is a lieutenant with the Durham Police Department.
Okay.
Did you tell him that there were 4 main injuries, 3 parallel and 1 horizontal?
According to this, I did, but we talked about this earlier, the fact that there is some information that's not correct in here. So, but according to this here, I did tell him that.
Asperger's at least.
And did you also tell Detective Holland on the 11th of December, this would have been after you got the SBI information and after you saw the autopsy, that 1 or 2 horizontal wounds might be consistent with falling, but not all of the wounds? Is that what you told him?
I don't remember telling him that, no, sir.
May I approach? Yes. We put up 4362, the very bottom.
according to this, that's what I told him.
You don't have any memory of that?
No, sir.
Sir, on December 12th of 2001, that would have been a Wednesday. So we would have been now like 3 days after the autopsy, right?
Okay.
Is that fair?
From the 9th to the 12th, yes, sir, that'd be 3 days.
And you spoke with the Durham Herald Sun.
Okay.
Right?
I guess so. You're saying I did.
Well, do you recall telling a reporter, this is after the autopsy, after you observed what you observed, after you heard about the SBI, do you recall telling the reporter that although Kathleen Peterson's injuries were consistent with the fall, some of them need to be explained more fully? Remember saying that?
No, sir, but I know they did take some of the stuff I did say at that time and change it, so I don't know that what they have in press is actually what I said, because I know they did alter some of the things I said, so I don't know that I would trust very much what's there. Anything else?
That's all I have. Thank you.
Redirect. No, sir. All right, you can come down, sir.
May I be excused to go back to my duties in Charlotte?
You can go wherever you want to go.
Okay. It's been a long day. Not as bad as yesterday, though. Yesterday was rough. I like the last witness. Well, he's probably right. He's probably right. They probably did twist what he said. I wish every witness would be like him, though. Because they get intimidated when they get challenged. And they're like, well, I guess you're right. Or, whatever. And no, they're just asking you a question. Don't get intimidated. Answer it. I hate when, like a witness does really good on direct and then defense gets up and says something because, of course, they're allowed to lead because it's cross. And then the person just caves, They were so good on direct and then they just cave when defense gets up there and they're like, well, I guess so. Yes, sir, I guess so. No. Stand your ground. Be like you were on direct. Tell them no. It blows my mind how people just fold just because the defense attorney is being a jerk. Yeah, he's probably a very socially awkward person, but I think he knows his stuff when it comes to his job. And he didn't back down about that, that he changed his practice because of that. There's nothing wrong with waiting until you get more information to put something down on a form. Because you don't have enough information to put a preliminary cause of death. Wait till you get a little bit more information Yeah, you can still do that before the autopsy. Wait and get a little more information. And then all these other stupid little scenarios that Rudolph was saying, like, oh, well, somebody could have pulled her hair and it could have made the lacerations bigger. Yeah, but why is the prosecution not objecting to calls for speculation? Like, sometimes I just want to go, that was a dumb objection. Why don't you object when you need to instead of objecting when it's stupid? I just don't understand sometimes why attorneys do the things they do and why they don't do the things they don't do. I guess it's just, I didn't go to law school, so I don't understand. I don't get it. I just don't get it. Okay, guys, I will be back in the morning at 9 o'clock my time for more. Oh, I should have looked to see who was next. We're getting closer to Deaver and the male escort. Should be any day now. Oh, man. I really hope Spitz isn't going to testify, but I think he is. No, it's not. It's perfect. It's perfect. I'm not rushed. I'm not late. I don't oversleep. It's perfect. I was even 56 seconds early this morning, Marty. Okay, guys. I will see you in the morning. Remember, be kind to people, love your family, and Jesus loves you, and so do I. Bye, guys. See you in the morning. Love you. Have a great evening. Bye.